Kodi. Give the memos. Dates will be allowed. Covered. Squarely covered. Just file a memo in the registry after serving the other side as memo for disposal, in which you mention it's covered on what point. If it's squarely covered and does not require detailed arguments, and put it on top of the list. You serve a memo on the other side, file it in the registry, move the matter tomorrow. I'll give you the earliest date. But it should not require any detailed argument. Put it. Fresh matter will come immediately.
Adjournments list 1, page number 1, serial number 1 to 4. Page number 2, 5 to 12. 5 to 12. Page number 3, list 1, page number 3, 13 to 20.
Serial number 17.
Yes.
I appear for the respondent. I have informed Mr. Srikanth to file objections a week's time, but he wants a date to be fixed to my lord. I leave it to my lord to fix a date.
Yes, relist the matter after 10 days date.
6th November.
6th of November.
Much obliged. Much obliged.
Page number 4, serial number 21 to 23. Page number 5, 24.
Serial number 24, my lords, I appear for respondent number 1. I have informed the petitioners in both the main and the connected matters. Today there is some inconvenience, my lord. Any date next week may kindly be fixed, my lords.
But what about the others?
I have informed the petitioners in both the connected and the main matter, and as well as the correspondent in the main matter.
Okay, when it reaches, I'll assign a date. There are other counsels for the respondent also. When it reaches, I'll accommodate.
Please, please.
Page number 8, 25 to 33. Page number 9, 34 to 38. Page number 10, 39 to 44.
Yes. You have informed the others. I'd request relist the matter on. Interim order earlier granted is extended till the next date.
Page number 11, 45 to 53.
Connected, is it? Connected. Shall we tag it? 48 to be tagged along with 39. Interim order earlier granted is extended till the next date.
11th of November.
Yes. Yes. Just inform the other side. Interim order earlier granted is extended till the next date. Relist the matter. 2 weeks admin date.
6th November.
6th of November.
Page number 12, 54 and 55. List 2 adjournments. Page number 1, 1 to 5. Page number 2, 6 to 15. Page number 3, 16 to 24. Page number 4, 25 to 29. Page number 5, 30 to 35. Page number 6, 36. Page number 7, 37 to 41. Page number 8, 42 to 45. List 2. Page number 9, 46 to 50.
40.
43. Sanjay. Serial number? List. First list. Page number 9, 46 to 50. Page number 10, 51 to 54.
50.
53.
Yeah. Have you informed the other side? You have to inform and report to the court officer. At request, relist the matter on
29.
just wait.
43.
No, count. Memo file which reads as here under light of the same petition is dismissed. Yes. Serial number? Yes. Orders you have to wait. I'll give time.
List 1 preliminary matter, serial number 1. Vijay Sim Reddy.
Yes. Just, no, correct. Now those aspects, how we can look into that, you have to sort it out. Now, if according to you, their reduction of pay by taking note of the audit objection is wrong, you have to challenge it independently. Then we'll have, if it is so, then we'll hear it in B group, not in preliminary hearing. It has to be heard, isn't it? So we'll have it in B group and we'll hear it. You have only sought for a mandamus. Then how is it maintainable? Now, if according to you, it is the stand of the university that what you are seeking for recovery is the shortfall of what they have reduced in light of the audit objection. Now, if according to you that reduction is wrong, then you have to challenge that action. That I'll ask them to communicate. I'll ask them to explain by way of an endorsement or a written communication the basis for reducing pay that they were earlier paying in terms of the observations made in the statement of objections. That you challenge it, we will consider it. If according to you, their reduction in terms of the audit objection is contrary to the service conditions or law, then you make out grounds of attack, we'll consider it. Unless you challenge that in this writ petition. No, correct. So that aspect requires adjudication. We will direct them to give a detailed speaking order for assigning reasons for their payment in terms of the reduced payment or in terms of the audit objection. And reserving liberty for you to challenge it. That we'll consider. That's all, isn't it? Huh? The present petition has been filed seeking for issuance of writ in the name of mandamus directing respondents 2 and 3 to release arrears of salary amounting to 18,64,774 with interest at 12% per annum. As regards the service emoluments and entitlement of the petitioner for the period of his work. Full stop. The respondent 2 and 3 have filed a detailed statement of objection, and it is their specific stand that they had paid the reduced salary and allowance at 25% lesser than what was being paid in light of the audit objections raised by the state government. Full stop. Such stand is taken at para 13. Full stop. Accordingly, it is the stand of the respondent 3 and 4 that the consideration sought for in the present writ cannot be made unless the petitioner were to challenge validity of the action of the respondent in paying a reduced salary and allowance. Full stop. After hearing both sides, there is also force in the contention raised by the petitioner that unless a written order is communicated to the petitioner regarding reduction of salary as claimed by the and allowance and allowance assign in the allowance, his challenge to such action of the respondent would be illusory. Full stop. Accordingly, the respondent 3 and 4 to make out an office order and communicate the same to the petitioner, detailing the basis for reduction of emoluments by way of salary and allowance as stated by the respondents in their objection that such reduction was pursuant to the audit objections raised by the government. Full stop. The petitioner, full stop. Next, upon such order being communicated by the respondent to the petitioner, petitioner's liberty to challenge such endorsement in accordance with law. All contentions are kept open.
Serial number 2, Srinandan K.
My lord, I appear for Union of India, respond number 1 in this matter, my lord.
No, just 1 minute. Just 1 minute. Now, the only question is whether there is an appellate authority constituted under the Act and the rules.
Naveen.
There was an order passed on just 1 minute. There's an order passed on 28/8/24, isn't it? So in that order, what it is stated that there is an the court has observed that there's an appellate authority, and then some information was sought whether it's constituted or not. Now you say, now you make a submission. As an appellate authority. Appellate authority. Yes.
Or I can go there also. The issue is there is a question of law which is involved here. Therefore, my argument is it is maintainable before your lordships and your lordships can decide it because I'm challenging the maintainability and the ability of the IC itself to decide this case because they did not have jurisdiction as on the date when they decided my case.
Why do you say they didn't have jurisdiction?
My lordships. I would like to take your lordships to the Act, the Posh Act.
Kudi. Sexual harassment. Act.
That's 11.
Sexual harassment at workplaces. Now you are an employee of what now?
I'm the employee of the private bank, which is there.
Of the bank.
Bank, which is respondent number 4.
I'm an account holder. Hope I am not disabled. No, that's why all the judges are now disabled. Yes. No, that's I'm just commenting. That's all. Yes. Anyhow,
Section-
he came yesterday asking for some extra deposit, which I've turned down. Yes,
Section 4, my lord. This is the constitution of the internal complaints committee.
section
4.
yes.
Constitution of Internal Complaints Commission. Lords, the first few provisions I will skip it. I'll go to directly subclause 3. The presiding officer and every member of the internal committee shall hold office for such period not exceeding 3 years from the date of their nomination as may be specified by the employer. Now they were given 3 years for the purpose of holding the office, post which the entire committee has to be completely changed and a new committee has to be constituted. Now, my lord, I attach the POSH policy, which is available at page number 28. There are 3 writ petitions, my lord. The first one, page number 81, annexure Q.
No, but now already the authority has passed an order.
The authority has given a recommendation. So as per the act, my lord, how the procedure goes is the internal complaints committee is a committee which as per the act should be formed by all companies, authorities, public bodies, everybody. And their job is to, if a complaint comes to them, they are supposed to take the complaint. The committee will hear all the parties. Inquiry will happen, post which they will give a recommendation to the employer, either to terminate or not to terminate, or several other things can be done, either suspension or otherwise. The recommendation should be acted upon by the employer within 60 days. Now, this is how the recommendation works. Though they call it as a recommendation, the employer does not have a choice. They have to go ahead and implement the recommendation. Now, my lord, the POSH policy, this is what is available in Respond number 4's website. They first form something called as a steering board at 83. Your lordship will find that. 83.
No, correct. Now, what's the point you're making?
The point, my lord, is that internal committee gets formed at page number 87.
Yes.
87 onwards are the members of the internal committee and STB. At page number 88, serial number 7.
Yes.
Members of IC is reconstituted effective 1st January 2021. And these are the members who sat and decided my case. Now 3 years gets over as on 1st January 2023. The complaint itself comes into place in March 2024 or 1st January.
But have you raised this defense there? Have
My
you
lords,
raised this defense there?
No, I have not. I have a reason for that. The reason, my lord, the person who appears before the internal committee can only be the party. A party cannot be expected to know the maintainability of an issue or legal aspects on the maintainability of an internal committee.
No,
This
then
is something.
correct. Having waited, participated, now if you raise, what's the waste of time? How do you compensate for the waste of time in the whole process?
My lords, the entire process is such that it's not a question of them accepting like an arbitral tribunal where the parties thereafter accept and say, yes, I accept this tribunal. Therefore, I'm amenable to its jurisdiction. That does not happen here because the act is very clear. If there is no jurisdiction, then a new committee has to be formed and that has to decide the issue.
No, that is a matter, different matter.
Yes, ma'am.
That should have been raised even prior to, even if you are a party in person, you should have raised that jurisdictional issue.
My lords, the
Now
party
having
in person,
that will
the
happen.
advocates are completely barred
No,
from
that-
even appearing there
No, that,
or assisting them in any manner.
okay, let us see. I'll list it in B group. We'll hear the matter.
My lords, my humble request is let it.
They don't become functus officio till a new committee is formed. That, no, that, let us see. Let us see. Let us see. Now, insofar as the legal position, you also take your stand in the light of the contention raised. File.
My lords, I would request that it may be listed in orders itself.
No, no.
Because my lord, last date itself, they were given the opportunity to file their statement of
I'll fix
objections.
a date.
And
I'll
it was still coming under preliminary hearing because the question of maintainability
No, no.
is still kept open.
But that will hear. They don't become, it doesn't become functus officio. Even where the term expires, unless a new body comes into place, it doesn't become functus officio. That will hear.
My
We'll
lord,
hear
the
the
act
matter.
bars them.
We'll hear the matter. List the matter, statement of objections to be filed within 10 days from today. The statement of objections also to advert to the legal contention raised by the petitioner that the term of office of the internal committee in terms of section 5(3) having expired, the internal complaints committee didn't have jurisdiction to entertain the complaint and make recommendation. 10 days. Relist on date. 6th of November in B group.
Grateful.
Grateful, my lord.
Three, Govind Raj K.
Yes, what do you say regarding the filling up of the second post?
My lord, I have yet to receive the instructions, my lord, in this case. Can we have it,
No, he's saying that now there was a requirement of second post also. So you take a call if it was, if the vacancy was due to superannuation. If suppose workload is more, that's a different matter. But his claim is that it is only consequential to superannuation. If that is so, then you have to, I'll have it next week, you get to.
Please, my lord. Regarding one post of Kannada teacher,
Correct.
we have.
Now that problem is solved. His
Yes.
petition is only insofar as post
English
contempt.
teacher.
Post contempt insofar as the second post. And he's saying that if the vacancy has arisen due to superannuation, they require it.
Kindly have it next week, my lord, any date.
Relist the matter in the same stage on. Yes. Yes.
Seal number 4. EPC Sidram.
Now you'll have to make all the remaining persons as a party. Now your claim is the seniority must be determined as on the date of appointment. No, I'm saying you'll have to make all other people who are going to be affected as parties. Your main relief is to redo the seniority list and that, huh? No, that's a different matter. No. How is that? Without hearing them, how you can decide? All those persons who are affected by any direction to be passed to redo the seniority list. No, that may be so, but if seniority is done, I'll have it next week. How many people are going to make now? If you are going to concede that only prospective, then you don't have to make, otherwise you have to make. You ascertain. If consequent to the redoing of the seniority list, the position of some of them are going to be affected, no purpose will be served. You make them a party. No. You make them, you get instructions and you make them a party. Petitioner to make all those employees as necessary parties who would be affected by redoing of the seniority list as sought for. In the interregnum, the state to accept notice for the respondents 1 and 2. Emergent notice to respondents 3 to 7. Petitioner is at liberty to serve standing counsel if any for the said respondents. List in B group after 2 weeks. Meanwhile, you ascertain from your client. Yes.
Order seat number 5, T. Mahesha, Virupaksha.
When was this disposed of? Now, see, more than 1 year you have kept quiet. No, then why? You let notify the other side. I'll have it tomorrow, day after tomorrow. In their presence, we'll pass an order. No, correct. For that one issue, now 1.5 year, the main proceedings are stayed, isn't it? And we are responsible for this. Now you notify the other side. When I'll have it on Monday or tomorrow. You just notify the other side. In their presence, I'll pass on. Relist the matter on Monday.
6, Nandareddy PN.
It's proxy counsel appearing for the respondent. Kindly provide another date. Kindly provide another date. Please, sir.
Letter also. Have a take a photo of the letter. Take a photo of the letter and then you just clarify. I'll have it tomorrow or on Monday.
Monday.
Monday. Relist on Monday. Photo to notify the other side also.
Indeed, madam.
7, Shivacharan. Kindly pass.
So what is the matter now? Serve a copy. Copy of statement of objections by the respondent served on the petitioner. List the matter next week. Date. Yes.
8, 30th. Serial number 8, Amareshian, in K. Sridhar.
Yeah. Who is the answering respondent?
My lord, I'm appearing, my lord. In this case, I
University. Observe. Page. Where is the order of the High Court? Correct, para 3. Yes. Now this para 3 direction, they have not complied with. They have not complied. Correct, correct. So they have not still taken a decision. The absorption is from which date? Which date? 36/22. So it dates back. So in 36/22, you are absorbed as no, correct, in which university? Cluster. So for the period, at least, now you attained a superannuation on so from April 2020, you are not paid till 30 till May 22. Now this absorption dates back, is it? Dates back. But though you worked for in that period till this date of 36/22, you were working in the earlier establishment. That you have to continue pay. Yes, you now you take your stand.
My lord, I have my instructions as on today is that, my lord, she has not worked during this period. This is what the instructions are. However, I have received the parawise remarks, my lord. I'll file the statement of objection.
File it. File it.
Yes,
I'll have it next week.
please, please.
You file it.
Next witness.
Let us. No, but you have worked, isn't it? Let us see. Let us relist the matter on next week.
Please.
Date
30th.
30th. Meanwhile, you make a note of dates and events so that if it comes to disposal, it will be easy. Yes.
9.
There are no other cases like this. You place that on record, let us. Let us.
9.
Request not further time not to file objections. I request further time to file objections. On the last occasion, it was.
I'll fix a date. On that date, we'll discuss. You, by then, whatever you want to file, you file it. The statement of objections, if any, by the other side, to be filed by the next date. Relist the matter on.
First week of November.
Let us date. 5th. On 5th, if they don't file, we'll go ahead, we'll consider your request. 5th. Let us see. Yes.
10.
And then you also just appraise the court of interim orders in the departmental inquiries, how this writ court should consider. We'll consider.
10.
Now, what about notice to R2 to R6? Steps in the bill. No, now it says awaiting notice, sir. So notice must be served. No? So who is responding 2 to 6? Huh. Where is that order? No, what is the punishment? Punishment or what? Huh. Order of suspension. Who appears for the, who is the authority who has passed that? So notice must be served. You take out notice by hand summons also. Petitioners at liberty to take out notice by way of hand summons to R2 to R6 as well. This would be apart from notice issued through court. Consideration of interim prayer is kept open. Relist the matter on. We have given you permission. Relist the matter on 30th.
11.
No, I appear for the
PL Sanjeev.
petitioner in this matter.
Yes.
An office objection was regarding serving copy on my learned friend for the respondent number 3, which I have done. Not impugned order at Annexure A, page 23.
Yes.
Not order of suspension may not pass with the respondent number 3 based on an FIR, not at page 44. Or registered by the Lokayukta police, not page 44, my lord will find. No, this is registered not at Kalburgi, not in Bangalore. No, that is most important for our matter. Not the Lokayukta Thane Kalaburgi, page 44.
Yes.
Not the Aparada Nadeda Dina, your lordship will find serial number 3. Not a case of not the disproportionate asset, punishable under section 13(1)B, read with 13(2). Not occurrence of the offense is 2008 onwards. Serial number 3.
Yes.
Not this not FIR is under challenge not before the not Kalburgi High Court. Not matter is pending consideration. No, I am working in Bangalore, not with the respondent number 3.
Yes.
Not my first submission to lordships is not at page number 23, the impugned order. The respondent number 3 would extract not the report submitted by the Lokayukta up to page number 25. Not second paragraph, page number 25, not your lordship will find the last line.
Yes.
Not ಲಗತ್ತಿ ದಾಖಲಾತಿಗಳ ಪ್ರತಿಗಳನ್ನು ಲಗತ್ತಿಸಿ ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ತಾವು ತೆಗೆದುಕೊಂಡ ಕ್ರಮದ ವಿವರವನ್ನು ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಗೆ ಕಳಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. Not up to here, it is a request not made by the Lokayukta. The consideration not is only one line. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಸರ್ಕಾರವು ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. Not whether the usage of the word ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ is enough not to place anybody under suspension. Not fell for consideration of this honorable court. Not in a writ petition where this honorable court, and my colleague is there in the court, not I request him to pass on the order copy. But kindly have a look at not paragraph number 9 and 10 not of this order. Page 8 onwards.
Yes.
Not page 9, para 9. As observed herein above, it is a power of the appointing authority to place an employee under suspension. An employee of Care Ideal, in this case at hand, the petitioner is placed under suspension by the impugned order. Whether the impugned order is a product of application of it is required to be noticed. The order reads as under, not similar to the order 1, not which I brought to your lordship's kind notice. Not except stating, not kindly have not your lordship kindly have look at not para 10. The preamble of the order is dedicated to the communication from IGP to the first respondent. All that the disciplinary authority would observe, ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿತ್ತು, except saying the issue is examined with care. No other depiction of application of mind is demonstrable in the order. Therefore, on the ground that the order of suspension is on the face of it a product of non-application of it, it is rendered unsustainable. It is straight law that application of mind is discernible if reasons are recorded in writing. Not ultimately, this honorable court was pleased to allow the writ petition and quash not the order of suspension. Not this is not ground number 1. Not ground number 2. Not in a similar set of circumstances where not an employee is facing a charge of not section 13(1)B.
Yes.
Not page 75. Not is one such order. Not passed with the chief secretary. Not the chief secretary.
Yes.
Not last paragraph, the page number 75, not last paragraph. ಆದರೆ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಆಪಾದಿತ ಅಧಿಕಾರಿ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರಿಂದ ಬಂಧನಕ್ಕೆ ಒಳಪಟ್ಟಿರುವುದಿಲ್ಲ. ನಾಟ್ ಸೇಮ್ ಕೇಸ್ ನಾಟ್ ಇನ್ ದಿಸ್ ಪಿಟಿಷನ್ ಆಲ್ಸೋ. ಮೇಲಾಗಿ ಈ ಪ್ರಕರಣ ಅಕ್ರಮ ಆಸ್ತಿ ಹೊಂದಿರುವ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಅವರು ಈಗ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರೆದಲ್ಲಿ ತನಿಖೆಗೆ ಅಡ್ಡಪಡಿಸುವ ಅಥವಾ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ನಾಶಪಡಿಸುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುವುದಿಲ್ಲ. ಯಾವುದೇ ಅಧಿಕಾರಿ ಲೋಕಾಯುಕ್ತದಿಂದ ಟ್ರ್ಯಾಪ್ಗೆ ಒಳಗಾದರೆ ಮಾತ್ರ ಈ ಹಿಂದೆ ಅಂತ ಅಧಿಕಾರಿ ಸಾಕ್ಷ್ಯಗಳನ್ನು ನಾಶಪಡಿಸುವ ಸಾಧ್ಯತೆಗಳಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಮಾನತಿನಲ್ಲಿಡುವುದರ ಜೊತೆಗೆ ಬೇರೆ ಹುದ್ದೆಗೆ ವರ್ಗಾಯಿಸಲಾಗಿದೆ. ಆದ್ರಿಂದ ಪ್ರಸ್ತುತ ಪ್ರಕರಣ ಅಕ್ರಮ ಆಸ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟದ್ದಾಗಿರುವುದರಿಂದ ಆರೋಪಿತ ಅಧಿಕಾರಿ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ನಾಶಪಡಿಸುವ ಸಾಧ್ಯತೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಮತ್ತು ಅವರನ್ನು ಬಂಧಿಸದೇ ಇರುವುದರಿಂದ ಅವರನ್ನು ಅಮಾನತಿನಲ್ಲಿ ಇಡುವುದಾಗಲಿ ಅಥವಾ ಬೇರೆ ಹುದ್ದೆಗೆ ವರ್ಗಾಯಿಸುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುವುದು. This order was passed by the Chief Secretary with the consent of the Chief Minister. But in the case on hand, the FIR has been registered. I brought to your lordship's kind notice.
Just read.
Please, madam.
After the table at page 24,
Please,
let us
madam.
just look at those 2-3 paragraphs.
Please, madam. Please, madam. I'll bring the question. ಈ ರೀತಿಯಾಗಿ ಸದರಿ ಪ್ರಕರಣದ ಪ್ರಾಥಮಿಕ ತನಿಖೆಯಿಂದ ಆಪಾದಿತ ಅಧಿಕಾರಿಯು ತನ್ನ ಸರ್ಕಾರಿ ಸೇವೆಯಲ್ಲಿ 2008ರಿಂದ ಈವರೆಗೆ ಸುಮಾರು ಸೋನ್ಸೋ ಮೌಲ್ಯದ ಸ್ಥಿರ ಮತ್ತು ಚರಾಸ್ತಿಗಳನ್ನು ಹೊಂದಿರುವುದಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಸದರಿಯವರ ಈವರೆಗಿನ ಎಲ್ಲಾ ರೀತಿಯ ಖರ್ಚು ವೆಚ್ಚಗಳು ಸೋನ್ಸೋ ಎಂಬುದಾಗಿ ಅಂದಾಜಿಸಲಾಗಿದ್ದು ಸ್ಥಿರ ಮತ್ತು ಚರಾಸ್ತಿಗಳು ಹಾಗೂ ಖರ್ಚನ್ನು ಕೂಡಿಸಿದಾಗ ಒಟ್ಟು ಸೋನ್ಸೋ ಆಗುತ್ತಿದ್ದು ರುಗಳಷ್ಟು ನ್ಯಾಯಸಮ್ಮತ ಆದಾಯವೆಂದು ಅಂದಾಜಿನ ಲೆಕ್ಕ ಹಾಕಿದಾಗ ಆಪಾದಿತ ಅಧಿಕಾರಿಯು ಸೋನ್ಸೋ ರುಗಳನ್ನು ಹೆಚ್ಚಿನ ಅಕ್ರಮ ಆಸ್ತಿ ಹೊಂದಿರುವುದಾಗಿ ಪ್ರಮಾಣದ ಶೇಕಡಾ ಸೋನ್ಸೋ ಇರುವುದಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಆಪಾದಿತ ಸರ್ಕಾರ ಅಧಿಕಾರಿಯವರ ಸ್ಥಿರ ಮತ್ತು ಚರಾಸ್ತಿ ಮೌಲ್ಯವು ಪ್ರಕರಣದ ತನಿಖೆ ಕಾಲದಲ್ಲಿ ಇನ್ನೂ ಹೆಚ್ಚಾಗುವ ಸಾಧ್ಯತೆ ಇದ್ದು ಸದರಿಯವರು ಪಡೆದಿರುವ ನ್ಯಾಯಸಮ್ಮತ ಆದಾಯ ವಿವರಣೆ, ಆಪಾದಿತರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಕಟ್ಟಡಗಳ ಮೌಲ್ಯಮಾಪನ, ಹಣಕಾಸು ಸಂಸ್ಥೆಗಳಲ್ಲಿ ತೊಡಗಿಸಿರುವ ಹಣ, LIC ಪಾಲಿಸಿ ಮಾಹಿತಿ ಹಾಗೂ ಇತರೆ ಖರ್ಚು ವೆಚ್ಚಗಳ ಮಾಹಿತಿ, ಆಪಾದಿತರು ಹೊಂದಿರುವ ಇನ್ನಿತರ ಆಸ್ತಿಗಳ ಕುರಿತು ಮಾಹಿತಿ ಸಂಗ್ರಹಿಸಿ ತನಿಖೆ ಕೈಗೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ. These are all the findings of the ಲೋಕಾಯುಕ್ತ. These are all part of the all the 3 paragraphs are.
Now they've conducted search, etc. Is it?
All that is done at Kalburgi. I'm now working in Bangalore. That's what I brought to you lordship's kind notice not at page 44. But investigation is done. Search, everything is over. Page 44 not in the FIR. He registered on 9/7/2024 at Kalburgi, not in Bangalore.
No, the preliminary investigation they have already done.
No, preliminary investigation is already done. I have also given my explanation. At this stage, all that they have to do is not collect documents, not from the authorities, and file final report.
Yes, what do you say? I'll grant an interim order, liberty reserved to you upon filing statement of objection to seek for modification of the order. I'll impose a condition that he will in no way interfere with any further investigation, etc., relating to the inquiry regarding proportionate asset.
Please.
And so this is only the suspension, limited only to suspension.
Please, only to suspension.
There should be no action in interfering with
please,
further proceedings.
Please.
You file your objection, I reserve liberty for you to seek modification of the interim prayer. The petitioner has sought to call in question the order at annexure A dated 4/10/2024, whereby the petitioner has been placed under suspension. Peruse the order. Only ground made out in the said order is as regards the petitioner destroying interfering with the further proceedings to be carried out. Learned counsel for the petitioner would submit that the preliminary investigation has already been carried out, and even otherwise, the nature of allegation made are primarily based on records and destruction of evidence as claimed cannot be resorted to. It is further submitted that petitioner would unconditionally cooperate in the inquiry proceedings or investigation proceedings without interfering with the same. Third, counsel for the respondent seeks time to file statement of objections. Taking note of the nature of inquiry, it would be and taking nature of inquiry as well as submission that preliminary inquiry is already complete.
No, I'm sorry, no, it's not preliminary inquiry, it's preliminary investigation. They are not conducted.
Preliminary investigation is
Yes.
already complete.
Yes.
No purpose would be served of placing the petitioner under suspension, but the interest of the authorities could be taken note of by imposing certain terms and conditions upon the petitioner. Accordingly, in light of the nature of allegation being relating to disproportionate assets, much of the evidence would be backed by records. Taking note of the submission that the preliminary investigation has also been made. The order of suspension is stayed subject to petitioner filing an affidavit within 1 week to the effect that he would not interfere with the further investigation or proceedings of the respondent authorities as is apprehended by them in the impugned order.
Please.
Accordingly, there would be a stay of the order dated 4/10/2024. Respondents are at liberty to seek for modification of the interim prayer upon filing statement of objections. Now it's only a case of disproportionate assets. So now he cannot do anything with that. If there's anything, you place it on record. He cannot destroy whatever immovable assets he has created out of that. Preliminary investigation is also done. Let us see. Yes.
Blush, please.
Well,
Who are the other respondents now?
No, respondent 1 and 2 may not have the state, which I have served not on the opponent.
AGA accepts response notice for respondent 1 and 2.
Blush, please.
well, Maitreya Krishna.
Yes.
My lord, there are some developments that have taken place which indicate that it might have been resolved. I would just request for this to be taken up next week so I can verify that and
Yes.
make my submission.
Notice is not yet required at this stage.
Not yet required. If it might be taken up next week, my lord, on Monday, it may.
No, relist the matter on
29.
Great. 20. My lord, next week, if a date may be given in the event that
22nd.
grateful.
13. Chairperson.
Krishna Malad is a employee of BBMP. Order of entrustment is sought to be challenged before this court. Order of entry,
Serve copy. Will have.
but there's an interim order granted in similar matters.
Let us see. Serve a copy. We'll have it tomorrow. You serve on any one of the standing councils. We'll have it tomorrow.
Mr. BL Sanjeev appears for BBMP.
Learned Council Sri BL Sanjeev is directed to accept notice for the respondent. Number
2.
correspondent number 2. What about Lokayukta?
Mr. Venkatesh Sarabhati. Venkatesh Sarabhati.
Sarabhati is directed to accept notice for respondent number 3. AGA accepts notice for respondent number 1. Copies to be served on the other side. Relist the matter on Monday. Tomorrow is holiday.
Please, for
Monday.
consideration of interim prayer.
We'll consider in the same stage. Office objections to be complied with, both with. Yes.
14. Arvind.
Yes,
Depending on the council, my lords. My lord,
you are seeking for amendment.
please, because in
Huh?
the meanwhile, my lord,
Huh.
the same subject, there was a criminal case where he has been acquitted, my lord. He has been held guilty in the disciplinary inquiry, my lord, dismissed from service. On the same subject matter, there is a criminal prosecution, my lord, where he has been.
Correct, but we have to now independently examine this.
Please, my lord, these grounds, your lords may kindly permit us to.
But during consideration of penalty order, these were not there. This is a subsequent development, my lords. But I will leave it to my lords on the amendment itself.
Let us see. If it can be considered in the same proceedings, we'll consider.
I'll leave it to my lords.
This is subsequent events.
Please, my lord, proceedings was going on. Acquittal reached finality, my lord, subsequent.
At the time,
Both were launched together, my lord. Same subject matter, same witnesses.
at the time of
Simultaneously
passing penalty order, my lords, conviction was there.
It's correct. That conviction has now been set aside by this one, ordinate bench of this one.
What is the charge?
Charge is, my lord, he is being a peon. In the night, he came to the building where the constructions were going on, court building, my lords, and he took away 2 cement bags and 2 poles. That is the charge, my lord. Therefore, he committed misconduct. Same, on the same matter, my lord, there is a criminal case that was filed, my lords, and which initially ended in conviction, my lords. And then the matter by way of revision was.
IA 1 of 24 is allowed, taking note of the contention that subsequent events are sought to be brought on record. Necessary amendment to be read out. Respondents are at liberty to file their statement of objections to the newly added additional grounds. List the matter week after next date would.
November. Tough November. Please, please.
Yes.
Great. 15.
Application is made, my lord, seeking extension of interim order. My lords, earlier, my lords, there was an interim order, my lords, not to disturb the petitioners. Matter pertains to, my lords, regularization. My lords, the interim order, my lords, was being extended, my lords, from time to time. However, my lords, after
Now,
28/9/2022, my lords, by inadvertence, my lords, the extension of interim order is not sought for, it is not.
What is the interim order passed?
My lords, not to disturb, my lords, the petitioners. Interim order, my lords, first interim order was granted, my lords, on 7/3/2022. The order, my lords, was that, my lords, respondents are hereby directed not to disturb the petitioners till the next date of hearing.
Now, since when has it not been extended?
My lords, from 23/3/2023, my lords, from 9/6/23, my lords, it is not extended.
From 9/6.
Yes, my lords, 9/6/23, my lords.
When have you filed the application?
Yes, my lords. Now an application, my lords, is filed seeking the extension of the interim order.
So you continue.
My lords, we are continued, but the apprehension is that, my lords, if they were to relieve us, my lords,
The IA number? IA number? The
1 of 24, my lords.
IA 1 of 24 has been filed. Looking for. You're working on contract or daily wage?
Contract.
Looking for extension of interim order granted on.
My lords, 7/3/2022, my lords. The first order was granted on
Granted on 7/3.
2022.
2022, which however, by oversight, was not extended from
9/6/2023.
9/6/2023.
My lords.
It is submitted that the petitioners continue to work as on date, and the non-extension of the interim order was by oversight. In light of facts borne out from record, including passing of interim order at the earlier instance, the interim order granted on 7/3/2022 stands extended. Accordingly, IA is disposed of. This is the matter in B group. Yes,
16.
Subject to your lordship's convenience, if a date may clearly be.
no, 2 weeks in date.
7th.
Yes,
Publish. 16, Jay Kumar.
This matter, my lord, there's an amended application filed, my lord.
Amendment
To file, there's an amended application filed, my lord, for the petition. I'll have to file my objections for that amended, because prior to it, my lord, I had filed objections.
what is the matter?
Lord, matter relates to suspension by an incompetent authority, my lord. The order of suspension is passed on April 2023. My lord, by the, my lord, annexure, page 170, my lord, is the order of suspension, annexure H.
Inquiry is started?
Yes,
No.
my lord. It is passed by the first respondent.
Inquiry is started or not yet?
Not yet, my lord.
Not yet.
Not yet.
Now, what is the legal position if they don't start inquiry?
My lord, I have sought for quashing of this order of suspension because, my lord, the first respondent, my lord, is incompetent to pass such an order, my lords, because the second respondent is the competent to pass the order. My
No, but why
appeal
you-
remedy itself is taken away, my lord.
My lord, in
I have
which-
challenged the rules itself in the,
No, that we'll see. But why you have not started the inquiry?
Lord, two.
Why should you pay him when he's sitting at home?
No, he is
Now
not
he-
sitting. 1 and 2 is been superannuated.
He's superannuated.
1 and 2 is
Petitioner
superannuated.
number
3
1
is
and-
already working.
3 is, my lord, reinstated, revoked his suspension and reinstated
No,
on
just one,
12/3/2024.
Just one. Now, if 1 and 2 have superannuated
Yes,
and you have not framed articles of charges, directly all proceedings go
yes, my lord.
insofar as 1 and 2.
Yes, my lord.
If you have not framed articles of charges as in the date of superannuation.
Yes.
Then for the others only we have. to
Period of
pay.
suspension, my lord, is the question, my lords, where the order of suspension is passed. Annexure H, my lord, was on 20th of April 2023.
20th
That
of
is,
April 2023.
is from the state government.
It is by the state government.
Why do you say that this order is by an incompetent authority?
My lord, the rules, my lord, which says, my lord, the,
Point out.
my lord, kindly, I filed an application for a amendment, my lord, on 6th July 2023.
So with a copy of that.
IA number
IA number 1, my lord, of 2023.
IA for
Amendment.
Amendment.
sir, amended petition you have already filed.
Yes.
Yes, my lord.
So you point out. Point
Please,
out.
my lord. Lord, rules 2020, my lord, annexure L, page 8,
Annexure
L.
page
Page 8, my lord. Relevant
annexure
annexure L, my lord.
page
Page 8,
8.
8 of the amended application, amendment application.
The application.
So,
The application was filed on 6th July 2023.
That is still not allowed, is it?
It is allowed. my lord.
Allowed. Okay, page 8.
Page 8 is the rules, my lord, 2020 of BBMP, my lord.
Yes,
May I request, my lord, to kindly
Yes.
come to page 50, schedule 2,
page
page 50.
yes.
Lord, Group A officers of scale, item number 2, my lord. Group A posts with pay scale of rupees 74,400 to 1,09,600 and below. That also, my lord, they have
stated as government. The rules are which under this also, my lord, under challenge, my lord. As per the Act, my lords, Karnataka Municipal Corporations Act, my lords, section 82.
No, you are saying now that in terms of Schedule 2,
Yes, my lord.
it is the government who is the
Yes, my
appointing
lord.
authority.
Yes, my lord.
And now the order is passed by whom now?
The government itself, my lord.
Huh.
My appeal remedy itself is taken away, my lord, by this rule, my lord, by which, my lord, earlier it was, my lord, the commissioner, my lord, it was BBMP commissioner, my lord. In 2020, my lord, so the amendment have taken place and the
No, now
amendment
correct.
has,
Now you continue to be under suspension, is it?
yes, my lord, still under, my lord, now, my lord, in March 2024, my lord, the third petitioner also, my lord, reinstated,
Reinstated.
holding pending inquiry, my lord.
So let the pleadings be complete. We'll decide the matter.
Lord,
Now your claim is this suspension period will have some implication on your emoluments, etc. And
First petitioner and second petitioners, my lord, both are retired, my lord,
no, we'll consider it now.
their pensioner benefits, my lord, are withheld, my lord. That
Why
is the,
pension benefit should be withheld?
lord, because of the pendency of the inquiry, my
No,
lord, that they.
You go ahead and pay the provisional pension. Let them pay the provisional
Please,
pension
my lord.
and then we'll fix it. So provisional pension is under what rule?
My lord, Corporations Act itself, Lord. That I have not produced before your lordships.
No, correct, but you just, if you want to check, I'll have it tomorrow.
Please, my lord.
You just say, what is the provision?
My lord, in the meanwhile, I'll also verify, my lord, whether they are getting the provisional pension or
Find
not.
out, find out. When do you want? Monday.
Monday, please.
So let it be settled for the time being, then we'll go into it and decide.
Please.
Relist the matter on. Monday. Huh?
Charge sheet is also been issued, my lord.
No, correct. Now we are only on the period of suspension.
Yes.
For the time being. The
Yes.
rest we'll see. Relist on 21st.
No blame.
17, 18, Keshav Bhatt A. Keshav Bhatt.
Petitioner is working as a D group employee, my lord, in the Karnataka Legislative Secretariat. My lord, it has called for applications, my lord, for appointment of junior assistants. Under the rules, my lord, 50% of these junior assistants has.
Who's the answering respondent?
Pardon me.
Who's the answering respondent?
But I filed the statement of objections in this matter. Already filed the statement of objection. My lord,
But I am raising two grounds.
Huh.
My lord, kindly see, my lord, annexure A.
Annexure?
A.
Huh.
My lord, ink page 18. Ink page 18.
Yes.
My lord, ಹುದ್ದೆ ಹೆಸರು ಕಿರಿಯ ಸಹಾಯಕರು 8 ಹುದ್ದೆಗಳು. For 8 posts, my lord, as junior assistants, my lord, they have called for appointment.
No, at page 8, junior assistants, 8 posts.
Yes.
Yes.
8 posts are there. But in fact, under the rules, my lord, your lordship may kindly see the rules, my lord. But that is at annexure A1. But ink page, my lord, ink page 39. Ink page 39. Your lordship gets it, my lord.
Yes.
Junior assistant, 50% by promotion from cadre of group D officials on the basis of combined seniority. So 50% of these posts should be filled by promotion. 50% by next, my lord, and 50% by recruitment. Your lordship gets there only.
Yes.
So, my lord, 50% direct recruitment, 50% by promotion. That is the thing. Now, my lord, petitioner is working as a group D employee and she is entitled to be considered on the basis where the 50% reservation is kept for promotion. but she will get it. But now they want to all these 8 posts to be directly recruited
That's not so.
in
my lord.
violation of these rules.
May I clarify?
Madam, he can clarify after I complete.
Your apprehension is that this 50% which is to be filled by promotion
Yes,
must be kept intact.
yes,
And unless that is kept intact,
yes.
it cannot be merged.
Madam, that is one. Secondly, this is, they are now call for 8 per, all the posts by their direct recruitment is in violation of these rules. One. Secondly, my lord, they before calling for, my lord, they have to take the concurrence of the finance department.
No, that will say, that will say. Now this 50% must be kept open and cannot be encroached upon. So that you are
Quite right, quite right.
Yes.
Direct recruitment is, my lord, to appoint their own people, my lord.
yes,
But their objections, I will.
let us see.
But yes.
I'll
they-
come back to you.
Yes,
My
but
lord,
their objections, they
No,
they
I'll
have
come-
filed objections.
I'll come back to you.
Allah, only 1 second, my lord. If your lordship sees their objections, that's really, my lord, very interesting. As and when in future they will do it and all that. They admit this. Kindly see the statement of objections which they have filed. Para 6, para 8. Statement of objections, my lord, page 6, para 8.
Yes,
Your lordship gets it, my lord.
yes.
Madam, as per the Karnataka Legislative Council Secretariat Recruitment of Conditions of Service of Officers and Employees Rules 2021, the mode of recruitment to the post of junior assistant is as follows. 50% by promotion from cadre group D. And my lord, then 50% by direct, that is admitted. Kindly see para 9 now, what they say is. Para 9. In the instant case, as per annexure H only, the recruitment is being done to the cadre of junior assistants only in respect of direct recruitment quota. The quota meant for the promotion of the in-service candidates is yet to be filled, and the case of the petitioner will be considered at that time as and when those posts fall vacant. There is nothing like that.
No, correct. Now we'll clarify
Yes,
that this 50% of posts for junior assistant
yes,
to be filled by promotion
yes,
in terms of the rule
yes.
to be kept vacant and not to be encroached upon by way of direct recruitment. We'll clarify that.
Very well, my lord. Now,
My lord,
out
the
of the 8 posts, 4 posts.
That's correct. So that will.
The total, my lord, the
Yes.
posts available are 23, my lord, not 8, my lord. 23 posts are available.
Whatever it is, what we are
Please.
saying is that in light of the rules,
Please,
50% of that, in terms of the rule, 50% of the posts of junior assistant is to be filled by promotion on the basis of combined seniority
please.
without violating the 50% quota as envisaged under this rule. You can go ahead. For
My lord, we have called for only 11 posts.
No, correct.
Yes.
So the interim order is there should not be violation of this
Please, please.
quota of 50%.
Out of 23, we have called for 11 posts by direct recruitment.
Now you,
That is less than 50% of the total number of posts available, my lord. And these 11 posts are very much required for the purpose.
So that you can go ahead without
Please.
touching this 50%.
Please. That's what we have already stated in the statement of objections that we
now
are
out of these
considering.
8 posts, my lord, if they fill only 8 posts are there now called for. If they fill it up during my tenure, my lord, I may not get the chance at all. My lord, when 8 posts are being filled up, my lord, 4 by promotion, 4 by direct recruitment.
So that we will ask, we can.
As and, my lord, what they say is as and when. That as and when may not occur at all.
No, that you point out from the rules.
Yes.
What is the how they are going to fill up this promotion?
But there is no posts are kept now. This call for is
Correct. I'm saying this promotional avenue
yes
of 50%. Now they have, we can make an observation that they may take necessary steps to also consider this quota and leave it at that. We can't give a positive direction.
along with this, my lord, along with my
But
lord,
we can't
while this, my lord, otherwise, my lord, my chance will go.
No, they'll consider it. Yeah. Now, how we can give a positive direction unless that proportion is also mentioned under the rules. I can't give.
But
it.
now they say, my lord, this is call for is, my lord, in the call for, whenever they call for the post, my lord, they have to keep these rules in mind. Call for must be, should be, my lord, in accordance with these rules. Now, if 8 posts are there, 4 should be by promotion and 4 by direct recruitment.
On that.
Or let them make a positive statement as and when, my lord, not as and when they are recruiting by direct recruitment. So if these 8 posts are filled by direct recruitment now, another 8 posts has to be given for
No, correct.
promotion.
But we can't give a positive direction. We'll ask them to consider that.
In the light of these rules, reconsider. Instead of considering, reconsider. That's all.
No, but we'll not come in the way of direct recruitment. But in so far as the promotional post.
That has to be, my lord. Otherwise, our chance will go.
No.
There is another reason why I submit this is also, my lord, annexure C, your lordship.
No, now we are only at the interim order stage. If you want a final disposal, let them, we'll consider it. Meanwhile, I'll ask them not to encroach upon this 50% and then we'll hear it. Otherwise, I could dispose it off, asking them to also consider this filling up of promotional quota in due course. I can't give a positive direction.
Not due course. Now when
I
they
can't
are
give a positive direction. Let us see. Otherwise, we'll hear the matter.
But she belongs to a backward caste, my lord,
No,
just to deny this.
No, we can't.
My lord, they have been doing this, my lord, intentionally.
No,
Intentionally. In accordance with the rules, let them do it. I have no objection at all. In accordance with the rules, let them do it, my lord.
No, I can make an
Rules say, my
observation.
lord, specifically it is admitted also.
No, but
And
I can't.
another point, my lord, another point. Annexure C, if your lordship sees.
No, that we'll see. I'll consider the interim prayer and keep it open. We'll see. I'll consider the interim prayer and keep it open. We'll see. Meanwhile, you do your research as to whether you can get a direction that proportionately it must be filled up. That's it.
Let them consider it proportionate.
My lord, we have already stated in the statement of objection that her avenues are not closed. She is having sufficient age, my lord. She is only 40
No,
years
but
old.
then you make out your case. Let us see. You do some research and come back. I'll make an interim order for the time being.
But interim order saying this.
It will be kept aside. It will not be encroached upon, that 50%. Remaining direction what you are seeking for filling up. You see if there's any authority, let me.
Sought for, my lord, the stay of this. My
No,
lord,
no,
in
that
any of
we can't.
this.
That we can't consider, but I'll keep your quota open. We'll see. The petitioner has sought for setting
But
aside.
in fact, they should have taken the consent of the finance department also to direct.
No,
They have no money.
No, that
But
we can't.
that is what the department has said.
No, that we cannot enter in.
I don't know. Next year, see if your lordship
Let us see,
sees.
I'm considering
And-
interim. I'm considering interim prayer. And so the petitioner challenge order at annexure A, whereby the petitioner has, whereby the Karnataka legislative, Karnataka legislature, or
Legislative Assembly.
Huh?
Karnataka, my lord, Karnataka Legislative.
Legislative Council.
Legislative Council
Karnataka Legislative Council.
has sought to fill the posts of
Junior assistants.
junior assistants.
Hiriya Sahayakaru, junior assistant.
Consisting of how many posts?
8 posts.
8 posts. Full stop. Land council appearing for the petitioner. I would point out that in terms of the Karnataka Legislative Council Secretariat notification 1/4/2022. Rules are framed according to which 50% of the posts of junior assistant are to be filled by promotion from cadre of Group D officials on the basis of combined seniority. And the remaining 50% by direct recruitment. It is the apprehension of the petitioner that the direct recruitment being made pursuant to annexure A is also an exercise so as to encroach upon the 50% quota to be filled by promotion from Group D officials. Full stop. it is the further contention that the petitioner falls within the zone of consideration for being promoted to the cadre of junior assistant.
Since she has worked for 14 years.
Since she has the requisite seniority. Full stop. Third counsel appearing for the contesting respondents have filed their statement of objections, and it is stated at para 9 that the recruitment being done is only in respect of direct recruitment quota. In light of the same, it is clarified that the process under Annexure A could be continued, while emphasizing that the filling up of posts of junior assistants by direct recruitment as resorted to at Annexure A is to be confined only to the direct recruitment quota. This is the matter in B group, week after next. Meanwhile, you just find out if there are any authorities, we'll dispose it of. On the ground of proportionate,
Yes.
you see if there's any authority, we'll consider and dispose.
Very good. Now only for direct recruitment, that proportionally, yes, they should. Very good.
Relist the matter on date 11. You give some authority of how this is to be considered when it is open. We'll consider. Yes.
19,
11.
11. November. No.
Appealing for the respond number 1 in this case.
For respondent number 2, my lord.
Yes.
My lord, I would like to pass on a memo, my lord, which has a letter issued by respondent number 1. This is passed subsequent to the order by this honorable court directing the respondent number 1 to seek instructions for the further action. Your Honor, my lord, the respondent number 1 has directed the petitioner.
What is the petition now?
Plus the petition is mainly this, that he has been transferred and he has been left with no posting. Now on 1/10/2024, my lords, respondent number 1, that is the authority has passed an order wherein he would come back and report at the headquarters, that is in Bangalore.
No, you know, show him a place, I'll close the matter.
Lordships, the copy is given to me today. I have no
No, just
instructions.
1 minute. Now, that is not sufficient. You must show him a place of posting.
Yes, your lordships.
So you tell us if he is going to report, where you are going to give, you place it on record, I close the matter.
Now, my lords, the last paragraph of the memo that has been produced by respondent number 2 now. It reads, if I may read.
No, where is the post? It's not sufficient to say that if he reports, we'll allot. You show me the post, I'll record that.
Oh, no, the posting has not been allotted.
So that you show that, you show the place of posting, I'll record.
Sure that I pass on the same to the authority. Pass an order and.
You place that before the court.
Can be taken up sometime during next week.
Yes.
Bring it on.
Lordships, it's just not transfer without posting. It's
Huh?
premature transfer also.
No, let us see, we'll see. Let them give, let them
Even on
give the.
merits, we have-
Even if they want to contest it on premature transfer, my lords, the problem was that he was on medical leave for quite some time. And there were 2 recommendations that were passed on to the authority by MLAs there. But because of his non-presence, because of his non-reporting to the duty, because of his ill health, the works that were supposed to be done were not going on. And they were continuously writing to us that because this man is not there, you please go on and bring somebody who is capable enough to work. That is the reason we had to go on with the transfer. And even while he was not keeping well, the respondent number 2 was placed in his place.
Now, how much more service he has?
My lord, both petitioner and respondent number 2 are both 59 years old, and both of us are contending we've got 6 to 7 months left prior to our retirement.
Because he was not keeping well, that we were, constrained to go on with the transfer. Because we were left with no option because he was not in a physical condition to work.
Correct. Now you show the place of posting.
It can, a
It
date.
also must be reasonable. If they give you a posting reasonably on the same whatever post you are, etc., you accept it and then there ends the matter. Let them give a place of posting, let us.
Today,
Let them give a place of posting.
today they have told head office.
No, correct.
Yes.
So I've asked them, you come forward with a place of posting. That by itself is not sufficient. You place on record a place of posting. If it is reasonable, then you accept it.
Due for retirement, that,
No,
very
that-
well, that's, I understand what you're like.
If
If
it
it
is
is reasonable, very well. Very well.
You place it on.
Yes,
Very
yes, I will. My lord, a date may be given, my lord.
Yes, yes. When will you come back?
Anytime during next week, my lords.
Date. 23rd,
24th, 20th,
24th.
please,
Yes.
interim order. Interim order subsisting as on today may be continued till then.
What is the interim order?
Stay of the order of transfer.
You're working.
Yes, I'm working in Davangere.
You're not relieved.
No, there's an interim order operating.
My lord,
on the date of transfer.
I reported to my duty, my lord, the relevant document is produced along with my IA for vacating stay on the 20th of August. 24th of August, they filed the petition, my lord. So I've reported to duty. After that, the stay has been granted.
And after which I've continued to work on it. Let me just draw the.
Let us see. Let us.
Yes.
I'm not entering into it. We'll see. If the place of posting suits you,
Yes.
there ends the matter.
Yes, till then, my lord, I may be continued here.
Interim order earlier grant is extended till the
Great.
next day. I hope you have seen the latest judgment on live law. If you don't report.
My lord, that's right. That's why, my lord, I have the benefit of
No,
it.
no, I'm just putting you on
Yes,
notice.
yes.
Because You're going,
Yesterday's
to,
date.
you're going to come back with some other litigant.
Very well. I've seen. Great.
Nishan. DL Sanjeev.
In WP number 25373 of 2024. And I appear for the respondent, my lords, in WP number 22116 of 2024. My lords, in this petition, on the last date of hearing, my lords, I had pressed for vacating of interim order. The board, my lords, stated that they would be filing the statement of objections. And time was granted, my lords. Till date, they have not filed.
In one of the other matters, my lord, that I'll have to file objections, my lord, request for a big time, my lord.
There is some urgency for me, my lords. If they want time to file objections, I have no objection, but let them take a date and file the objections. My lords, this is a very short matter.
Petition number 22116 of 2024. I appear for the petitioner, but the matter pertaining to my lord's seniority list, which is under challenge. Lord, in the previous round of litigation, my lord, the similar seniority list was challenged. Lord, the coordinate bench has passed an order quashing the seniority list on the ground that Lord, seniority list contravened Lord, the law laid down in my Lord M.N. Nagaraj's case. Lord, the very same mistake is crept in my Lord, and the board has published the impugned seniority list, which is under challenge. Lord, hearing Lord, IA for vacating is as good as my Lord hearing the main petition. Therefore, my lord, I will file objection to the IA for vacating stay. Your lordship may have this matter, my lord, after 10 days. And my lord, the interim order is granted. Since, my lord, in the previous round, similar interim order was granted.
Previous round, my lords, it was a concession order on a statement made by the board, my lords. There was a concession. To that effect, my lords, interim order was passed. Relying upon that order, my lords, they have said that this is a similar order and a similar order has been passed.
Let us see. We'll see. The objections to IA for vacating stay to be filed by the board as well as the contesting parties. Relist the matter. 10 days correct, Admil 1 date. 28th. You file by then.
My lords, this.
Just wait.
May I request for 24th then, my lords?
No, let him file. We'll see. 4th of November. Let us see. We'll set it aside or we'll place them on terms. Now, in case something happens.
Lords, this is the third date they are taking time, my lords.
Let us see. First before me, next we will not give.
Please, man. I'm grateful.
Group matters 21.
Order may be.
Interim order.
Interim order
granted
my lord, it may be
till the next date.
Let's
21.
Serial number 19, I'm very sorry. If it can be taken up on the 25th, 24th was the date assigned. Petitioner counsel is also here.
Very well.
25th, my lords.
28.
That's okay. Much obliged.
Great.
Matters 21. Abhinav Raman.
I'm
My lords, appearing for respondent.
My lords, in this matter, my lords, coordinate bench at Kalburgi bench has passed an order. There are batch of petitions in which very same notification is in challenge regarding the roster appointments. And there is an order, even the present petition has been mentioned in the same order. And all the matters have to be placed before the Honorable Chief Justice, my lords. And to secure appropriate order for consolidation of all the petitions for it to be heard together, my lords, in view of avoiding of conflicting decisions.
Here is the order passed in WP 201537 of 2023. There is the order dated 23/9/2024, which reads as here under.
This pertains to my lord appointment to selection to the post of associate professors. Kindly see my lord the.
Correct, but now the order of the coordinate bench refers to this matter only.
My lords, the notification is same for assistant professor as well as associate.
Of course, notification is same for both associate and what we have challenged is to the post of assistant professor.
Let us see, the registry to take note of the order of 23/9/2024 in an appropriate manner. Meanwhile, just find out in the registry.
I shall find out now that they have placed it.
Relist the matter. Now it's directed to be listed there on 21st.
Please.
Relist the matter on. We'll have it on 24th. Meanwhile, find out what it is.
Please.
Relist the matter on 24th.
Please. Obliged.
Obliged.
22, serial number 22. One.
Remember the petitioner's matter. In this matter,
Yes.
Lordship, the petitioner, he was appointed as a temporary, he was given a temporary posting, Your Lordship, as a second division clerk in the year 1985. So our grievance is subsequent to this posting, it was a temporary posting, and in 1988 he was removed. He was terminated from the posting on the ground stating that he's age barred, Your Lordship. On the ground that he is age barred and he's not working efficiently as per the roster scheme, he was terminated from his posting.
Annexure?
We have not attached that as an annexure. But that is an undisputed fact, Your Lordship. That fact is not in any dispute.
You were discharged.
I was terminated in the year 1988, Your Lordship. Subsequent to that, I filed a writ petition. And the court has directed the respondents to consider my representation, and the respondents have considered the representation and appointed me again in the year 1998, Your Lordship. In 1998, they appointed me and they have decided a pay scale of rupees 1,040 to 1,900 payable from the date of the order. The order was passed on 17/8/1998, Your Lordship. Lordship, so now my grievance is, when I was initially appointed in the year 1984, from 1984, they have terminated me in the year 1988. And subsequent to that, for almost 10 years, I was not having any job, Your Lordship. From 1984 to 1998, I have not been paid a single rupee.
Now, have you worked?
I have worked, Your Lordship. From 1984 to 1988, I worked. 4 years I worked.
1984 to 88.
88, I worked, Your Lordship. 4 years I worked. I've fulfilled all my duties. but I've not been paid even a single penny, even for that time when I worked, Your Lordship.
So that you place something on record, we'll direct them. Now for that period,
Please, Your Lordship.
you place something on record, we'll direct them.
Please, Your Lordship, I'll seek instructions from my client. We take note.
This, my lord, in this case, the petitioner appointed 1985 to 1988. He was temporary SDA at Swami Vivekananda High School. At the time, you have to temporary work. The post the said post was reserved for SC category. The petitioner belonged to BCT category, has approved the post incorrectly. It is the terminate of the post.
No, correct. Now, till the date of termination, he says between 84 to 88.
Yes, ma'am.
He has worked. If he has worked, then you have to pay.
So at the time you have to claim for the beneficiary. I have not, the observation of the single bench also. You have to, that period you have to claim for the monetary benefit he has claimed, no problem.
That's all. So let him clarify.
Please,
He
Your
says he is not paid for that period.
Please, Your Lordship. I will also, because from 1988 to 98, Your Lordship, 10 years, they have removed me without any, they have not given me a fair hearing also, Your Lordship.
I have not claimed for this.
I will produce the necessary documents to that.
So that's a different matter. Now, if you are taken on temporary basis to a post which was kept only for reserved, then you are not entitled. But for the period of your work, that we will consider and pass.
Please, Your Lordship. I will provide.
Learned counsel for the petitioner submits that for the period from 1984 to 88, though he has put in work.
1985 to 88.
Appointed on
85 to
1/4/1985.
1/4/1985
to 17/8/1988.
17/8/1988. Though he has put in work, he has not been paid any emoluments. Full stop. Petitioner to place on record any records in evidence of which respondent also to verify. Relist the matter on.
My lord, in this case, the annexer F. See the annexer F, page number 16. Typed copy. 17. Page number 17, typed copy. PTK. ಎನ್.ಆರ್. ನರಸಿಂಹಮೂರ್ತಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರು ವಿವೇಕಾನಂದ ಪ್ರೌಢಶಾಲೆ ಕುಪ್ಪೂರು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ತುಮಕೂರು ಜಿಲ್ಲೆ ಇವರ ನೇಮಕಾತಿ ಅನುಮೋದನೆ ಬಗ್ಗೆ ಪತ್ರ ವ್ಯವಹಾರ ನಡೆದಿದ್ದು ಆಯುಕ್ತರು ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯವರ ದಿನಾಂಕ 1/12/88 ಪತ್ರದಲ್ಲಿ ಈ ಕೆಳಗೆ ಕಾಣಿಸಿರುವ ಕಾರಣಗಳ ಮೇಲೆ ತಿರಸ್ಕರಿಸಲಾಗಿರುತ್ತದೆ. 1. ರೋಸ್ಟರ್ ನಿಯಮವನ್ನು ಪಾಲಿಸಿರುವುದಿಲ್ಲ. 2. ಒಟ್ಟಾರೆ ಸೇವಾ ಅವಧಿ ಇರುವುದಿಲ್ಲ. 3. ಸದರಿ ಅಭ್ಯರ್ಥಿಯವರು ವಯೋಮಿತಿಯನ್ನು ಮೀರಿರುತ್ತಾರೆ. ಮೇಲಿನಂತೆ ಹೊರಡಿಸಿದ ಹಿಂಬರವನ್ನು ಪ್ರಶ್ನಿಸಿ ಸಿ ನರಸಿಂಹಮೂರ್ತಿಯವರು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿಯು ದಿನಾಂಕ 11/4/89 ಇತ್ಯರ್ಥವಾಗಿ ಹಿಂಬಾರದಲ್ಲಿನ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಸಂಬಂಧಿಸಿದ ನೌಕರರಿಗೆ ಅವರ ಕುಂದುಕೊರತೆಗಳನ್ನು ಮಂಡಿಸಲು ಅವಕಾಶ ನೀಡಿ ಸ್ಪಷ್ಟ ಆದೇಶ ಹೊರಡಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ಅದರಂತೆ ಶ್ರೀ ನರಸಿಂಹಮೂರ್ತಿಯವರು ನಿರ್ದೇಶಕರು ಪ್ರೌಢ ಶಿಕ್ಷಣ ಇವರಿಗೆ ಸಲ್ಲಿಸಿದ ದಿನಾಂಕ 16/8/89 ಅರ್ಜಿಯಲ್ಲಿನ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಮರುಪರಿಶೀಲನೆ ಮಾಡಲಾಯಿತು. ಮಾನ್ಯ ಆಯುಕ್ತರ ಆದೇಶದಲ್ಲಿ ನೇಮಕಾತಿಯನ್ನು ಪರಿಗಣಿಸಲು ಯಾವುದೇ ಹೊಸ ಅಂಶಗಳು ಇರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಅವರ ನೇಮಕಾತಿ ಅನುಮೋದಿಸಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ.
No, just 1 minute. Now, next page, serial number 2 is what you're seeing. Next page, serial number 2.
ನೌಕರರು ಹಿಂದಿನ ಭಾಗಕ್ಕೆ ಆಹಾರರಿರುವುದಿಲ್ಲ.
That's what you're seeing.
Yes. ಅದರಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹೇಳಿದ ನೋಡಿ. ಮೇಲೆ ಕಾಣಿಸಿರುವ ಅಂಶಗಳ ಆಧಾರದ ಮೇಲೆ ಸಿ ಎನ್.ಆರ್. ನರಸಿಂಹಮೂರ್ತಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರು ತಂದೆ ಶ್ರೀ ರಾಮಯ್ಯ ಜನ್ಮ ದಿನಾಂಕ 8/4/49 ನೇಮಕಾತಿ ದಿನಾಂಕ 1/4/85 ಶ್ರೀ ಸ್ವಾಮಿ ವಿವೇಕಾನಂದ ಪ್ರೌಢಶಾಲೆ ಕುಪ್ಪೂರು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ತಾಲೂಕು ತುಮಕೂರು ಜಿಲ್ಲೆ ಇವರ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದ ಗರಿಷ್ಠ ವಯೋಮಿತಿಯನ್ನು 33ರಿಂದ 36ಕ್ಕೆ ಹೆಚ್ಚಿಸಿರುವುದರಿಂದಲೂ ಹಾಗೂ ಮೀಸಲಾತಿ ಉಲ್ಲಂಘನೆ ಸರ್ಕಾರ ಮಾನ್ಯ ಮಾಡಿರುವುದರಿಂದಲೂ ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಮೀಸಲಿರಿಸಿದ್ದ ಹುದ್ದೆಯಲ್ಲಿ
BCT ಗುಂಪಿಗೆ ಸೇರಿದ ಇವರನ್ನು ವೇತನ ಶ್ರೇಣಿ ಡ್ಯಾಶ್ ರಲ್ಲಿ ಕನಿಷ್ಠ ವೇತನ ಮೇಲೆ ಕಾಣಿಸಿರುವ ಷರತ್ತುಗಳು ಕೂಡ ಅನುಮೋದಿಸಿದೆ.
Correct, but what we are saying, for the period of actual work for 4 years,
Yes, ma'am.
you verify, you also independently verify whether it's worked. If he has worked, then something he has to be paid. If he has worked, at least for the actual work done. Remaining, we will not give any other
That
benefit.
appointment is illegal, I have to terminate.
Maybe, but now he has done, he has worked there. That you verify. If he has worked, then something you will have to ask the state to pay. It cannot be that he has worked without any pay. Relist the matter on 24th. You ask the government, you can't ask him to have worked without anything. Yes.
23.
Lords, I appear for the petitioner in this case. The petitioner was a branch manager at Ankola branch. With regard to some loans granted, some procedure irregularity has been cited as a charge sheet and paid. The second one is disciplinary matters, my lord. Because of that, petitioner is not getting the pension. So it may be taken on first, because first one they have given the major portion of gratuity amount for that gratuity. And the only issue was whether during the period of suspension, whether it should be counted for the service. It's earlier decided by this court, honorable court only. Second one, disciplinary action may be permitted to be taken first, this 2013 matter. That is 18,368 of 2013.
No, just one minute. Now, you have already attained superannuation.
Superannuation, yes.
When?
Because after superannuation, they have passed the order of dismissal as on the date of retirement from service. Actually, earlier prevailing in the law was that after retirement, they cannot pass it. But afterwards, it was referred to the 3-judge bench of the Honorable Supreme Court. And by virtue of legal fiction, the department action pending as on the date of retirement continued beyond retirement. And earlier, your lordship must be aware that earlier law was that after retirement, they cannot pass the order of dismissal, even in spite of legal fiction. Later on, it was matter to larger bench. And Honorable Supreme Court 2 and 1, 2 favor upon this one, held that even after retirement, from the earlier date, dismissal can be passed by virtue of legal fiction. So because of that, he has lost pension for having served around 38 years of service because of that. So I have to argue in it because there is a disciplinary action. It's a lot because 51 charges they made without any charge. Only last they are telling because of that there is no charge for 51. They say all procedure irregularity. You are likely to cause some financial loss. There is no fraud, no exceeding discretion or delegated power.
File your synopsis. We'll take it up. I'll fix a date.
28.
In fact, my lord, out of 51 charges, my lord, only 2 charges were held to be not proved. And my lord, it is not that these are, my lord, not so serious charges. There are specific findings to say that there has been loss caused to the banks. Accounts have gone NPA, my lord, loans have not been recovered, and an amount of almost 46 lakhs, my lord, have the bank has suffered losses. These are all, my lord, a total of 610 documents been marked in evidence. Lord, it has been proved that he's committed these lapses and irregularities, and therefore the order of punishment is passed. Lord, that is in the second matter. The operative portion of the order also says that the period of suspension should not be counted as period on duty. Therefore, my lord, if the connected matter, my lord, is taken up first, and your lordship, my lord, decides that matter, my lord, the bearing will directly be on the first matter, because, my lord, the gratuity that he is seeking is for that period of suspension. And because it is held to be a period not spent on duty, the remaining period, my lord, till he served in bank, my lord, we've paid gratuity.
You paid it.
Paid gratuity.
My lord, there is a
Therefore,
judgment
my
of
lord,
the coordinate bench.
it is the disciplinary inquiry matter that needs to be considered first. And my lord, serious charges of, my lord, inquiry proceedings only runs into almost 200 pages.
Make out your
Please.
synopsis
Very well.
of what article of charge, what evidence, what documents in a tabular form.
In fact, my lord, the inquiry report, my lord, comes out in a quite detail, and my lord, in a chronological order as to what the charges are and the documents marked in evidence, and analysis are quite specific. For my lord, it should not be much difficult for your lordship to, my lord, consider. In fact, if I read out charge sheet, my lord, that may lead to some confusion, but inquiry report is quite specific and detailed.
Lord, so
It
that
starts at page 310. And
Eight.
summarize 310 annexure H
The second matter.
in the second matter.
Good.
And
Disciplinary inquiry.
it has summarized the entire charge sheet as well as my lord analyzed the evidence on record in a quite specific manner. 310. As many as 51 charges, my lord, held to be proved against him.
Lord, the entire disciplinary proceedings is without following the rules and regulations.
That he can
stipulated.
argue, my lord,
Have
I'll
any
point out.
Tabular form.
I'll
with
point
regard to the regulation.
I'll point
Said-
out.
Followed.
No, my lord, it's not.
Put it, put.
I'll file my synopsis, my lord, it'll be easier for your lordship.
This one, with regard to
Try to
regulation,
keep it as short as possible so that not lordship.
without regulation,
You have a look at this.
It's not,
I'll give a copy.
I'll have a look.
I'll give.
Counsel for the petitioner. Files. A note,
But
same is taken on record.
I'm also filing my list of authorities, so my learned friend gets.
Respondent
Lords, I
files.
already filed the list of authorities. It is in the.
Respondent is filed the list of authorities.
Authorities.
Both parties are at liberty to file synopsis by the next date. Relist the matter on
28 will be,
Any date convenient to my learned friend, he has to begin.
28, 28,
28.
28 minutes.
Copy. Copy.
24. Prasad?
24, my lords, I had made a mention in the morning. I refer for respondent number 1 to request an accommodation for today. I've informed the petitioners as well.
Yes. But what is this matter?
This matter questions the seniority list of district judges, and the petitioner wants to, in the first matter, he wants to be placed above respondents numbers 3 to 34. My lords, and during the pendency of the writ petition, all the petitioners have retired. However, they still wanted to press this case for the benefit of super time scale being considered. So for that, my lords, it will have to be decided on merits, whether they are entitled to this reliefs that they have sought.
File a synopsis then, and we'll fix a date and go ahead with the matter.
Please, it lies in a narrow compass. Mr. Nagaran has to argue. That's why I requested for an adjournment in this today.
Relist the matter on
Any date, my lords, after next week, any date it can be fixed, my lords.
week of November date. 5th of November. Both sides to file a synopsis. But after serving advance copy on the other side. Yes.
Great, sir.
Great.
25.
Appear for the petitioner in this. My lords, a short accommodation. It may be fixed on 28th, my lord.
We'll file a synopsis before that.
Please, my lord.
Both sides to file synopsis. Relist the matter on
28th, my lord.
28th. Yes.
Much obliged.
26. Satish?
Appearing for respondent, my lord, in this case. My lord, kindly have it next week, my lord, 28th or 29th, my lord. I'm ready, but today I could not come to the court, my lord, for that reason.
Matter at request on
And
29th.
please, my
Yes.
7.
Lord, the matter pertaining to my lord seniority list in the cadre of my lord additional chief engineer. Lord, this is similar to my lord serial number 20.
Roger posted it to 4.
There's an overlap, is it?
Yes.
My lord,
We have to club it with that.
Lord, at serial number 20, my lord, latest seniority list is challenged. In the present writ petition, my lord, the seniority list of 2022 is under challenge. That is the only difference, my lord. In principle, my lord, on the same.
Has to be tagged. Because if that goes relisted on, what is that date?
4th
4th of November, along with seal number 20.
28.
This matter has to be heard first, my lord.
Huh?
If they're
Correct,
challenging
correct,
the old matter, my lord, if
That's
this,
why I have tagged it.
yes,
Hmm.
this matter has to be
We'll
heard.
hear
but
it,
if this
but
is
we have
what-
to hear both together.
Yes.
If the old seniority list goes, then the consequent one also will go. Let us see.
In that event, my lord, serial number 20,
Will have to be heard after this.
Yes,
but it's not, since
No,
other
we'll-
side,
no,
other side is,
We'll club it.
other side is insisting, my lord,
No, how can we decide challenge to a later seniority list when the earlier one is still under challenge?
Yes.
Huh? Isn't it?
yes,
Logically. So both will have to be heard
but
together.
if
So the
this,
challenge made there will be an overlapping of the grounds of attack, how the seniority is prepared. So we will take up together, we'll take the first one, second one, and then decide.
not if the ground floor goes, superstructure which is constructed on ground floor would collapse. Not the seniority list of 2022 goes, not board has prepared the seniority list of 2024 on the principle which is adopted in the year 2022. If my contention is accepted in the present writ petition,
This one goes.
that
Subsequent one
the
goes.
20 subsequent one.
go.
Let us see. That's why I've clubbed it. Let us
It
see.
should be in the B group, my lord, if
This 18 one. Huh? The B group. Anyhow, that is in B group, isn't it? The 20 is in B group.
20 is in IAM.
All of them not done, even 24.
No,
this
that
also-
one will put it, we'll fix a date. Let it be clubbed. Both you file synopsis. Yes, then we'll fix a date.
28.
Let's for the petitioner, my lords. My lord, 6 weeks time to file a rejoinder to the objection, my lords.
Might request. This the matter week of.
My lords, date may be fixed after 2.
Joined if any by the petitioner. Yes, next.
Tough round.
Please.
29.
And for petitioner, my lords. The petitioners are my lord, the Purva Karmikas, my lords.
Who is the contesting respondent?
Contesting respondent is my lord, state
State.
and deputy commissioner and also my lord, fourth respondent.
Yes.
Plus my representation, the annexure E, my lords. The annexure K to K3. That's wherein, my lord, without any reason, the respondents stop to pay the salaries, my lord.
You are still working.
Yes, ma'am, he's still working. My lords, earlier they are paying my lords 29 and all, 29,000 rupees, 30,000. Now they are paying only 14,000 and all, my lord, without any reason. So I produced, my lord, my salary certificate, my lords, at annexure H series.
Annexure?
H, G, annexure, annexure F, last condition.
This was the earlier pay skip.
Earlier pay scale, my lords.
Earlier.
Yes, ma'am. Now, my lords, they have to pay 32,600, page number 34, respect of first petitioner. 32,600, my lords. Page number 34, last condition.
Serial number?
Serial number 37, in respect of the first petitioner, my lords. My calculation is, my lord, as per page number 33, next is 34. Plus, as on 1/3/2022, they are liable to pay, my lords, 32,600.
This is as per government circulars.
No, my lords, this is my calculation. I have made this.
Correct calculation on what basis? Government.
On the basis, yes, on the basis of pay scale, my lords. I am appointed on, my lords, 1/3/1995. As on that date of appointment, I was regular pay scale of 840 per month, my lords. Now, my lords, without any reason, they are paying only 18,388, my lords.
They're not even paying this 23,234.
No, my lords. They are given time bond benefit, increments in the salary. The person who is appointed with me given promotion, and one person is died during the my lords, employment. Our wife was given, my lord, a compassionate appointment. My lords, but in respect of these petitioners, my lord, they not paying the salary
as per the appointment.
Where is the latest payslip?
Annexure F1 is 35, respect of first petitioner.
Now, you have to take your stand.
Appointment is illegal appointment of the Paura Karmika and D group. In this case, you have to the Uma Devi case, the contrary and
But
daily
you
wages appointment.
But have you filed your statement? You file your statement. As long as they are doing work, you cannot pay them less than the minimum wage payable as per the notification. If you are paying less than that, then it cannot be, you will have to, it's a different matter.
Yes, ma'am.
Kempanna, you will also have to take your stand.
As we have no role to pay
They-
appointment, that is the government has to take.
Take your stand.
Yes, ma'am.
Plus, their stand is that, my lord, these petitioners appointed, my lord, as per the council decisions, my lord. As on the date of appointment, the deputy commissioner is the authority to appoint the, my lord, regularize the Paura Karmikas, my lord. But, my lord, as per the council decision, my lord, the petitioners are regularized as Paura Karmikas.
Regularized.
Yes, my lord, we are regularized. I am produced the, my lord,
Government has not yet passed any order on that.
No, no, my. It is.
Annexure A, will also be kindly see.
Councillors have taken decision and appointed. That's what the government is not appointed.
No, correct, but then the council may have sent a recommendation to the government, isn't it?
No, by that time it is power was transferred to the deputy commissioner, not to the council.
But anyhow, my lord, the persons who are appointed along with these petitioners, my lord, given promotion, given all benefits, my lord. Petitioner also, my lord, given the increments, time bond, 10 years time bond, the benefit also given. And compassionate appointment is also given, my lord. And produce all the documents. Annexure A, will also be kindly see. And annexure B, my lord,
But let them complete their pleadings. You take your stand in writing.
Yes, my lord. I verify and
State to complete their pleadings by the next date. Relist the matter on, when do you want?
Huh?
When do you want?
21, 29,
29.
9.
By then you must take your stand in writing.
Yes.
Who's going to clean this? Who's going to clean your road? You require the services, you will have to pay. What you pay cannot be less than the minimum wage notified.
Now there are thousands of Paura Karmikas are staying in different municipalities. That is the policy of the government. Government has to take decision. Thousands of Paura Karmikas are.
So entire.
You will have to take a uniform stand.
Not only this municipality. All municipalities the same problem.
municipalities have to cover.
Same problem.
Same problem.
There any other matters, we'll club it then. But at least till what is decided.
Pending in so many cases is pending is there. Yesterday I have to come to this similar case of the.
No, so then what you do, you ask your official
Yes,
and get a list.
yes, ma'am.
We'll club everything and if there's going to be an overlapping of the legal issue,
Yes, ma'am.
we'll club everything. Yesterday matter, you give the number.
Yes,
Meanwhile, you ask your government official to make a list.
yes, ma'am.
At least that you place it by 29th.
Yes,
We'll club all the matters and then we'll take it up simultaneously.
For that it can be avoided repetition. Even in the second petition, fourth petitioner has already filed and already rejected by this honorable. Again, he has
different issue.
Let us see, let us see.
similar.
Anyhow, we can club all the matters and take it up together. You give the other numbers, ask your official to get the number.
Yes, ma'am.
Yes.
30, Angmar, please.
Lord, appear for the petitioner, my lord. There is some power problem. Kindly have short accommodation next week, my lord.
Yeah, 20.
30.
30th, my lord. 30, my lord.
At request. Release
Next week only, I will do it.
matter on date.
30th.
Yes.
30th. Till number 31.
Not file their objections, your lordship.
The state has to file.
Not the state, the,
Prashant.
please. The Tumkur Cooperatives Milk Federation.
Respondent number 3.
You are appearing?
My Lord, I am appearing for respondent, my lord. My
Sorry?
lord, it is ready. Statement of objections is ready. I will serve it, my lord. It may be taken on 30th, my lord.
Relist the matter on 30th.
Please.
Yes. Next.
32, Sunil Kumar H.
My lord, appealing for respondent. Pleadings are not complete, my lord. They will have in the last occasion also, when the court had directed on 6th March, that they have to serve the petition copy. On 12th June, we appeared. Even
Okay,
then,
just-
petition copies are not served.
Give him one more.
Please,
Give him one more set.
please,
Relist the matter week after next week.
please,
5th November.
5th of November. Give him a
please,
set.
please, definitely. Obliged.
33,
Petition copy.
Please, my lords. This is a matter pertaining to an Anganwadi worker who was appointed at Lakshmipura in Shivamogga, my lord. She was married in, that was in 2015, my lord. And then thereafter, she was married. And in 2019, and with her husband, she has been staying at Perumanahalli. In 2023, she learned that in Perumanahalli, because the distance is around 60 kilometers, she has to travel. And thereafter, she has gone in the family way. She has 2 children, and her father-in-law is suffering from cancer. So in July, she gave an application for seeking her transfer from Lakshmipura to Perumanahalli, where the concerned worker, the Anganwadi worker, was to retire. So her application was not being considered, and another Anganwadi mini worker who was working at Lakkinhalli, she was being transferred to Perumanhalli. She doesn't fulfill the eligibility criteria of completing 5 years in mini Anganwadi as per their own guidelines issued, my lord. So therefore, that on this ground of eligibility criteria, which is not fulfilled by respondent number 6, my claim for transfer kindly be considered, my lord. That was my request. That has not been considered. So I'm before this honorable court for seeking that I'm eligible and the person who is appointed is not eligible.
What is there any policy regarding?
Yes, my lord. I have produced it, my lord.
Transfer.
Your lordship, yes, your lordship will kindly find it at annexure K, my lord, at page 41.
Yes.
In that, they have issued at page 43, your lordship will get it. Anganwadi ಕಾರ್ಯಕರ್ತೆಯರು ಮತ್ತು ಸಹಾಯಕಿಯರನ್ನು ಆಯ್ಕೆ ಮಾಡಲು.
Page 40.
Your lordship could get annexure K 41.
Yes.
Then annexure 43. Please.
Yes.
At next page 45, your lordship will kindly see.
Yes.
In item number 6, my lord. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆ ಖಾಲಿಯಾದ ಸ್ಟ್ರೋಕ್ ಅಥವಾ ಹೊಸ ಕೇಂದ್ರದ ಅರ್ಹ ಮಿನಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕರಿಂದ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ಕೋರಿ ಅರ್ಜಿ ಸ್ವೀಕೃತವಾದಲ್ಲಿ ಮಿನಿ ಕಾರ್ಯಕರ್ತೆ ಮೊದಲನೇ ಆದ್ಯತೆ, ಸಹಾಯಕಿಯರಿಗೆ 2ನೇ ಆದ್ಯತೆ, ಸ್ಥಾನ ಪಲಟಕ್ಕೆ 3ನೇ ಆದ್ಯತೆ, ದಿಸ್ ಇಸ್ ಸ್ಥಾನ ಪಲಟಕ್ಕೆ, ಐ ಆಮ್ ಸಿಕ್ಕಿಂಗ್ 3rd ನೀಡಿ ಅವರನ್ನೇ ಆಯ್ಕೆ ಮಾಡತಕ್ಕದ್ದು. ಅಂತಹ ಯಾವುದೇ ಅರ್ಜಿಗಳನ್ನು ಸ್ವೀಕೃತವಾಗಿಲ್ಲದಲ್ಲಿ ಸ್ಥಾನಪಲಟ ವರ್ಗಾವಣೆಗೆ ಆದ್ಯತೆ ನೀಡುವುದು. ಸದರಿ ಯಾವುದೇ ಪ್ರಕರಣಗಳು ಇಲ್ಲದಿದ್ದಲ್ಲಿ ಹೊಸದಾಗಿ ಆಯ್ಕೆ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪ್ರಾರಂಭಿಸಿ. Then kindly see at page 48, my lord, the clause number 12. ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಅಂಗನವಾಡಿ ಸಹಾಯಕಿಯರನ್ನು ಕಾರ್ಯಕರ್ತೆಯನ್ನಾಗಿ ಪದೋನ್ನತಿಗೆ ಗುರುತಿಸುವ ವಿಧಾನದ ಕುರಿತು. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗಳಿಗೆ PUC ಉತ್ತೀರ್ಣ ಹೊಂದಿದ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯರಿಗೆ ಮೊದಲ ಆದ್ಯತೆ ನೀಡುವುದು. ಅಂಗನವಾಡಿ ಸಹಾಯಕಿಯರಿಗೆ 5 ವರ್ಷ ಕನಿಷ್ಠ ಸೇವೆ, ಉತ್ತಮ ಸೇವಾ ದಾಖಲೆ, ಹಿರಿಯ ವಯೋಮಾನ ಹೊಂದಿದ ಸಹಾಯಕಿಯರನ್ನು ಉಚಿತ. So therefore, here they say both of them
these mini Anganwadi as well as the helper with the other grade. 5 years experience, if it is they have, they should be considered to be appointed as Anganwadi worker, my lord. So here, may I bring it to your lordship's kind notice that the respondent number 6, who is Srimati Jayashila, she was appointed at page 51, annexure L. This is to Peruman Halli, she has been transferred, but her appointment, your lordship will find at page 40, my lord.
She has not completed the.
Yes, my lord. At page 40, your lordship will get it. At Lakkenhalli, on 13/1/22, she was appointed.
So she's not eligible.
So 5 years period has not been completed.
Look into.
My lord, one submission is that these Anganwadi workers are being appointed from the regional area within 3 kilometers radius of their residence normally. My lord, when this Anganwadi Karyakarta is, when she is transferred to another place where 60 kilometers beyond, according to the 60.
No, I'll clarify, my lord. In Peruman Halli, where I am seeking my this appointment as Anganwadi worker, the distance is hardly 700 meters to the Anganwadi center, my lord. So if I am transferred, the distance is hardly, now I have to travel 60 kilometers.
No, under the.
At present, she is working in.
At Lakshmipura. She is
Yes.
working at Lakshmipura, which is in Shimoga district, my lord. From there, she is seeking transfer to Tarikere Anganwadi area, where from her house, the distance is around 700 to 800 meters.
Page 45.
Please, my lords.
At seal number 6, the transfer applications can also be considered.
Considered.
So you look into it, get instruction.
I'll get instruction.
When do you want it?
Next week.
Date. State to complete
24.
instructions by the next day.
Please.
30th, and 30th.
Please.
30th.
Very well. Much obliged, my lord.
34, let it be. Petition.
Yes.
Lord, petitioner was, Lord, initially, Lord, has a Anganwadi helper. She has been appointed in the year 2011 at annexure B. Lord, subsequently, she has been promoted as a Anganwadi assistant in the year 2017 at annexure C at Anganwadi center at Pura of HD Kote Taluk. And Lord, in the year 2023, she received a notice with an allegation that the milk powder was missing from the Anganwadi center. She was caught red-handed and explanation was sought on 12/7/2023. Allegation that the milk powder was missing. She was caught red-handed from the Anganwadi center. Lord, the order of dismissal passed on 4/9/2023 indicates, Lord, prior to issuing of such SOCAS notice, the decision already taken on 5/7/2023 to dismiss the petitioner from the service. That kindly see annexure A, my lord, paragraph 2 of the order passed by the fourth respondent. Ullekha number 2. Page 11. Lord.
Yes. Yes.
ಪ್ರಸ್ತಾವನೆ ಉಲ್ಲೇಖ ನಂಬರ್ 1ರಂತೆ ಪತ್ರ HD ಕೋಟೆ ಶಿಶು ವಿಜ್ಞಾನಪುರ ಯೋಜನಾ ವ್ಯಾಪ್ತಿಯ ಪುರ ಗ್ರಾಮದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯ ಭಾಗ್ಯರವರು 4/7/23ರಂದು ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಲ್ಲಿರುವ 13 kg ಹಾಲಿನ ಪುಡಿ ಪ್ಯಾಕೆಟ್ಗಳನ್ನು ಚೀಲದಲ್ಲಿ ಕಟ್ಟಿ ಆಟೋದಲ್ಲಿ ಸಾಗಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಅಲ್ಲಿನ ಗ್ರಾಮಸ್ಥರು ಖುದ್ದಾಗಿ ಆಟೋ ಸಮೇತ ಹಿಡಿದು ಇಲಾಖೆಯ ಅಧಿಕಾರಿ ಮತ್ತು ಸಿಬ್ಬಂದಿಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯಾದ ಶ್ರೀಮತಿ ಭಾಗ್ಯರವರು ಸಾಕ್ಷಿ ಸಮೇತ ಸಿಕ್ಕಿಬಿದ್ದರಿಂದ ಹಾಗೂ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಯೋಜನಾದಿ ಖುದ್ದಾಗಿ ಭೇಟಿ ನೀಡಿ ಅಲ್ಲಿನ ಗ್ರಾಮಸ್ಥರಲ್ಲಿ ಪರಿಸ್ಥಿತಿ ಅವಲೋಕಿಸಿ ಅವರನ್ನು ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಯಿಂದ ವಜಾಗೊಳಿಸಲು ಶಿಫಾರಸಿರುತ್ತಾರೆ.
ಉಲ್ಲೇಖ 2ರಂತೆ 5/7/23 ಶಿಶು ಅಭಿವೃದ್ಧಿ ಇಲಾಖೆಯ ಅಧಿಕಾರಿಗಳು ಗ್ರಾಮಸ್ಥರ ಜೊತೆ ಮತ್ತು ಬಾಲ ವಿಕಾಸ ಕಾರ್ಯಕರ್ತರ ಸಮಿತಿ ಸಭೆಯನ್ನು ನಡೆಸಿ ಹಾಲಿನ ಪುಡಿ ಸಮೇತ ಅಕ್ರಮವಾಗಿ ಆಟೋದಲ್ಲಿ ಸಾಗಿಸುತ್ತ ವಿಷಯ ಮತ್ತು ಕಾರ್ಯಕರ್ತೆಯ ಶಿಸ್ತು ಕ್ರಮದ ಬಗ್ಗೆ ಚರ್ಚಿಸಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಆಹಾರ ಪದಾರ್ಥಗಳನ್ನು ಸರಬರಾಜು ಮಾಡಿದ್ದರೂ 6 ತಿಂಗಳಿಂದ 3 ವರ್ಷದ ಮಕ್ಕಳಿಗೆ ಮನೆಗೆ ವಿತರಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು 3 ರಿಂದ 6 ವರ್ಷದ ಮಕ್ಕಳಿಗೆ ಶಾಲಾ ಪೂರ್ವ ಶಿಕ್ಷಣವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಮತ್ತು ಇಲಾಖೆಯ ಮಾಹಿತಿಗಳನ್ನು ಫಲಾನುಭವಿಗಾಗಿ ಸರಿಯಾಗಿ ನೀಡುತ್ತಿಲ್ಲವಾದ್ದರಿಂದ ಈ ಕರ್ತೆಯನ್ನು ವಜಾ ಮಾಡಬೇಕೆಂದು ಬಾಲ ವಿಕಾಸ ಸಮಿತಿಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. That is on 5/7/2023. The notice kindly see the notice issued on 12/7 at Annexure D.
Now that we'll see. Now you take your stand in writing. Please. Let them take the stand in writing.
Now, my lord, by virtue of this order, now they wanted to fill up the vacancy by notifying. I produced the IA, my lord, the file.
That would be subject to this. We will make it clear. And we'll hear this.
Lord, once, my lord, the application is called and filled the vacancy.
So we'll make it clear that they have to mention in the notification that in light of this matter being pending, whatever you are going to fill up by recruitment would be subject to orders to be passed, and the newly appointed person cannot claim equity. You have to notify it in your selection, the list, as well as in the appointment.
Please.
And all this Anganwadi thing also must be done properly. There must not be.
There is
any-
serious allegations against.
So correct. So you file your statement.
Please.
I had given explanation at Annexure E.
Let us see, we'll see, let him file a statement. The petitioner has sought for stay of the notification dated 19/9/2024,
Please.
whereby the notification has been passed to fill up the post of Anganwadi assistant.
Teachers, assistant, please.
Anganwadi assistant.
Assistant.
As regards, which is that?
Serial number 11.
As mentioned at serial number 11.
11. That is Pura.
It is that this vacancy sought to be filled up was consequent to the removal of the petitioner working in the same post. In light of pendency of the present writ petition, wherein the termination of the petitioner is in challenge, it's made clear that filling up of the post at Annexure F would be subject to orders to be passed in the present writ petition. Such a fact of pendency of the present writ petition to be notified to the applicants who are sought to be appointed by virtue of the notification at Annexure F, in order to ensure that the persons appointed would not claim equities in the event the present petition is allowed. There is a statement of objections to be filed by the state within 10 days. Relist the matter on. Yes.
6th of November.
Please.
5.
Here for respondent number 2 and 3, my lord. Kindly short accommodation because of senior is out of session.
My lord, there is a similar matter challenging the very same endorsement as in this writ petition. This both need to be combined and heard together. The pleading is complete.
Short accommodation. Next week maybe.
Relist along with the WP number so and so.
8,194.
Filed the objection.
They have filed the statement of objection.
Filed the objection.
On date could.
On or after 6th November, may kindly.
Date could after. Admin. 11th. AGA. Now who appears for 4?
194.
Government.
Government advocate.
AGA
He
is
has
directed
taken
to
notice.
accept notice for 1 and 4. Yes. Next.
36.
Petitioner.
Yes.
11.
Recruitment matter, my lord, pertains to recruitment to 92 post, my lord, station controller train operator in the BMRCL. My lord, the recruitment notification, my lord, prescribed, my lord, a competitive written examination. The written examination is conducted, my lord, petitioners, my lord, are my lord, top rank holders, my lord, and are in the select list. Private respondents, my lord, feature in, my lord, what is called the waiting list. Thereafter, my lord, the recruitment notification also, my lord, prescribes, my lord, a psychometric test to be conducted.
What is?
A psychometric test. But the psychometric test, my lord, is thereafter conducted. After the psychometric test is conducted, my lord, a notification issued, my lord, prescribing the minimum eligibility criteria after the test is conducted. Thereafter, my lord, I am found to be ineligible, my lord, on the basis of psychometric test. And thereafter, my lord, I'm ousted from the list. My lord, this matter, my lord, was heard by coordinate bench. My lord, as by way of an interim order, my lord, dated 21/12. My lord, a fresh psychometric test was directed to be conducted as regards the petitioners. That was taken up in appeal. My lord, the division, honorable division bench, my lord, felt that such an order could not be passed as an interim stage, and thereafter stayed that order. My lord, I will only, my lord, trouble your lordships with the recruitment notification. The recruitment notification is 52.
No, appointments are made, not
Yes,
yet
please.
made. Anyhow, I should say the, I mean, irrespective, without any, that metro is boon. Day yesterday, I traveled, I think about some 13 or 14 kilometers in whatever, went on time. And my vehicle, I asked it to come. So
I think
I reached.
More than day before yesterday. Yesterday, people would have felt the advantage of metro
yesterday,
with the rains.
No, yesterday only.
Yesterday, yes. Yesterday because
So I reached 10 minutes late, but my car came much, I don't know when it came. So I reached in time, and I should say it is a boon for it. And despite it being jam-packed during office hours, it's a small price to pay to reach your destination in time. So it's definitely doing well. Yes.
My lord, only contention, my lord, is that the psychometric test, my lord, is in the nature of an eligibility test. And an eligibility test, my lord, cannot be conducted without, my lord, prescribing the minimum eligibility criteria before the examination is conducted. Even the recruitment notification.
So just take me to the recruitment notification.
Kindly. Page 52, if your lordships may kindly have the recruitment notification. And thereafter to page 55, my lord, paragraph 8.
Page 50?
52, the recruitment notification starts. I'm so sorry, this is in the second petition.
Yes, first petition, I think Mr. Ravi Shankar is appearing.
Not
Second petition, my learned friends appearing.
WP 28577.
Manjuna. Second petition. Second.
I'm so sorry, I should have made that.
Page?
Page 52, my lord, the recruitment notification commences. Page 55, paragraph 8, if your lordship kindly sees, my lord. At page 55.
Para 8.
Para 8. ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ. ಲಿಖಿತ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳ ಆಧಾರದ ಮೇಲೆ ಆಯ್ಕೆಯನ್ನು ಕಟ್ಟುನಿಟ್ಟಾಗಿ ಮಾಡಲಾಗುವುದು. ಆಯ್ಕೆ ಮಾಡಿದ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೂಲ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆಗಾಗಿ ಮತ್ತು ಕನ್ನಡ ಪರೀಕ್ಷೆಗಾಗಿ ಕರೆಯಲಾಗುವುದು. ದಾಖಲಾತಿ ಮತ್ತು ಕನ್ನಡ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾದವರನ್ನು ನಂತರ ವೈದ್ಯಕೀಯ ಫಿಟ್ನೆಸ್ ಪರೀಕ್ಷೆ ಮಾಡಲಾಗುವುದು. Very clearly says that the recruitment, my lord, will be conducted on the basis of the marks in the written examination. May I read that again?
No, it's clear.
Please.
And there would only be a medical test.
Please. That, my lord, is contemplated under clause 9.
Only as
eligibility.
Yes.
Para 9. Para 9, my lord. Next page.
So it's only in terms of a written exam.
Please. I am, my lord, featured in the select list. In fact, petitioner number 1 is rank holder number 1. The private respondents are in the waiting list.
Para 9?
Para 9, my lord, is what is the medical test. The lordship sees the second paragraph there, my lord, second unnumbered paragraph. Station controller train operator ಗಳಿಗೆ 1:5 ಅನುಪಾತದಲ್ಲಿ psychometric ಪರೀಕ್ಷೆ ನಡೆಸಲಾಗುವುದು. That is the only contemplation.
Now, this is Which post?
It's called station controller, train operator,
They're the ones who run the trains actually.
Station controller.
station controller.
And train operators also. So they are the ones actually, they're the and engine drivers, so to speak.
Loco mode, loco pilot.
What is this 1:5 ಅನುಪಾತದಲ್ಲಿ psychometric?
1:5 essentially is the
Every one
after-
post, 5 candidates.
May I just clarify that, Lords, if your Lordship permits?
Yes.
Lords, the written test is conducted.
Yes.
On the basis of the persons who would have secured the marks, Lords, based on the number of posts, into 5 will be Lords, made eligible to undertake the psychometric test. That is what it essentially means. So 1:5 is as against one post, 5 persons who would have participated in the written test would be made eligible to take the psychometric test.
Yes,
That's what.
that's it, correct.
Now, my lords, the core issue, my lords, if your lords were to consider this, my lords, there is no cutoff marks prescribed in the written test. Lords, now the resultant situation is a person who has secured 18 marks in the written test as against 85-90 marks, like the petitioners, are the ones who are now selected, my lords, by virtue of the second process, which is called as the psychometric test. Number one. Secondly, this is the first time, my lord, in this metro that the psychometric test is being conducted. The earliest of the recruitment took place in the year 2016. 2023 is the next recruitment. Not what it prescribed was a medical test in the nature of a psychometric test is what is contemplated. That is already read before your lordships, my lords. I will not be repetitive of it. Now, what was psychometric test was never known. It was not notified. Not 4 days before the test were to begin, on 17/11, they sent a mail for the test to be conducted on 21st, 22nd, and 23rd, saying that psychometric test will be consisting of 1, 2, 3, 4, 5 subjects, including something called as a reaction test. Now, what is reaction test is never provided for, my lords. Even in that leak, we have provided the documents. My lords, considering all these things, my lords, this honorable court in the initial stages or the interim stages directed that there's a requirement of giving one more opportunity of conducting a psychometric test because there was no equal opportunity or there was no exposure to the opportunity which was made available, my lords, to the persons who would be successful. So therefore, but nonetheless, my lords, the metro went before the division bench and the division bench said at an interlocutory stage, there should not have been a direction to conduct a retest. That's essentially what was directed by the honorable division bench. Now the matters that be lodged before your lordships, my lord, there are 2 questions which essentially arises for your lordships consideration. Number one, my lords, if a written test is conducted, can it be rendered completely OTOs? That, my lords, if it is something like this, it is rendered completely OTOs, where the test, the results of the written test is completely overcome by conducting the psychometric test, and the people who are completely in the down bottom of the written test results, my lords, are the ones who are actually selected, my lords, in the psychometric test. There should have been some minimum cutoff marks. Lord, the reason why I say this is, lords, let us assume, my lord, that there are candidates for whom I am appearing who have scored about 80 to 85 in the written test. Lord, there are successful respondents who have secured 18 marks to 22 marks, my lords, in the written test. My lords, in the other recruitment processes conducted by the the Railway Recruitment Board (RRB), they prescribe a cutoff marks of 45%. If a person doesn't qualify himself in the written test by securing 45%, then he will not be eligible, my lords, to take the psychometric test. Notwithstanding that 1:5, my lords, your lords knows that even when the district judge exams are conducted, in the preliminary examinations, my lords, the written test, there is a cutoff marks which is prescribed. If a person doesn't pass the written test within that cutoff marks, notwithstanding 1:5, whoever is the remaining eligible candidates will have to be made eligible for facing the viva post. This is number one. Lords, point number 2 is, you exposed us to an unknown competition. Lords, this is something which was not known at all, not notified, not known. 3 days prior to the date on which these tests are conducted, you say that this is what we are going to conduct. You don't give even ample time, my lords, for preparation. And one very serious thing is, there is something called as reaction test, where 1 second is 1000 milliseconds. There are students who are failed on the ground that they have failed in 0.02 milliseconds in the reaction test. But what is reaction test? Let them show on record that they had given ample notice of the fact that there is something which is a reaction test to which we are required to be exposed to. Further, just one more point I will just add it. These are the points on which I will be deliberating, Milords. One more point which I really want to add in this matter is, this is a recruitment process where after the written test is conducted, it is something like in a free field, people are permitted to just run amok. Whosoever runs the target which they want, without we knowing what is the target, whosoever runs the target where they want, they are selected. They have not fared in the written test at all. And Milords, I recollect, Milords, how this test is conducted. I remember when we were kids, we were playing this pinball. That marble used to go and sit at the places where there are exposed to. My apologies, Milords, because of my illness, I could not be personally present in the court.
Last part I couldn't hear. Last part we couldn't hear. There was some connect.
My apologies, Milords. Milords, I'm sorry. The last part is, Milords, am I audible, Milords?
Yes.
Milords, the last part is like this. They just throw the marbles. Whichever marble goes and hits that minimum target, let us say of 50 marks, they are passed. Those who do not go, they are not passed. Neither in the notification nor in the subsequent notices sent to us on 17/11, it indicates that there is any cutoff marks for the psychometric test. As a matter of fact, we have failed only because of a cutoff marks which is prescribed in the psychometric test, which is never a part of the recruitment process.
To add, my lord, the notification regarding the minimum marks is prescribed after the examination is conducted.
Where is that?
Your lordships will see that at page 158. (158). Your lordships will see, my lord, T1, T2, T3, T4, and TG test. And thereafter, my lord, the candidate must achieve marks equal or greater than the minimum score specified for each of the tests. If the candidate scores below the minimum marks in any one or more tests, it will be deemed as not suitable. The candidate must attain a score below the specified maximum marks for test Q and test 7. Surpassing the maximum marks in either test will result in being deemed not suitable.
This is on what date?
No, there is no date, my lord, but I don't think it is disputed that this is issued after the examination. This is issued after the examination. There's no dispute.
The minimum marks is based on the number of candidates who attempt the examination. There's a formula which is prescribed for calculating.
Come back.
That can never be. It's not a competitive examination.
You complete it.
Please.
So this is subsequent.
This is subsequent.
Yes.
My lord, such a test, my lord, this is not a competitive examination as though the marks will be discovered after the examination. That, my lord, is the written examination. Giving a go-by to the marks achieved by the petitioners in the written examination. In the psychometric test, my lord, marks are prescribed, minimum marks are prescribed after the examination. And this was exactly the case in Manjushri's case, my lord, for the Supreme Court. May I pass on?
Yes.
Where, my lord, there was the case of an interview.
Manjushri. This is referred to the larger bench.
Para 12, my lord.
This is anyways been explained.
Para 12, this appeal is by K. Manjushri, whose name was found in the first list. She contended that the minimum marks for interview not having been prescribed either under the rules or by the resolution dated so-and-so by the administrative committee the action of the full court altering the norms for selection by introducing minimum marks for interview after completion of the selection process would amount to changing the rules of the game, not only after the game was started, but after the game was played. Para 17, my lord, the lordships, my lord, formulate the questions.
No, this has been answered.
I'm
The
sorry, what?
reference has been answered.
No, not yet.
Yes,
No,
yes.
no, it's pending, my
It's
lord,
on
before the larger.
No, it's answered.
Manjushri.
No, last one.
We'll just check that.
But I
Manjushri,
have
will it?
that.
No, it has been answered.
I'll just check that.
Last month, Apex Court has referred to both judgments and have.
Regarding
I'll
the
just
rules,
check that.
change in the rules. Please see para 27.
Yes.
But what could not have been done was the second change by introduction of the criterion of minimum marks for the interview. The minimum marks for interview had never been adopted by the Andhra Pradesh High Court earlier for selection of district and sessions judges grade 2. In regard to the present selection, the administrative committee merely adopted the previous procedure in vogue. Previous procedure as stated above was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolutions dated so and so and held that was adopted on so and so was only minimum marks for written examination and not for the interviews. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process consisting of written examination interview was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer to 3 of them. Then para 28, my lord, in Ramchandra Iyer's case is referred to. Para 33, if your lordship may straight away come to.
Yes.
The resolution dated so and so merely adopted the procedure prescribed earlier. Previous procedure was not to have any minimum marks for interview. Therefore, extending the minimum marks prescribed for written examination to interviews in the selection process is impermissible. We may clarify that prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules and regulating the selection can prescribe by rules the minimum marks for both the written examination interviews or prescribe minimum marks for written examination but not for interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks for interview, it should do so before the commencement of the selection process. If the selection committee prescribe minimum marks only for the written examination before the commencement of selection process, it cannot either during the selection process or after the selection process add an additional requirement that the candidate should also secure minimum marks in the interview. What we have found to be illegal is changing the criteria after completion of the selection process when the entire selection proceeded on basis that there will be no minimum marks for the interview. And thereafter, my lord,
that reference was answered again in the case of this judicial officer.
Yes.
I think Gujarat or Northeast one of
Gujarat, please.
Huh?
Gujarat.
Anyhow, we'll see. Now, so this is in sum and substance.
Please.
So then now you get ready for your reply.
Yes.
I'll fix a date. Examine that latest one. Now,
I'll
there
do
are two things. One, they're saying that this minimum of the psychometric test minimum was not prescribed. Apart from challenging the test itself,
yes,
their second argument is that minimum of the psychometric test was not prescribed.
As on the date. I'll clarify that one. I'll get my instructions also.
So
Any date, I leave it to him. I'll just check on this reference.
Pleadings are anyway complete, my lord, but pleadings are complete. Pleadings are complete.
Correct.
Yeah, but
so this is the only point.
Please. Yes.
So then we'll have it on.
Lords, the other one also, my lords, as your lordships, as I
Yes.
mentioned,
Yes.
without prescribing a cutoff marks in the written test, if written test is the sine qua non for the purpose of participation, my lords, in a selection process, can it be rendered redundant by just saying that 1:5 we are going to select for psychometric test and whoever passes in the psychometric test is going to be selected? That can't happen. Otherwise, it becomes the entire selection process becomes redundant.
Yes.
Please.
Usually at 2:30 we have a CMP list.
Yes.
So we'll take this up after that.
Very well. Any date.
Now the short compass one is as regards the validity of the test as raised by Ravi Shankar, saying that it's vague. Second is the contention that the minimum
Was
in the
prescribed.
psychometric test was prescribed after the
After the-
had commenced.
Those are the two main issues. I'll address both of them.
So relist on 28.
28.
Please, minutes.
At 2:30, madam.
After the
CMP list.
After CMP list. Very well,
Great.
minutes.
Great.
Great.
Good. 37.
Yes, for appear for a petitioner in this case.
Yes.
I need to file an objection in the connected case of 8/9/2024.
They have not filed.
Lord, in the connected writ petition, Lord, he is not a party. I have not sought for any relief, Lord, which is prejudicial to him in my writ petition. Lord, if ultimately, if my Lord were pleased to allow the first writ petition, but then my writ petition will have to be dismissed. Otherwise, Lord, I will get the relief in my writ petition.
So in the first writ petition, pleadings are complete.
In the first writ petition, pleadings are complete.
My case is, my lord, this is second round litigation. Earlier, Lord, my lord, the petitioner was dismissal from service without holding inquiry. In my place, directly appointed the third respondent. So against that, the petitioner approached this honorable court. This honorable court set aside the appointment of the third respondent, appointment of the third respondent, termination of my service, and directed the reinstatement my service. Man. Against that order, the third respondent approached the writ appeal. Writ appeal confirmed. Thereafter, the authority has issued the notice. So what in the earlier termination allegation that I was remaining unauthorized absent. So without that issue, they are called for notice to furnish my details in respect of birth certificate and residence certificate, mass card. Man. Thereafter, my lord, without issuing the subject on that point, so issue pass the termination order without considering my representative the explanation that. So you are submitting the false document at the time of my appointment, my lord, and continue the third respondent. Thereby approach this honorable court. The honorable court to stay the my termination order. So till then, subsequently he approached that. So because of my termination order, continue my service.
Lord, what happened
The second round litigation also without giving any opportunity, and the allegation issue of the testimonials are false and incorrect. They pass the termination order.
Correct. Now, so the state is the appointing authority.
Please, my lord.
So you file your
State, the first writ petition, my lord, already statement
The
of
file.
objection is filed.
Right.
The second writ petition,
No, second is consequential.
Only
If
consequential.
the first he succeeds, then second will automatically go.
Exactly.
Huh?
the lordship may kindly fix another date, my lord, so that.
Relist the matter on. Get ready on by the next date.
Please, my lord.
Relist
November.
on
5th November.
5th.
Very well.
38. Adi Narayan.
This week after next, no representation on behalf of the petitioner.
39 Arjun. 40. Jeevan Kumar PS.
Yes.
Case of respondent number 2 in this case. This is a matter, Your Lordship may recall that about 80.
First matter, bullets.
Yes.
Pleadings is said to be completed. Pleadings has not been completed in both the matters.
Either it's question of law involved in, there are no factual issues. No,
Let them
Section
file that-
17A of approval is what been challenged.
Let them file that they have no objections. So that you,
No, that is your risk. If you don't want objection, then we'll take it up. That's
let
your
them
risk.
file that they have no objections at all. But they cannot rely on some other documents without their being given copies to us.
No, I'll place the entire the approval
they will have
file,
to-
my lord, that they are not entitled to look into those files. I'll place the entire approval file which was sought under section 17A. Your Lordship, I don't have to give the copy to them. That file, my lord, I'm entitled to give it to your lordship. Your Lordship may recall section 19 of the Prevention of Corruption Act. There is a 19(3), my lord, there is a bar on stay, where issue of sanction, irregularity and other things which are raised. Their contention is irregularity in sanction. Assuming that, my lord, even there is an irregularity, question of stay does not arise in this case. Their contention, my lord, they have two grounds. One ground is that their names are not appeared in FIR, which is true, my lord, their names are not appeared in FIR. During the course of investigation, there are series of documents was found where money has been transferred to their relatives. The money belongs to poor people, transferred to the tune of one of the petitioner, my lord, that's 1.21 crores has been transferred to sister of the one of the petitioner. And similarly, my lord, another petitioner also has been played a crucial role. Therefore, my lord, we sought on permission under section 17A to investigate Prevention of Corruption Act matter. That has been challenged here. And
the permission was granted.
Permission was granted. Now, stay is operating on that, my lord.
One more aspect, my lords. Coordinate bench of this FIRs were challenged by the accused in those FIRs. Coordinate bench directed them to proceed with the investigation, file the investigation materials before this court, not to file a charge sheet. Produce all the investigation materials. That matter is listed on 30th of this month. Let them file those investigating materials, my lords. If
No, now we are only on the what is the challenge in the present?
17A order is under challenge.
Issue has been settled by.
Now we will not enter into other issues.
Yes.
That's a matter in your 482 petition, it's pending.
Yes.
Now we are only on the point of sanction. So that you argue will consider.
Plus, pleadings are said to be completed.
So that we'll see if required. Then he says it's their risk. They are going to go ahead without pleadings. Then they cannot take up any factual contentions. Legal, if any, will hear it. It's their risk.
In fact, this entire matter was squarely covered by the coordinate bench. May place the judgment.
So let us see, let them start.
Yes, madam.
The order under challenge in the first petition, my lords, could kindly get it at page number 45.
Yeah. Yes.
If my lords are to kindly see, my lords, the three FIRs which they have relied upon. May I read that prastavane, my lords?
Yes.
ಮೇಲೆ ಓದಲಾದ ಪತ್ರಗಳು ಶ್ರೀಮತಿ ಆರ್ ಲೀಲಾವತಿ, ತಂದೆ ಆರ್ ರಾಮು, ಬೋವಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ಮಾಜಿ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು, ಡಾಕ್ಟರ್ ಬಿ.ಕೆ. ನಾಗರಾಜಪ್ಪ, ಜನರಲ್ ಮ್ಯಾನೇಜರ್, ಪಿ.ಡಿ. ಸುಬ್ಬಪ್ಪ, ಕಚೇರಿ ಅಧ್ಯಕ್ಷರು, ಇತರ ನಿಗಮದ ಸಿಬ್ಬಂದಿಗಳು ಮತ್ತು ಹೊರಗುತ್ತಿಗೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಗಳು ಸೇರಿಕೊಂಡು ಸರ್ಕಾರದ ಬೋವಿ ಜನಾಂಗದ ಬಡ ಜನರಿಗೆ ಉದ್ಯೋಗ ಕಲ್ಪಿಸಿಕೊಡಲು ಬಿಡುಗಡೆಯಾದ ಹಣವನ್ನು ಸ್ವಂತ ಲಾಭಕ್ಕಾಗಿ ಪಡೆಯುವ ಉದ್ದೇಶದಿಂದ ಸರ್ಕಾರದ ನಿಯಮಗಳನ್ನು ಪಾಲಿಸದೆ ಹಣವನ್ನು ತಮ್ಮ ಇಚ್ಛೆಯಿಂದ ಬಿಡುಗಡೆ ಮಾಡಿ ಮಧ್ಯವರ್ತಿಗಳ ಮೂಲಕ ಹಣವನ್ನು ತಮ್ಮ ಸ್ವಂತಕ್ಕೆ ಬಳಸಿಕೊಂಡು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು These three FIRs have been referred to it. ಈ ಮೇಲ್ಕಂಡ ಮೂರು ಪ್ರಕರಣಗಳು ಸಿಐಡಿಗೆ ವಹಿಸಲಾಗಿರ್ತದೆ. ಈ ಪ್ರಮುಖ ಆರೋಪಿ 5/4/21 30/6/22 that is the petitioner, my lords, where I was serving from 5/4/2021 to 36/2022.
Please ask your officials to sit. Let them sit.
ಬೋವಿಯ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ ಆಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಾರೆ. ಇವರ ಅಧಿಕಾರದ ಅವಧಿಯಲ್ಲಿ ಆಗಿರುವ ಸುಮಾರು 80 ಕೋಟಿ ಅವ್ಯವಹಾರದ ಬಗ್ಗೆ ಸತ್ಯಶ್ರೀ ಅಪರ ನಿರ್ದೇಶಕರು ರೀತಿ ವಿವರವಾದ ವರದಿಯನ್ನು ನೀಡಿದ್ದು, ಈ ವರದಿಯಲ್ಲಿ ಆಪಾದಿತ ಅಪರಾಧಿ ಹಣ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿರೋ ಬಗ್ಗೆ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಶ್ರೀಮತಿ ಲೀಲಾವತಿ ಇವರು ನಂತರ ಕರ್ನಾಟಕ ಬೋವಿಯ ಅಭಿವೃದ್ಧಿ ನಿಗಮಕ್ಕೆ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರಾಗಿ ಬಂದು ಟಿ ಯೋಗೇಶ್ ಅವರು ಸಹ ಬಿ.ಕೆ. ನಾಗರಾಜಪ್ಪ ವಿವಾದಿತ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ವಿರುದ್ಧ ತನಿಖಾ ಕಾಲದಲ್ಲಿ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. All this been referred. The next paragraph. ಈ ಪ್ರಕರಣದ ತನಿಖಾ ಕಾಲದಲ್ಲಿ ಮೇಲ್ಕಂಡ ನಡೆಸಿರುವ ಕರ್ತವ್ಯ ಭ್ರಷ್ಟಾಚಾರದ ತಡೆ 1988 ಅಡಿಯಲ್ಲಿ ಸಹ ಅಪರಾಧಿ ಆಗಿರುವುದು ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಈ ತನಿಖೆಯನ್ನು ನಿಯಮಾನುಸಾರ ಕೈಗೊಳ್ಳಬೇಕಾಗಿರುವುದರಿಂದ ಬೋವಿ ನಿಗಮದ ಅಂದಿನ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ ಡಾಕ್ಟರ್ ಬಿ.ಕೆ. ನಾಗರಾಜಪ್ಪ, ಸಹಾಯಕ ನಿರ್ದೇಶಕರು, ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆಗೆ ಇಂದಿನ ಬೋವಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ ಅವರ ಅಧಿಕಾರ ಅವಧಿಯಲ್ಲಿ ಬೋವಿ ನಿಗಮದ ಸಂಬಂಧಿಸಿದಂತೆ ಸುಮಾರು 80 ಕೋಟಿಯಷ್ಟು ಹಣದ ಅವ್ಯವಹಾರದಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಇತರ ಸಾಕ್ಷಿಗಳ ಹೇಳಿಕೆಯನ್ನು ಸದರಿಯವರು ಸಹ ಅವ್ಯವಹಾರದಲ್ಲಿ ಭಾಗಿಯಾಗಿರುವಂತೆ ಕಂಡು ಬರುತ್ತಿರುವುದರಿಂದ ಸದರಿಯವರ ವಿಚಾರಣೆ ತನಿಖೆಯಿಂದ ಅವಿಶ್ಚಿತವಾಗಿರುವುದರಿಂದ ತನಿಖಾಧಿಕಾರಿ ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುವುದರಿಂದ ಇದಕ್ಕಾಗಿ ಕಲಂ 17 ಭ್ರಷ್ಟಾಚಾರ ಕಾಯ್ದೆ 1988 ಅಡಿಯಲ್ಲಿ ಸರ್ಕಾರದ ಅನುಮತಿಯ ಅವಶ್ಯಕತೆ ಇದ್ದು, ಸದರಿ ಅಧಿಕಾರಿಯ ವಿವರಣೆ ಮಾಡಲು ಮತ್ತು ತನಿಖೆ ಮಾಡಲು ಸರ್ಕಾರದ ಅನುಮತಿ ನೀಡುವಂತೆ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಕೋರುತ್ತಾರೆ. ಸರ್ಕಾರದ ಆದೇಶ the permission has been granted for in respect to these three FIRs. May I make a request to kindly take the FIRs which have been produced. FIR's, my lords, page number 29. Whether any complaint was given by the Bowie officer company till the date of sanction, my lords, if I put this question to myself, there was no complaint given by the Bowie till the date of sanction. From if they make an allegation from 2021 till 2024, my lords, till the date of sanction, there was no complaint given by the officers of the Bowie alleging any misappropriation against any other officials. In a complaint given by some individual against the other individuals, my lords, if my lords are to kindly take page number 29.
No, no,
This
the-
is what-
the FIR, who's the complainant, who's the informer for the FIR? You're saying that who's the informer? No?
my lords, this is a FIR filed by one of the person alleging fraud against the other persons. There's no allegations as such against the Bowie Corporation in all these FIRs. If my lords are to kindly take one FIR, my lords. If my lords, page number 31, what is the allegations made there?
Page?
31. This is an FIR, my lords, crime number 7 of 2023, which my lords could kindly get it at serial number 3 in the sanction order.
Yes.
Plus, if the entire FIR at page number 31, my lords,
Yes, read.
there's no allegations against the Bowie officials, against these petitioners. May I read that one, my lords?
No, now they have filed a charge sheet or not yet?
No, not yet.
There's a
That
stay,
is the
huh?
reason, my lords, why coordinate bench said, you investigate, place those materials before this honorable court. Let us see whether there's an allegations. If there is some allegation, we will permit you to file sanction.
Correct. Now to investigate without 17A, can they investigate?
Well, let's let them, I'm not against, let them produce all the investigating
No,
materials.
I'm asking. Now the 482 court has permitted investigation to go on.
All these allegations, my lords, they say that it occurred in 2021, 22, 22, 23. I was only for the brief period of 9 months to 11 months.
From when to when?
My lords, I was there from 5/4/2021. I was posted from 5/4/2021 till 30th of June 2022. If there is an allegations, my lords, from 2020 till 2023, none of the officers who are serving before me, nor who have been posted after me has been made accused in this case.
No, now charge sheet is not yet filed.
Not yet filed.
So we don't know who the accused are.
That is the reason, my lords, why the coordinate bench, my lords, let them place. This matter could be taken in first week of November. If
No,
there
no.
is some materials, my lords,
We are only on 17A. I'm not going to enter into investigation because that will result in overlap with that. Whether 17A is sustainable.
my lords,
your account or
17A,
not,
my
only
lords,
on that day
if section 17A to be read,
good.
there should be some allegations against me in the FIR, my lords. May I read 17A, my lords?
Yes.
Inquiry or investigation of the offenses relatable to recommendations made or decision taken by a public servant in discharge of the official functions of the state duties. No police officer shall conduct any inquiry or investigation into any offenses alleged to have been committed by a public servant under the Act, where the alleged offenses relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous approval in case of person who is or was employed at the time when the offenses was alleged to have committed in connection with affairs of the union of that government. Provided no such approval shall be necessary for cases involving arrest of a person on spot on charges of accepting or attempting to accept any undue advantages for himself for any other offense, any other person, provided further the concerned authority shall convey his decision under this section within a period of 3 months, which may for the reasons to be recorded in writing to such authority by extended for further period of 1 month. if the FIRs which are produced, my lords, which they rely upon, I have no allegations against me. Not even a single iota of evidence in those allegations made against, in those FIRs which were registered in the year 2022.
Yes.
It was not immediate sanction which has been given, then these FIRs. And subsequently, my lords, after this, on October 2024, my lords, a fresh FIR has been registered against these officers under PC Act, which they have not been placed before this honorable court. May pass on this FIR which has been registered under PC Act against these officers. For the first time in the 2024, my lords, on 10/10/2024. A fresh FIR against these officers under the PC Act has been registered.
No, no FIR. It's only a complaint.
No, FIR has been registered.
That's a different FIR.
Same allegations, my lords, they go on registering the FIRs. If may pass on the FIR, my lord. What is the allegations? Which has been registered in October 2024, my lords, and the same allegations. If my lords were to kindly see the sanction order, my lords. Kindly see the complaint which is at page number 18. If this FIR, my lords, if this
Page
18, my lords, copy to the- Page 18, my lords.
Yes.
For the first time in October 2024, the officer of the Bowie Corporation has lodged a complaint saying the same allegation that 2021-22, 22-23, there is a financial audit being conducted, and audit shows that there is some discrepancies. Well, it's pursuant to audit, whether they have conducted any investigation departmentally to substantiate their audit contentions. Plus, strangely, may I make a request to kindly take an FIR which is at page number 8, which is at page number 3, my lords. They say that audit is conducted in October 2024, my lords. In the year 2022, an FIR has been registered saying that all the records of the corporations have been misplaced. And a charge sheet is filed against one single person.
That we'll see, but now we are only on 17A. Whether the
Well,
attack on
in
17
if their allegation, my lords, that in an audit report, if they had come to know that there are some discrepancies in the accounts, my lords, can they take a sanction which has been filed independently by independent official, independent persons, without there being allegations against these petitioners? Charge sheet is filed against one person. That yes, records of 221 cases. If there are no records at all, my lords, the question of conducting an audit, what is the documents which have been relayed? And they could have placed a sanction for this FIR, my lords, not to the FIRs which were registered in 2021-22, where there is no allegations against petitioners or the corporations.
This they have not obtained sanction.
No, this is subsequent to directions given by this honorable court by a coordinate bench. This FIR has been registered. Kindly take, my lords, the strange thing, my lords, if my lords are to kindly take page number 18 as to why this FIR has been registered. Is there any government order to register an FIR, my lords? Ulleka, may I make a request to kindly read the Ulleka, serial number 1. ಗೃಹ ಸಚಿವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭೆಯಲ್ಲಿ ನೀಡಲಾದ ನಿರ್ದೇಶನದಂತೆ serial number 2. ಮಾನ್ಯ ಸರ್ಕಾರದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ಸಮಾಜ ಕಲ್ಯಾಣ ಇವರು ಹತ್ತು ನೀಡಿದ ವಾಟ್ಸಪ್ ಸಂದೇಶ if pursuant to audit, my lords, if officials have been called for an inquiry to substantiate that this is what the inquiry audit report has become, please explain the discrepancies. Nothing has been done, only on a WhatsApp.
This is not even in challenge.
We'll
This is
challenge
not
it.
even
It has
in
been registered on 10/10.
Let us,
Subsequent to direction, first page, my lords, direction given by the coordinate, may I make a request to my lords? The first page, document number 1. 26/9, this direction has been given. Because before my submission would be, before granting a sanction, there should be an iota of evidence being placed. And this iota of evidence will have to be discussed.
let us. Now you appear in,
In my case, my lords, all the 3 FIRs, 1 sanction order. In his case, my lords, 3 different sanction orders. For this, FIRs are one and the same. May I make a request, my lords, before my going to my seniors complaint, my lords, which
yes,
kindly take Annexure C, my lords.
will continue after 3:30.
ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಇವರನ್ನ
What is the urgency?
ಇವರನ್ನ ಏನಾಯ್ತಾರೆ 20/9/2021 ಅಲ್ಲಿ ಒಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತದೆ ಇವರನ್ನ ದ ಸೇಮ್ ವಾಸ್ ಚಾಲೆಂಜ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಇವರನ್ನ ಇದರಲ್ಲಿ ಇವತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಲೀಸ್ಟ್ ಆಗಿದೆ ಇವರನ್ನ ಅಗೈನ್ 8/10/2000 ಇನ್ನೊಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು ಸ್ಟೇ ಇದ್ದಾಗಲೂ ಟ್ರಾನ್ಸ್ಫರ್ ದೇರ್ ಫಾರ್ 2:30 ಇವರನ್ನ
Not 2:30.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇವರನ್ನ
Heavens will not follow it.
ಇವರನ್ನ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಒಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ 20/9/2024 ಆಯ್ತು ಸೊ ಅದು ಸ್ಟೇ ಆಗಿದೆ ಮೀಟ್ ಅಗೈನ್ ಒನ್ ಮೋರ್ ಟ್ರಾನ್ಸ್ಫರ್
Transfer is not a matter of urgency. You look at the latest Supreme Court order, you have to go and report and then only challenge. Look at live law yesterday. We'll have it on Monday. Give memo.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇವಾಗ ಸೀರಿಯಲ್ ನಂಬರ್ 51
Transfer, I'm not going to intervene. There's no urgency. We'll have it on Monday. You must report for duty and come.
ಇವತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಸೇಮ್ ಕೇಸ್ ಒಂದಿದೆ
Let us see. Let us.
ಅದಕ್ಕೋಸ್ಕರ
No, you give it. Let us see. When 51 comes, you make a mention.
Serial number 45.
Huh.
See, mine is 45.1. The 45 not somehow not it is being connected. Not it is nothing to do with the 45. So that way we dealing with that.
Which must be deleted.
45.1 has to be dealing from the 40.
You appear in 45.1.
45.1. Not interim order is there. Yes.
45.1 deleted from 45 at on basis of the mention made by the council for petition and 45.1. Interim order earlier granted is extended till the next day. Relist the matter on date.
With your lordship's kind leave.
ಸರ್ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ
54 ನಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ಬೇಕು ಸರ್
54 ರೀಚ್ ಆಗುತ್ತೆ ಸರ್ ಮಧ್ಯಾಹ್ನ ಇರಿ ವೇಟ್ ಮಾಡಿ
ಆಫ್ಟರ್ 2:30
ಮಧ್ಯಾಹ್ನ 2:30.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು
Lakshmikant, ಇದೀರಾ? Lakshmikant? Lakshmikant? ಇಲ್ಲ, ಬಂದಿಲ್ಲ.
Petitioner.
Pronouncement of order, serial number 1, Lakshmikant.
Accordingly, the petition is allowed, order of detention and its confirmation are set aside forthwith. The decision shall be released forthwith and the order of such release must be communicated to the detaining authority by electronic mode as well.
Grateful.
ಈಗ ನೆಕ್ಸ್ಟ್
VDR.
ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್
List 2.
ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಅಲ್ವಾ?
ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ಇಮಿಡಿಯೇಟ್. ಇಲ್ಲ, ಯಾರು ಮಾತಾಡ್ತಾರೆ?
ಲಿಸ್ಟ್ ಒನ್ ರೆಸ್ಟ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ ಹಾಕ್ತಾ ಇರಲ್ಲ. 230 ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಒನ್ ಮ್ಯಾಟರ್
ಇಲ್ಲ, ಲಿಸ್ಟ್ 2 ಇವಾಗ ಕರಿತೀವಿ, ವೇಟ್ ಮಾಡಿ.
ಇಲ್ಲ, ನಮ್ದು ಲಿಸ್ಟ್ 147
ಲಿಸ್ಟ್ 147, ಲಿಸ್ಟ್ 2 ಆದ್ಮೇಲೆ. ನಂದ ನೋಡು ಹಂಗಾರೆ ಇದು YHM 520 ಬಂತ. ಹೌದಾ? ಧಾರವಾಡ ಬೇರೆ ಚೇಂಜ್ ಇಲ್ಲ, 3421 ಹಾಕು. ಹಾ,
Lordship, list to serial number 44, Your Lordship, for the respondent.
Serial number?
44, Your Lordship. Already informed the petitioners.
Petitioner, my lord.
Just regarding a memo filed by the petitioner lordship, I just need to seek instructions. I have no dispute with the arbitration, only I'll verify the documents, short accommodation.
You have no objection for appointment of.
No dispute with the arbitration clause, your lordship.
Ah.
Certain documents they have produced.
Ah.
I just take instructions and then make my submission.
But what are those documents produced?
There are additional notices and responses, my lord.
Ah,
It's
that's
already,
a-
it's between both of us only.
No, but that is of no consequence.
It's
Both
not of
you
any
agree-
consequence. The arbitration notice is already part of the record. My lord. It's
No,
already,
No, the fact that there's a clause is not in dispute.
no.
Not a dispute.
So do you have any objection for reference?
Lordship, but only the notices I have to verify, because I had initiated the section 21. They have preferred the CMP. I'll just take instructions on the two notices, your lordship, and then I'll submit on the next date.
Notice is only to putting you to notice that there's a clause.
The
Isn't it?
notices were not sent by our office, so I'll just take instructions on the valid contents of the notice.
Relist the matter.
Any short date,
When Monday, Tuesday,
please, your lordship.
in the orders list, mail orders list, admission. We'll dispose of it. It'll be disposed, isn't it? Hopefully next time.
Yes, yes.
Please, your lordship.
List the matter in the orders list on Monday.
Monday, please.
In whichever matters of CMP where both parties don't dispute the arbitration clause, you can move it out of turn and inform the court officer will take.
Your Honor,
Yes,
list to 28,
list two.
28, serial number 28
Ah.
for PF. We give a 1 week's time, we'll furnish the PF.
Just wait, we'll come to that.
6 to 2, non-compliant, first time serial number 1.
Small class 10 has to be included, your lordship. It's the only objection. Not to perpetrate, I will do it.
Petitioners permitted to comply with the office objection. Could have.
Notice also may be ordered simultaneously.
Please to exercise the power under
Petitioner
section
is permitted to comply with the office objection. A petitioner undertakes to comply with the office objection in court today itself and prays that the matter may be taken up for admission and notice issued. Full stop. In light of the undertaking, the matter is taken up for consideration of issuance of notice. Full stop. Now, what is the clause?
Clause 10 of the memorandum of understanding, my lord, page 18, 19, my lord, page 19, my lord, my kindness, page 19. If any dispute arose between the parties, it shall be got resolved through arbitration proceedings as provided under the arbitration. My lord got it.
No, but is it stamped?
My lord,
Stamp. It's only on 2 rupees paper. Stamp.
yes, your lord.
2 rupees paper.
No, this 2 rupees, my lord. There is an agreement of sale also, my lord. Continuation of the sale agreement is agreement of sale is there. And sale deed has been executed. Thereafterwards, memorandum of understanding was entered into between the parties, same parties, your lordship.
Anyhow, I'll issue notice, but
Yes.
Look into this aspect
Yes,
of stamp as well.
yes,
And that latest apex court judgment in NM Global
yes,
regarding stamp, have a look at.
yes. That will. My lord may say emergent notice, your lordship, so that.
No, this MOU is between
Between the petitioner and the respondent number 1 and 2. my lord.
issue notice.
1 and 2 are the husband and wife.
Issue notice. Emergent notice.
Please, your lord. I will do the needful now itself.
Yes.
Non-compliant second time, Serial number 2.
My lords, I appear for the petitioner, my lords. I'm seeking your leave to appear virtually. My lord, the only office objection, my lord, is that the original of the agreement is not produced. My lord, I've submitted a memo. The issue, my lord, is that the original agreement on stamp paper was signed by the respondent and it is in the custody of the respondent. He sent a scanned copy to me, which I countersigned, and it was kept in for my records, my lord. I have submitted that copy which I have, where I have signed, but the stamp. Yes, my lord.
In light of the in light of the response to the office objection that the original agreement is in custody of the respondent, we said office objection is kept in abeyance for the present. Yes.
My lord, matter may be taken up for notice. My lord, the arbitration clause is contained in the sale agreement, my lord, at page 23 of my application, my lord. My lord has page 23, my lord.
Yes.
My lords, on the left-hand side, my lord, clause number 10, dispute resolution.
Yes.
Any claims, disputes, or differences arising out of or in connection with this agreement, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration by a sole arbitrator to be mutually appointed by both parties. In accordance with the provisions of the Arbitration and Conciliation Act 1996, the arbitration proceedings shall be conducted as per the provisions of the.
So now the parties to the agreement have been arrayed. Who are the parties to the agreement?
My lord, the petitioner and the respondent, my lord. My lord will find that on the my lord, on page 18, my lord, which has the stamp paper. And just under that, my lord, Ball Beverage Packaging, that is me, my lord, I am the petitioner, and customer is Amara Breweries, that is the respondent.
The dispute is relating to?
My lord, dispute relates to non-payment of dues, my lords. The agreement was for, my lords, I manufacture beverage cans, which are used for packaging various beverages.
You have sent a notice.
I have sent a notice, my lord. The arbitration notice, my lord, I have sent 2-3 legal notices. The last arbitration notice, my lord, dated 1/11/23, my lords will find at page 35, annexure F.
Then acknowledgement.
My lords, received, yes, my lord. Reply, my lord, dated 30/11/23 is at annexure G, page 39. They do not dispute the liability. They only seek time to make payment. Page 39 is their reply, my lord.
Notice to the respondent. Any other mode of service?
My lord, I may be permitted to take out hand service, my lord.
Petitioners permitted to take out notice by hand summons as well on the respondent. Yes.
I'm grateful, my lord.
You can also serve the counsel in case the counsel was made out reply.
Yes, my lord. My lord, the reply came directly from the company, unfortunately.
Yes.
So
next.
Grateful, my lord.
Non-compliance, third time. Serial number 3 to 17.
Just 2 weeks. Just 2 weeks. 2 weeks time granted.
Kindly pass over the man.
Just wait. 2 weeks time granted for necessary compliance. Which matter?
See, serial number 3, my lord. For the petitioner in this case, my lord. Senior is held in other court, my lord. Kindly pass over, my lord.
Pass over 3.
Please, my lord.
Apologies, my lord. Serial number 8.
8.
Yes, my lords. I appear for the petitioner. In fact, all the office objections have been complied except the first office objection, my lords, which the office note clearly states.
Just wait.
Please, my lords.
What does the office note state?
That the respondent number 2 and 3 are the directors of respondent number 1. As to why respondent number 2 and 3 are made parties to the present petition when the invoice does not even have their names, my lord.
This is the only office objection.
That's the only office objection. That may be kindly be overruled by.
In light of the submission made by counsel in response to the office objection raised, the office objection is overruled. Tell me.
Please, my lords. Also, my lords, may kindly peruse ink page number 19. These are the invoices, my lords, where the arbitration clause has been mentioned at clause number 9. Ink page number 19, my lords, 19. Clause number 9, my lords, arbitration. 9.2 to be precise, my lords. 9.2.
Where do you find? Page 18.
Page 19, my lords, 19. Just behind the invoice. Yes, my lords. 9.2.
So this itself is arbitration clause.
Yes, my lords.
Now this is an invoice.
These are the invoices, my lords, being raised by the petitioner.
They have acknowledged.
Yes, my lords. They've acknowledged and they've also paid in part with respect to the same.
This is sufficient.
Yes, my lords. And there's a notice also being issued, my lords, at ink page number 24 at annexure E.
Page?
Ink page number 24, my lords. 24.
24 is another invoice only.
Apologies, my lords. Apologies. Humble apologies with respect to non-numbering of the same with respect to my record and the court's record, my lords.
1,000 apologies.
Please, my lords. Maybe a million as well, my lords.
Which page now?
That is at annexure E. This is the notice issued, my lords.
You have issued it to the respondent.
Yes, my lords.
This is served.
Yes, my lords.
Where
The
do you have
postal acknowledgement as well as receipt has been annexed
on
in
all
the subsequent pages.
All the three.
Yes, my lords.
1 and 2 is there.
Please, my lords.
And then page 43 for R1 and R2.
Yes, my lords.
R3.
R3 again is a director, my lords.
That is 44, is it?
Yes, my lords.
Huh?
Please.
Tracking report.
Tracking report.
That is for R3.
Yes, my lords.
Issue notice. Any other mode of service?
By hand, my lords.
Petitioner is at liberty to take out notice
Or
via hand as well. Apart from taking out notice by electronic mode.
Please, my lords.
Relist on 30th.
Much obliged. And again, apologies, my lords.
Yes.
Serial number 14. I have complied all the office objection on 20th June itself.
No, there are some more.
In fact, as on 20th June, I had complied all the office objections.
Second installment.
Perhaps it might have been raised after the
Second
compliance.
installment.
Please, the short date making.
You comply and then you move it.
Please, I'll do. I should.
Yes.
Non-compliance, fourth time, serial number 18 to 21. 18 to 21.
Serial number 19 and 20, a week's time, my lords, I'll comply.
19 and 20 weeks time granted for necessary compliance. Relist on
24.
Grateful.
18. 21.
24. Furnishing PF matters, serial number 22. Serial number 22 to 31. 22 to 31.
Serial number 26.
No, I think one by one. Yeah, one below, common. Yes.
Serial number 26 minutes. I have a submission in this. In this, my lords, the R1 and R2 my lords have subleased the property to the respondent number 3 my lords. And on the last occasion, my lords, the notice has been returned as addressee left without instructions. And my lords, presently the R3 is squatting over the property. ಇದೇ ತರ ಸುಮಾರು ಜನಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Correct.
R1 and R2.
So you will have to do it third time, isn't it?
Yes, my lords.
So you take once more, after that we will immediately order for paper publication.
Yes, please.
No, seal number 25.
Just a minute. Week's time granted to do the needful.
And in respect of office objections, my lord, they have asked that why the R3 is made as party, my lords. Since it is subleased to the R3, R3 is also bound by the original agreement. That is my submission. I've also written the submission, my lords, but it was not overruled, and therefore that has also come up.
The office objection at serial number 2, at serial number 7 is kept in abeyance. Yes, release the matter on 30th. Take out immediately.
Yes, emergent notice.
Yes, emergent notice.
Serial number 25.
Registry.
Appear for the applicants, you know.
Just one. Registry to put up postal tracking report on the next date of posting. Serial number 20.
25.
31.
25.
Sorry.
Yes.
You know, seal number 25. Appear for the applicants, you know. Week's time may be granted to pay the PF, you know.
Week's time to do the needful. Yes.
Obliged.
31 malots. In this malots, the respondents, subsequent to me issuing section 21 notice, they have filed an OS malots. I may be permitted to serve the counsel appearing.
To do the needful, the petitioner is permitted to serve counsel appearing for the respondents in
OS 2816 of 24.
2816 of 24.
Please.
Relist the matter on. Yes.
First, it's serial number 36.
Serial number, no, wait, till 31. Yes.
28, Your Honor, serial number 28. Shara came back as wrong address. 1 week's time may be granted to.
Week's time granted to do the needful.
Thank you.
Serial number 30. In this, the acknowledgement has been returned stating that the addressee has left without instructions, which is considered as deemed service under 27 of. I may be permitted to file necessary application for substituted services, my lords. The respondents have several criminal cases pending against them. They're actively.
Correct. You're saying deemed service under which rule?
27 under General Clauses Act. Deemed service. Addressee has left without instructions without providing the forwarding address, my lords. And they're constantly absconding because they have several.
Correct. You finish the 3 times, then we'll do back to back. We'll give short dates, then we'll do substituted service and there ends the matter.
Yes, ma'am. Much obliged.
Time to do the needful.
It may be reissued against R1 to R3.
Orders matter.
Serial number 23, my lords.
Yes.
My lords, connected matter was listed yesterday as well. The developer is absconding in this matter. If I may be permitted to serve them via e-summons, and I'll take out back-to-back summons as well, my lords.
23. Weeks
23
time granted to do the needful.
My lords, if
petitioners at liberty also to take out a notice. You want the registry to take out or you will take it out?
I'll take it.
Take out notice by way of email as well. Yes. To the email to which communications were last made.
My lords, observation if it could be made to the partners all of the developer company as well. Because as of right now, the email IDs that we have, not all of them may be active, but as per the MCA website, Ministry of Corporate Affairs website, one of the partners, their email is listed there. If I may be permitted to serve them via email.
File a memo.
Very well.
The petitioner, full stop. The petitioner is at liberty to take out notice that by way of email to the partners of the respondent entity as well. Details of which are furnished in the memo.
My lords, one last submission. It's not a connected matter, but it's a related matter, my lords. Same developer, different property is listed on 25th. If this may be also listed on the 25th.
We list on
25th of October.
25th.
Grateful, grateful.
Serial number 27. R1 is already represented, my lords. In the section 9 proceedings, R1 is represented by the same counsel who's appearing before this honorable court as well. I may be
Hello.
permitted to serve
Serial-
notice.
Serial number 27.1, my lord, I appear for the respondent number 1, my lord. My lords, in the first matter, my lord, we are yet to be served with a copy of the papers, my lord.
You accept notice, we will ask
I
her to-
accept notice, my lord. I undertake to file wakalat, my lord.
Yes. Lord Counsel, so and so. Undertakes to Pradeep S. Saukar, Kundasamy and Ramdas undertake to file wakalat for R1 in serial number for the respondent in serial number 27.
Yes, my lord.
Petitioner to serve copies forthwith. This is the
My
matter.
lords,
This is the matter for admission on.
Any day.
my lords, 3 weeks time may be granted to file my objections, my lord. Court commissioners have been appointed in the section 9 petition, my lord. The survey
That
is
may
yet to
not
be.
have relevance, my lords. They have themselves admitted in their reply notice stating that you've initiated arbitration in the connected matter, let all the disputes be resolved together.
Let us see, you make the submission. We'll have a date next week. You make a submission
Yes,
on
ma'am.
that date. List the matter on 24.
Much obliged.
Serial number 29. Serial number 29, my lord. I'll take notice as a trial court advocate, K.R. Pradeep, my lord.
In OS?
OS number.
OS or AA?
Serial number 29.
No, what is the proceeding pending before the trial?
It's actually earlier, my lord.
AA or OS?
OS, my lord. Earlier injunction suit filed, my lord. Suit has been dismissed due of this arbitration clause. It's a trial court advocate, K.R. Pradeep is there, my lord. Take notice to Pradeep.
Week's time granted to do the needful. Petitioners at liberty to take out notice.
Our
counsel who appeared in the original suit, previous original suit proceedings as well.
Yes, R1 to R5 minutes.
But if he comes well and good, otherwise you take out simultaneously.
Both I'll take.
Just wait.
Orders. Serial number 32.
Your lordship, appearing for the petitioner in this matter, your lordship.
Yes.
Your lordship, is regarding the service to respondent number 4. We've taken several, we have also taken process thrice, your lordship. It may be had next week. Senior wanted to make submissions regarding the service to respondent number 4 in this matter, your lordship.
You make a through substituted service, you take out, there ends the matter.
Your lordship, we have attempted to take substituted service and it has come unreturned, your lordship. It may be had next week. I will I may be permitted to serve the respondent number 4 through email, your lordship.
No, that will permit. You take out substituted service by advertisement as well. The petitioner is permitted to take out notice by email to the respondent, which would be in addition to necessary steps to be taken by way of substituted service. Relist on. Next.
Let's
33.
Yes.
33. Mahesh
Time granted to do the needful.
34. 34.
No representation on behalf of the petitioner. Relist the matter on.
30. 35.
Yes.
Filed a memo of calculation in pursuance to the judgment of the Honor Apex Court. Now it has been diluted.
So what is the procedure to be followed?
But whether the stamp duty is paid is correct or not. I have filed a memo of calculation, but it is a bond millet according to section 21A. 100 rupees is paid on the agreement. That is correct what is stated. That memo of calculation will have to be accepted and provided if it is wrong, there are other side is may point out. That is usually the orders is passed.
But what is that?
Agreement, agreement of construction.
That NM Global, isn't it?
Yes, yes.
What does it say?
It says memo of calculation.
And
it has to be placed before the court to verify whether it is correct or not. According to me, I filed a memo of calculation that it is a bond as per section 2(1)(a), the stamp duty paid is correct.
I'll have it on Monday. Just get that judgment. Let's have it.
I-
List the matter on Monday,
Last may post it in the admission list itself.
in the admission list.
Yes.
Yes.
36. Lordship.
My lords, serial number 35 will be filing the objections. My lord.
Objections filed, taken on record. So what is your stand? It's not properly stamped.
ಅಲ್ಲ ಅವ್ರು ಸ್ಟಾಂಪ್ ಬಗ್ಗೆ ಇಲ್ಲ ಅವರು whether it has to be arbitrator has to be appointed or not. ಅವರು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿ.
Then we'll take it up for
I
admission.
will point out that.
Yes.
36.
36, Lordship. In this case, there are 3 respondents. I have filed an application for substitution service. Respondent number 3 is served. His name has been mentioned. Respondent number 2 is the same respondent number 3 is managing director of respondent number 2 company. Therefore, respondent number 2 notice may be held sufficient. As far as respondent number 1 is concerned, she is my sister. That I may be permitted to take steps through email and WhatsApp, Lordship. And office objection raised it. I have not taken steps through court and RPID 2 times. That's why substitution application is objection they have raised.
No, one by one. Now, first is for R1, want to take by substituted service.
Substitution service, but office has raised an
No,
objection.
correct. That's you cannot unless you finish 3 times.
Yes, Lord. I will text notice. She is my sister. Email and also email, WhatsApp, and also through
R2.
email.
R2.
R1. R1 sister.
Issue notice to R1, petitioners permitted to take out notice by way of email as well.
Email, WhatsApp, and also through court.
And
RBI.
through other electronic mode. And stuff. What about 2?
2 is Tariq Ahmad is managing director. He is also respondent number 3. His respondent number 3 is served. Therefore, he is a managing director of respondent number 2.
No, but 2 is on the entity.
He is a entity, Lord, represented by managing director, who is respondent number 3, Tariq.
Let us see, but now you, for the time being, you take out. By the next date, let us.
Yes.
Urgent notice to respondent number 2 as well. Now, what are the other office objections you comply?
I will comply. I will comply.
Other
As far
office
as the
objections?
substitution service, let it be kept in abeyance.
Other office objections to be complied with, IA 1 of 24 is kept in abeyance for the present. Relist the matter on. Yes.
Lordship, through email and also to respondent number 2 also.
Yes.
I'm sorry, my lord. I'm sorry to make a mention.
More.
Sorry, 35, your lordships have said that Monday, and I have got some difficulties. Now I recollect. Any next date of the CMP day listing? Any other? Yavaglo? Very good. I'm sorry.
37.
37, my lord, this matter some urgency, my lord, this case, my lord, the respondent unilaterally appointed an advocate as an arbitrator, my lord, without approaching this honorable court, and the arbitration proceedings is going on. Notice was issued, my lord, it was not served. Second time, my lord, I issued note, it is awaited, and also permitted to serve the counsel representing before the arbitrator. My lord, she is refusing to accept the.
No, but now they've already appointed yourself.
No, my lord, they unilaterally appointed themselves without approaching this honorable court. My lord, similar matter, my lord, was stayed by this honorable court. My lord, just present the copy, my lord.
What is it?
No, my lord,
What is the procedure now in case of such?
My lord, such case, my lord, that has to be nullified by this honorable court, my lord. The unilateral appointment itself was questioned, and that matter, my lord, there was a stay, and subsequently, my lord, that was quashed by this honorable court with this petition. The next page in the order sheet, my lord. The next page, which is without consensus, my lord. And there was a stay, and subsequently, the my lord, that was quashed by this honorable court with the judgment. Paragraph 12, my lord, is the reasons. Page 11, 12. Page 11, my lord, paragraph 12.
Please.
Yes.
It is trite law that the appointment of sole arbitrator unilaterally by one of the parties to the dispute would be rendered a nullity in the light of the mandate of the statute and its interpretation by the apex court in plethora of cases. Therefore, the arbitrator has to be appointed on consensus. Such a situation that has emerged has been dealt with by the High Court of Delhi in so and so case. And my lord, ultimately the unilaterally appointed, my lord, the arbitrator was nullified at page 19. There has to be consensus, my lord.
Now you have sought for stay of this or how?
Stay of the proceedings before the learned arbitrator, because my lord, they keeping the matter day to day, and tomorrow my lord, it is posted for passing interim order.
No, but now
Please.
under 11.6 can we pass such an order?
Please, my lord, that judgment which lordship has took, my lord, it is also filed on 11.6 only. Second page, my lord, lordship may kindly.
That
The
could-
petition is filed on 11.6 and 11.5 and 6, my lord. And the reliefs are, my lord,
That is the second relief.
please, my lord.
Huh?
Please, my lord, second relief, my lord, is none.
But have you sought for that in this?
Please, my lord, I sought that, my lord, I questioned the same.
Your question.
Please, my lord, my prayer is to nullify the arbitrator unilaterally appointed and appoint him, my lord, the sole, that neutral arbitrator, by the way. And that is an advocate, my lord, has been appointed. 11.6 and 12 and 14, my lord, these are the grounds to challenge.
The petitioner has filed IA 2 of 24, seeking stay of further proceedings pursuant to the letter at annexure E. Counsel for the petitioner submits that the respondent has resorted to unilateral appointment of the sole arbitrator. Reference is made. Where's the letter?
Lord, their arbitration letter, my lord, at annexure C, page number 37. They don't even name the arbitrator. My lord. 37 is the
made
arbitration notice.
to the letter enclosed at annexure C, and it is further submitted that
This notice is not served on us.
no, but where is the appointment? No?
Lord, the appointment is annexure E, my lord. They themselves go and request the and annexure E, my lord, page number 43. Is the advocate, my lord, issues a notice.
Just one.
Please.
Annexure E, and it is submitted that the arbitrator at annexure E who has issued the letter was not an arbitrator appointed by consent of both parties.
Please, or by this honorable.
Reference is made to the order in Manish Chibbar versus Anil Sharma and another 2020 SCC online Delhi 1731, as well as order passed in CMP 343 of 2021. And it is submitted that the proceedings pursuant to the letter at annexure C and E are required to be stayed pending further consideration. Please stop. Taking note of the submission made that the arbitrator who has acted in terms of annexure E is an arbitrator unilaterally appointed by the respondent. And in light of the present petition having been filed, it is necessary to stay the proceedings pursuant to Annexure E for the present.
Please,
So now you have to take out notice.
I already took minutes and avoid money.
Office to put up report regarding notice issued to the respondents.
6 to 8.
6 to
8 money.
8. Relist on.
Please,
Yes.
please, deeply obliged.
Admission 38. Number one, Ravi.
Yes.
Except for appointment of arbitrator, my lord. The dispute is landlord and tenant dispute. They issue the terminated notice, they have not been respond. As per Annexure B, notice was issued. It was duly served to the respondent, but he never come forward to either vacate or appointment of arbitrator to resolve the dispute as per the class number 6 of the lease agreement. It is available in page number 20 up.
So notice is held sufficient. Notice is held sufficient.
Sufficient.
You are the lessor.
Or lessor, I am the lessor.
Now he is not paying the rent, or what is the dispute?
Not paying the rent, and as well as after a lapse of period, lease period, you have issued the evicted notice and demanded the due rent and as well as evict. Otherwise, he initiated the arbitration proceedings.
Where is the clause page?
Yeah, page number 20, my. Page number 20, class number 6 of the arbitration.
You have sent notice. You have sent notice.
Send the notice Annexure B, man. Page number 26 is the bottom line. 6 months from the date of receipt of this notice, failing which I hold is instruction from my client to file a suit for ejectment or arbitration case as against you from the scheduled premises without.
Now this has been served.
Serve, my.
Where is the service?
Serve, and is R2 is one of the R2. Later on, it was deleted. He has given the reply as per Annexure C.
No. R1 is Aircel.
R1, it was served, but it was not given any reply or.
Where is this proof of service?
But acknowledgement was not produced, madam, but in my file is.
File it with the memo. Put it. But it is not served.
It was sent in correct address. And R2 is a agent.
Who is deleted?
Later he deleted, my lord, but he is not a party to the lease agreement because, but anyhow, the R2 was giving the rent.
You have to, now how can you get over this?
Moreover, this repetition also I have taken the paper publication, my lord. They have not come forward.
No, but there's no service only of your arbitration.
But he has not been responding in this.
No, but there must be service of notice.
Because postal notice was sent to correct address to the R1. It may be considered as a due, sir.
How can we consider it?
That postal article was sent to correct address.
Otherwise you send it, I'll keep it pending, send it once again, let us. Then I'll take note of both. You send it.
Send it, man.
Send it once again.
Watch up.
I'll keep the petition pending.
Watch up.
Then you produce this along with that, let us.
Watch up.
List after 2 weeks. Would वापस करेंगे.
39.
For the petitioner.
Yes.
No, the dispute is with regard to implementation of certain coal handling plants in, my lord, in this particular matter, there is a likelihood of settlement. I was informed yesterday that 75% of amount was paid. Kindly, it may be posted after 2 weeks, my lord. If it is there, then I will file it a memo for
List at request of the petitioner on 2 weeks submitted.
Yeah.
Next one, same.
No, no, my lord. In this, there is no settlement. Settlement is not happening. In fact, we had issued a notice to them also. It was also served to them. I have produced the acknowledgement for having served the arbitration notice at page 151.
Where is the agreement first?
Pardon?
Where is the agreement containing the clause?
My lord, Annexure A, at page 64 is the arbitration clause, my lord.
Annexure?
Annexure A, page 64, clause 32. Arbitration clause, clause number 32.
My lords, if may be permitted, I'm instructed to appear on this matter as a respondent. Just been informed by the client. May be given 2 weeks time to file the vakalat, my lord. We are informed even settlement discussions are ongoing in this matter as well. A request for 2 weeks time, my lords. We'll file a vakalat in the meantime and report settlement if anything.
Learned Council. Priya Kale.
My lords, I put my name in the chat box, my lords.
Yes, you know, chat box. So and so undertakes to file wakalat for the respondent. Relist the matter. Week after next, I'll give a date.
Sure, my lords.
5th of November. Next.
41. 41. Homer.
Appearing for the petitioner in this case, your lordship.
42. Varsha.
41. Your lordship.
Yes. Yes.
May I? Your lordship, this is the dispute arising out of 2 purchase contracts between a petitioner and the respondent, your lordship. Now, both the purchase contracts are in Annexure B, page 24 and 25, your lordship. Page 24 and 25, where there's an arbitration clause in the purchase contracts, your lordship.
Now, this is not required to be stamped.
No, your lordship. It's duly signed by both the parties.
No,
your
no, is it required to be stamped?
No, your lordship, it's not required.
Just check.
Yes, your lordship.
Because now there's nobody on the other side. So before I proceed on this basis,
Yes, your lordship.
make a submission whether this annexure B requires to be stamped or not.
It is.
Examine
Yes, your lordship.
and you come back.
Yes, sir.
So now, since they are not there, then we have to take note of this and appoint. So you have issued your notice.
Yes, your lordship. Notice has been duly issued.
It is in page number 43 to 49, your lordships, notice invoking arbitration. And it is returned with an endorsement, addressee refused, your lordships. It's in page number 52. The endorsement.
Do you have an original of this?
Yes, your lordships. We are saving it for the arbitration, your lordships.
You bring it on the next date.
Yes, your
I'll give it back.
Yes, your lordship.
Relist on. Tuesday, Wednesday, when do you want?
Shorter date may be accommodated.
23rd.
Yes, sir. Great.
Just examine that one point.
Yes, sir.
42.
For the petitioner, my lord.
Yes.
The matter, commercial appeal 263 of 24 is reserved for judgment, my lord.
Please.
So kindly adjourn the matter.
So you have already approached the
Because they have filed a section 8 application that got dismissed.
Section 8.
Yes, my lord, that got dismissed and challenged before the division bench. It has already heard the matter. It's reserved for judgment on 28th of August. Because can this matter, since they have already seized of the matter, this matter cannot be.
Relist.
It's a longer date if possible.
After 2 weeks or 3 weeks.
4 weeks at least, my lord.
After 4 weeks. At request. Relist on.
28th now.
Please. Grateful.
43.
There's a possibility of a settlement going on between parties, so it will be taken up.
Relist at request on both sides on. After
2 weeks, my lord. 2-3 weeks. 2 or 3 weeks.
3 weeks. 6th of November.
Please.
Next.
44 again, 45. 45.
For the response, I'm in 2 weeks' time to file a counter affidavit to this. Lord, last occasion itself, they have taken time. I have to take instruction from few of the respondents, man. It's 2 weeks' time.
So agreement of sale, my lord, admittedly arbitration classes, their notice was served, no reply.
Let us see last time as a last chance. Objection at request of respondent. Relist on 2 weeks argument. 5th, no further adjournment.
Please.
46.
Same.
Same.
Please. Great.
7. 47 Santosh.
Is there no standing counsel for this?
My lord,
Managing Director, Karnataka Road Development Corporation.
that's what, my lord, it has been served, but there's no representation from the respondents.
Just find out if there's any standing counsel.
Standing counsel.
There is.
Find out and inform the court.
So and so. I'll just pass over later. I'll pass over, you find out. There must be a standing counsel for that. Pass over. Next.
48.
Yes, it is for appointment of arbitrator, annexure A series to the laws 16 and 17 of the.
Who is R1?
R1 is the president of the society. Who has taken the decisions of the entire committee.
Okay.
So R2 is the secretary. He is only the executor.
What has happened to notice to R1?
No, which was served.
R1 no serve ಆಗಿದೆ.
R2 ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. Secretary of the society.
R2 ಹೆಸರು
ಜಗದೀಶ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಕೌನ್ಸಿಲ್ ಹೆಸರು
ದೇವರಾಜ್, ಸಾರಿ ದೇವರಾಜ್.
ದೇವರಾಜ್ಗೆ
one opportunity will give. If he doesn't come next day, I'll proceed.
So next week any date. Because old matter.
No representation.
So
New
you are
matter. New matter.
My notice is also served.
Yes.
So they are not
representation
replied.
On behalf of R2. It's made clear that if R2 does remains absent by the next date, court would be constrained to proceed passing of orders. Relist the matter on 29.
Yes, sir.
Yes.
49.
My lord, serial number 49, my lord, I appear for the respondent, my lord.
Yes.
I may be permitted to file my objections, my lord.
Statement of objections filed is taken on record. Relist the matter on. Wait. Yes.
50.
Please, oblige me.
My lords, I appear for the petitioner. This is a section 11 application, my lords, for appointment, seeking appointment of an arbitrator. My lords, this dispute arises out of a sublease agreement, my lords. We have placed a registered agreement, my lords. Stamp duty has been paid in that. Because it's a long-term lease, my lords, so the lease deed has been registered and stamped. My lords, the lease deed is at page number 32. The parties to the lease deed again, my lords, are at page number 32. Confido states, which is respondent number 1. And the landowners, which are serial number 1 to 4, are the confirming parties to the lease deed. If my lords may kindly have page number 33, it shows the registration details. Page number 40, my lords, shows the stamp duty and everything has been paid. So, my lord, this is a duly registered agreement, my lords. The dispute is regarding the termination of the lease deed, my lords, because the land which we had taken was acquired by the Bangalore Metro. So the petrol pump, my lords, had to be shut down. And we sought refund of the security deposit, my lords. So the dispute is qua the refund of the security deposit.
You have issued notice.
Yes, my lords. My lords, the notice is that, my lord.
The arbitration clause at page.
Yes, my lords, arbitration clause, it is clause number 24, is at page number 58, my lords. It says laws applicable and dispute resolution, clause number B. Any dispute between the parties arising out of this deed will be referred to arbitration as per Arbitration Conciliation Act. Venue will be Bangalore. And because the situs is at Bangalore, my lords, the seat will also be at Bangalore. That's why, my lords, we have approached this Honorable High Court. The notice invoking arbitration, my lords, is at page number, my lords, 121, which is 11th October 2023, my lords. We have issued the notice invoking arbitration. We have received responses from respondent number 2 to 5. Surprisingly, my lords, the original sub-lessee, respondent number 1, they have not responded to our arbitration.
But you have served.
It has been served.
Now reply is at annexure.
My lords, reply is at annexure K.
That is 2 to 5.
126. Yes, my lords.
What about 1?
1 has not responded, my lords.
Where is the service?
My lords, this is actually an old notice, my lords. So I am only seeking this indulgence. We don't have the service receipt. But, my lords, what my submission is that in case we have filed the section 11, that itself, my lords, can be sought or can be deemed to be commencement or arbitration, my lords. In any case, my lords, the respondent number 2 to 5, which are the confirming parties, they have already responded. They have disputed our arbitration, saying that you have not vacated the land premises. And this is happening, my lords, because there was an acquisition which was done. So it's a public knowledge.
Correct. I'm only on the point. What has happened to R1 notice?
My lords, my lords, I submit, my lords, that R1 notice, the delivery receipt, my lords, we were not able to locate.
Okay, you issue now.
My lords.
I'll issue notice to the
lords, we'll issue
parties. You issue one more.
We'll do that.
And then you see if you can make out a case.
Sure.
That though the notice is issued subsequently,
my lords,
it could still be made good.
I'll be grateful, my lords. I'll be grateful. In fact, my lords may also allow me to serve by hand by other modes as well. The notice, the court notice, so that, my lords, we will issue the notice again to them, and also the court notice can also be sent to them.
Issue notice to the respondents. Petitioners with liberty to take out notice by way of hand summons as well. Now, in so far as that notice to 1,
Milos will again issue.
What is the legal position? You'll have to say.
Milos will do that.
You can do it and then say it would stand good if the acknowledgement to the first was lost.
No worries. Milos, in fact, Section 21 of Arbitration Conciliation Act says that arbitration is deemed to be commenced when you invoke the arbitration. Now, my lords, there have been various other notices, not just October 23 notice. There have been various other communications which has been sent.
R1.
Absolutely, my lords.
Reference to arbitration.
Yes, my lords. We have stated in that we will take appropriate legal measures. Of course, I have to check, my lords, whether we have used the word arbitration or dispute resolution. But the moment, my lords, we say that we will invoke appropriate legal remedies. According to me, my lords, that is sufficient for the purpose of arbitration. Because in any case, my lords,
So you produce that then?
I'll do that, my lords. I'll do it. In fact, those who hasn't produced, I'll appropriately address that, my lords, whenever that situation arises. Grateful.
Relist on.
51. SK. 51.
No representation on behalf of the petitioner, relist the matter on.
52. 52. Charanjit.
Yes.
For petitioner, my lord. This is the case of invoking of arbitrator, sole arbitrator. The matter is pertaining to the rents, arrears of rent, which the respondent has not paid. And there was a particular clause regarding this, my lordship. In case of any dispute regarding the arrears or whatever it is, there shall be a sole arbitrator appointed.
When was the notice issued?
Yes, my lordship. Invoking of notice, it is 5/4/24. 5/4/24, my lord.
Page?
1 second. My lordship, page 37.
Now the respondent is the tenant.
Yes, my lordship.
Now it has been served.
Yes, my lordship.
Page?
Sorry, my lordship.
Service, evidence of service.
I guess page 34, my lordship.
Page?
34. 34 and 33 are the acknowledgements.
No, the notice is at annexure H, is it?
Sorry, my lordship.
Notice is at annexure H.
Annexure, yes, my lordship.
And the acknowledgement is at annexure E.
42, sorry, my 42, J, K. We have sent through various means, my lordship, through private DHL and through postal receipts.
L also.
Yes, my lordship, L and M. M is the final thing. It has been delivered.
Item delivered.
Yes, my lordship.
They have replied.
Yes, my lordship. Annexure N.
N.
N, my lordship.
Do they refer?
Page number 46.
46,
my lordship. They have replied to the notice. 15/4/24, my lordship.
Page?
46, my lordship.
No, 46 is the reply.
Yes, my lordship.
Do they say anything about your invocation of arbitration?
That is in the agreement, my lordship. Page 20.
Correct. I'm saying in the reply.
They are disputing in that part. They are telling the vague reply, you have not registered the document. So first register the document, then come to the court, then give us a notice.
They've raised a dispute regarding the stamping.
Yes, my lordship.
So what is the stamp?
My lordship, I have paid the stamp fees and I have come now.
You have paid?
Yes, my lordship, it has been done.
Just show me.
Page number 17, my lordship. Page 17.
It has been paid. Now, appointment of the person named.
Yes, my lordship.
Huh? Or somebody else. You want the person named.
Okay, my lord. Anyone.
No, it's up to you.
Named, my lordship.
Named. He's a retired district judge.
Yes, my lordship.
No, but he has disagreed for that. We'll appoint another retired district judge only from the panel.
He's in the panel list, my lordship.
He's there.
Yes, my lordship.
The petitioner. It's not for appointment. Of an arbitrator to adjudicate the disputes between the petitioner and respondent in terms of clause 13 of the agreement between the petitioner, who is the landlady, and the respondent, who is stated to be the lessee, the land lessor, and the respondent is the lessee. The lease agreement at annexure A, the rental agreement at annexure A is stamped. Insta. But this is not a registered agreement.
Earlier, it was not a registered document. Now it has been.
No, you only stamped it. It's
Yes,
not-
ma'am.
What about registration? Now whether, just examine what's the legal position, whether it can be looked into for collateral purpose. If it's not registered, examine it, I'll have it next week. Relist the matter on 24th. Examine that point.
Yes, ma'am.
If it's not registered, whether under 48 for collateral purpose, we can look into the arbitration clause or just examine it.
Macho.
Page number 54, Kavita D.
Serial number 54 appears with the petitioner, Your Lordship.
My lord, today morning I have filed the wakalat in the counter for the respondent. And we have got serious objection for appointment of.
To file it.
Yeah.
Let him file their
Third
objection.
counsel so and so undertakes to file wakalat for the respondent. Objections to be filed by the
Before.
next date. Relist the matter on
First week of November.
the 5th.
Passover matter, serial number 3. Vinita.
Lordship, in the,
Yes,
Lordship, in the first round, your Lordship, it filed as CMT petition where only because the name of the arbitrator was not mentioned in that petition was withdrawn. And there is an order, your Lordship, at page number 30, where it was.
what is the office of?
Now, office objection that I'm coming to that, your Lordship, the stamp duty, that has to be. In fact, your Lordship, that is in the first round, the objection was not raised. And these are ex-servicemen where they have invested their,
So correct, but now
Correct.
for that,
correct,
just have a look at the order passed in NM Global. Have a look at NM Global.
yes,
Larger bench has resolved that issue of stamping of arbitration. Come back, I'll have it next.
please, your Lordship,
Relist the matter on 24th.
please.
47. Santosh.
Petitioner, my lords.
Lord,
I'm told that Mr. Vijay Kumar Bhajantri is appearing for the KRDC. Vijay Kumar Bhajantri. Bhajantri Associates.
Land Council Sri Vijay Kumar Bhajantri is directed to accept notice for the respondent. Petitioner to serve copies on the said council. Relist the matter on week after next week. You serve today itself.
Worship.
Yes.
continuation, serial number 40. Jeevan Kumar, PS, Virupaksha, PH, AGA.
Yes.
Annexure B, my lords, page number 24.
Page
24. My lords, why this order, my lords? This petitioner was posted to that place on 5/4/2021. Annexure C by kindly proceed. On 21/11/2021. Petitioner files a complaint to Honorable Chief Minister. Was with regard to the allegations misappropriation of funds during the year 2019-20, 18-19 under various schemes.
petitioner himself, right?
Yes, my lords. No action has been taken till today, my lords, on this complaint.
If my learned friend produces the government order under which CAOD has been constituted to inquire, that would itself would be clear, my lords, under which order the COD was directed to investigate.
What is written down? What is written down?
ACS, Additional Chief Secretary, Social Welfare, Varadi Mandisi.
Yes.
By the Honorable Chief Minister.
Yes.
If my lords are to kindly take Annexure D, my lords, at page number 28. Dr. B.K. Nagarajappa, Pradhana Vyavasthapakara, Karnataka Bovi Sabbari Nigama, so and so. ಸದರಿಯವರು ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೋವಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ಕೇಂದ್ರ ಕಚೇರಿ ನ್ಯೂನತೆಗಳನ್ನು ಅರಿತಿರುವ ಕೆಲವು ಮಧ್ಯವರ್ತಿಗಳು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ನಕಲಿ ಮಂಜೂರಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಹಣ ಬಿಡುಗಡೆ ಮಾಡುವಂತೆ ಗಲಾಟೆ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ 2019-20, 20-21ನೇ ಸಾಲಿನಲ್ಲಿ ನೀಡಿರುವ ಕಾನೂನು ಬಾಹಿರ ಮಂಜೂರಾತಿಗಳನ್ನು ತನಿಖೆ ನಡೆಸಿ ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ಸುಗಮ ಕಾರ್ಯನಿರ್ವಹಣೆ ಮಾಡಲು ರಕ್ಷಣೆಯೊಂದಿಗೆ ಸೂಕ್ತ ಭದ್ರತೆ ಒದಗಿಸುವಂತೆ ಕೋರಿದ್ದಾರೆ. ಈ ಪತ್ರದ ಮೇಲೆ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ACS ಸೋಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಕೂಡಲೇ ವರದಿ ಮಂಡಿಸಿ ಎಂದು ಷರ ದಾಖಲಿಸುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಕೂಡಲೇ ವರದಿ ಮಂಡಿಸುವಂತೆ ತಿಳಿಸಲು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿ ಅವರಿಗೆ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. Till today, my lords, no action has been taken on this company. Because I make an allegation that there is misappropriation which has been signed even by the senior officers. That is the reason why I have been implicated, in which I am not a party to the FIR. May I pass on the government order under which COD has been constituted in the year 2022? May I pass on this government? May I read that government order, my lords, at page number 1? ಮೇಲೆ ಓದಲಾದ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಕಡತದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೋವಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ಅನುಷ್ಠಾನಗೊಳಿಸಿರುವ ಗಂಗಾ ಕಲ್ಯಾಣ ಯೋಜನೆ, ಸಮೃದ್ಧಿ ಯೋಜನೆ, ಭೂ ಒಡೆತನ ಯೋಜನೆ, ಐರಾವತ ಯೋಜನೆ ಹಾಗೂ ನಿಗಮದ ಇತರೆ ಯೋಜನೆಗಳಲ್ಲಿ ಹಣ ದುರುಪಯೋಗವಾಗಿರುವ ಕುರಿತು ದಾಖಲಾಗಿರುವ ಕೆಳಕಂಡ ಪ್ರಕರಣಗಳನ್ನು ಸಮಗ್ರ ತನಿಖೆಗಾಗಿ CIDಗೆ ವಹಿಸುವಂತೆ ಕೋರಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಕೆಳಗಡೆ 4 ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಭೋವಿ ಅಭಿವೃದ್ಧಿ, ದಿಸ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಆನ್ 2/12/2023. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಭೋವಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ಅನುಷ್ಠಾನಗೊಳಿಸಿರುವ ಗಂಗಾ ಕಲ್ಯಾಣ ಯೋಜನೆ, ಸಮೃದ್ಧಿ ಯೋಜನೆ, ಭೂ ಒಡೆತನ ಯೋಜನೆ, ಐರಾವತ ಯೋಜನೆ, ನಿಗಮದ ಇತರೆ ಯೋಜನೆಗಳಲ್ಲಿ ಹಣ ದುರುಪಯೋಗವಾಗಿರುವ ಕುರಿತು ಈ ಕೆಳಕಂಡ ಪ್ರಕರಣವನ್ನು CODಗೆ ವಹಿಸಿ ಆದೇಶಿಸಿದೆ. Kindly see the orders which they seek the consent. They limit themselves. They don't go into 2018-19. And they seek a sanction against the FIRs where even there's no allegations made against me. I have given a statement before the COD. Is it at page number, the next page? ಹೇಳಿಕೆ. Kindly see the next page, my lords. I'm sorry, I could not. ಹೇಳಿಕೆ. I have given a statement, my lords, way back in the year 2023 with regard to all the allegations. And the next government order, my lords. The next is the government order. The next document, my lords. 2018-9.
Yes.
Next proceedings before the government and government order. Kindly see the Vishya. 2018-19 and 19-20 ಸಾಲಿನಲ್ಲಿ ಸರ್ಕಾರದ ವಿವೇಚನಾ ಕೋಟಾದಲ್ಲಿ ಬಾಕಿ ಇರುವ ಕರ್ನಾಟಕ ಭೂಮಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮದ ನಿಗದಿತ ಯೋಜನೆ ಮಾರ್ಗಸೂಚಿ ಅಳವಡಿಸುವ ಬಗ್ಗೆ. Then there is the proceeding sheets. The next page. Government order with regard to all the allegations which I have made. And with regard to Malots, the last document, Malots. May I request last document, the complaint given on 29th August 2024 to Manya Police Maharnideshkar CID Gataka. I'll put the page numbers after the proceeding sheets.
The Secretary is Social Welfare.
Please.
30th September, August
29th August 2024. Last but 4 pages. 29th August 2024.
Yes.
Which I have given a complaint to Director General of COD, giving all the documents to the COD as to allegations made from 2015, 16 and 18, 19. They don't make any investigation against these complaints. After I give a complaint before the COD, they take a sanction against me itself, where against an FIR where I am not a party and there's no allegations against me. In this regard, Malats, morning I submitted, let them file their statement of objections. Bringing all the facts before this honorable court. Malats, 17A, putting in the criminal action in force, there should be some substantial materials.
No, but 17 is only for investigation.
Please, Malats.
And
Let
you
them
have a-
invest, not only this,
You have a
Malats.
protection. You have a protection already.
I am not been given protection, Malats. If
482.
in that I am not a party. That was filed by a accused in those complaints. If those protections have been given in this case, Malats, let them investigate. Not only this, Malats, entire 2018-19 and make officers.
No, we can't now. We can't enlarge the scope.
Plus, it may not be enlarging the scope.
No, I'm
It is all.
It's not for
My
the-
submission would be.
No, correct. It's for them and for you to move the authorities or.
It is only my submission as Malats. They have picked choose the officers which have been involved. They just want to leave the officers who are on the higher ranking and will blame the officers who have not even committed anything, where the instance started based on my own complaint in the year 2021. Immediately on the charge after taking charge. Well, some protection if my laws were to issue. I have been given no protection. That is the reason, my lord, 17A was stayed by the coordinate bench. Not and in the FIRs, if my lords were to kindly take the FIRs, my lords. After I give a complaint to the Director General of COD, giving all the documents, they moved before the government and taken a sanction on 6/6/2024.
That is on 6/6/2024. The representation is 29/8/2024. I don't understand how.
Sir, ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ಆಮೇಲೆ ನೀವು ಹೇಳಿ. ಇಲ್ಲ ನೀವು ಹೇಳ್ಬಿಡಿ ನಾನು ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳ್ತೀನಿ. 2021 complaint is there. The ACS has ordered and COD has been constituted to inquire into all the allegations, not only these allegations which they seek contentions. Against all the grants which have been made from 2018-19, the government order appointing COD is very clear.
18-19
till 2023. They leave the officers who have come posted after my tenure, my lords. They leave the officers who are working before my tenure.
They can't leave anybody. They can't leave anybody.
They can't leave anybody. That is exactly my point, my lord.
No, that will make some observation. Let us.
Yes, sir.
They can't.
And
leave
some
any-
protection, my lords.
Protection is not within my scope. That you will have to work out appropriate remedy.
And my lords, the one more point, my lords, the reasonings. If my lords were to kindly come to the orders passed.
Page?
Page 45, my lords. Is there any reasonings given by the office before granting the sanction? ಅವ್ರು ಕೋರಿದ್ದಾರೆ ಕೊಡ್ತಾರೆ.
Let us see how they substantiate.
In this regard, my lords, I would pass on one judgment.
Could it-
Page number 19, my lords.
One copy.
Or women copy. ಇದು ಬೇರೆ.
Yes.
Para 21, page number 19, my lords. And that is what extracted section 17A.
Yes.
Para 22, my lords, and para 23. I'll read from para 23. In my considered view, section 17A and its purport must be observed with complete strictness, being mind, public interest and protection available to such officers against whom the offences are alleged. Offences are alleged, failing many, which many a time it would result in malicious prosecution. Section 17A is a clear filter that prosecution must pass in order to discourage and avoid vexatious prosecution, though cannot be considered as a protective shield for the guilt, but to safeguard for the innocent. The provision supra has been considered by the apex court in so and so. May I go to page number 26, my lords? Section 17A casts an obligations on application of mind on the part of competent authority in three situations. The section makes it clear that no officer shall conduct any inquiry or investigation without the previous approval. Therefore, approving authority will have to look into the materials, apply its mind in all the three contingencies. That is inquiry, and investigation. Though inquiry are often used to interchangeably, there exists a difference between the two. Etymologically, the source of both inquiry and inquiry could be a same and derived from French and from Latin. Inquiry has a formal and official ring to it. Inquiry is informal and can be unofficial. Inquiry could even be into question. Inquiry is a formal investigation. Investigation is a such. Therefore, Act casts an obligation of application of mind upon the authority to consider whether approval is sought to be for an inquiry or an it becomes imperative for the authority to apply its mind as to what is brought before it, as application of mind is a bedrock of all the orders of any orders that authority passes, failing which it would be contrary to the principles of natural justice, as non-application of mind itself is violative of principles of natural justice. Application of mind by an authority is demonstrably only in order to authority makes in order to demonstrate application of mind by authority. It must contain the reasons, as recording of the reasons is an order is only the way that can construe such application of mind. Reasons are live links between the mind of decision taker to the controversy in question and the decision arrived at. Reasons and application of mind is impregnably for an order to sustain the scrutiny of law, be it administrative or quasi-judicial. Reasons in every circumstances need not be elaborate, but nevertheless should bear an application of mind. The case at the end and the impugned order which will have to be tested on annual of the mandate of the statute, if the intent behind the enactment on the rule of applications. If on a case of all the facts that are narrated herein above, and order that is impugned in the petition is tested on the annual of the objects and reasons of section 17A of the said act, it would fall foul as the same as the order except Kulankushavagi Parishilisi. There is nothing indicative of the facts that it bears an application. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, and it does not even bear any semblance of the application of mind. Therefore, on the ground that order does not bear, would lose its legal stand and as a result would meet its obliteration. If my lords are to kindly see the orders being passed.
No, but go to page 46.
Please.
Third paragraph.
Third paragraph.
There is some report. Last 4 lines. ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣ ಮುಂದಿನ ತನಿಖೆಗಾಗಿ. Last 3 lines of the third paragraph. ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ಡಾಕ್ಟರ್ ಸೋ ಅಂಡ್ ಸೋ ರವರ ಅವಧಿಯಲ್ಲಿ ಆಗಿರುವ ಅವ್ಯವಹಾರ
ಅವಧಿಯಲ್ಲಿ ಬಗ್ಗೆ ಅವ್ಯವಹಾರ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
So what is that?
What is that report says? Malas, there is no application.
Let us see.
That is, there is no app.
Let us. Yes.
Yes.
We'll take it one by one.
Yes. Now, just though your lords.
First, what is the scope of
17
inquiry?
AM, 17. Since my senior friend my lord has read this Sri Rupa's judgment, this honorable court subsequently rendered judgment in connection with Sri Rupa itself may place that judgment. In earlier matter, my lord, matter was remanded back to the authorities. Liberty was granted to authorities to pass an appropriate order. There,
In this matter.
yes. Ma'am. Subsequently, my lord, 17A order
remanded,
was
is it?
passed. Was remanded, my lord, earlier. If I'm correct, it was remanded.
So they're given liberty.
Liberty. Subsequently, order was passed. That also came to be challenged. Now, your lordship may take this judgment, my lord.
All judges of this court only.
Yes, yes, my lord. In fact, 17A is extracted, my lord, at page 3. Your lordship may request your lordship to para 25 at page 5.
Para 25.
25, my lord, they extract the scope of Prevention of Corruption Act by relying on Supreme Court judgment. I will not trouble your lordship by reading that para, my lord. May I request your lordship now come to para 30, my lord.
Yes.
In fact, para 28, my lord, they extracted the parliament again inserted section 17E of the PC Act 1988 with effect on so and so. Provision has continued to remain in statute book. It is also provided sanctions, so on, so, etc. Now, your lordship may come to para 30, my lord. It is therefore not necessary that there should be a clear incriminating evidence with the investigation officer at the stage of him seeking prior approval under section 17A of the Act. All that is required under the provisions of section 17A of the PC Act is that the investigation officer has some credible evidence on the basis of which he forms an opinion. What is required now is opinion, his opinion, that an investigation is warranted. As a consequence, the state government would be required to only consider the opinion that is formed by investigation officer and the material that is that he possesses while considering the request for approval. Since the public servant is yet to be investigated, the question of considering any incriminating material and coming to the conclusion that the investigation is necessary would not really arise in this particular case, since the public servant is yet to be investigated. The question of considering whether there is incriminating material or it is veracity by the state government to come by the state government to come to the conclusion that investigation is warranted or not would be untenable and stands to logic or reasons.
So that means the state government cannot sit on appeal.
No.
On the opinion of the investigation officer. But there must be some opinion formed by the investigating officer that this is a case that requires
investigation. Because, my lord, section language of 17A precludes even inquiry. If I don't do inquiry, if I don't do investigation, how can I produce any material before a competent authority to give an approval? Therefore, my lord, that the whole intention is he has information which discloses that commission of cognizable offense under the PC Act, relevant section of PC Act is committed. And that is my opinion. I'm placing it before you to grant approval. So that is what is required. Then para 32, my lord, it may also be pertinent to state here that the state, same para, para 32.
Just one.
Yes. In fact, para 34, my lord, next page makes it more clear. Page 8, my lord, para 34. Your lordship got it? It is also clear from the wording of section 17A of the Act that state government is not required to exhaustively and meticulously consider all the material available with investigation officer at the time of he seeks approval, and it is only required to examine and consider whether the opinion formed by the investigation officer that an investigation is warranted is justified or not. If the state government is satisfied that the opinion formed by the investigation officer is justified and it is employee is required to be subjected to investigation, the state government can accord its approval. I will also see para 36. At this stage, a stark and starking difference between granting of a sanction to prosecute and according an approval to investigate to an investigation officer would have to be elaborated. The grant of sanction to prosecute and the grant of approval to investigate are two very different concepts and would be governed by completely different parameters. At the stage of seeking sanction to prosecute, the investigation officer would have completed the investigation and would also have collected material which, in his opinion, would prove that the public servant is guilty of an offences alleged against him. In other words, at the stage of seeking sanction to prosecute, the investigation officer is well armed and certain that there is a material which would establish the guilt of the public servants. It is also to be noted that despite this firm opinion of the investigation officer, which is based on the comprehensive investigation, the law still mandates that the state government should accord sanction to prosecute, and only when such sanction is granted can be prosecuted be launched against the public servant. At the stage of granting sanction to prosecute, the respective government is required to examine all the material collected in the course of investigation and then come to conclusion as to whether the material collected indicate if case of for prosecuting the public servant is made out. Now I request my lord para 39. In respect to according an approval to investigate, obviously the situation would be completely different, since at that junction, the investigation officer would not normally have any incriminating material and would only possess credible information about the commission of an offense. And it is this credible information that is required to be considered and analyzed by the government. It is thus clear that the parameters that govern the according of approval to investigate would be completely different, and the government would have a much wider discretion while considering the request for investigation officer. To summarize, the view has conferred a twofold protection vice versa public servant for offences under this act. The first layer protection is even before investigation is conducted, where a prior approval is needed under section 17A of that. A second layer is in protection is after completing the investigation, where sanction to prosecute the public servant is required under section 19 of the act. Now, Lordship, come to para 47, my lord, next page. Then single judgment will extract the famous word, my lord. The integrity of public servant is required to be beyond suspicious, as a proverbial added that Caesar's wife must be above suspicious. If there exists even a shadow of doubt on the integrity of a public servant, it will not only harm a reputation, but would also tarnish the entire system of which he is part. Thus, in such a situation, if the aspirations cast on the integrity of the public servant and an investigation officer under the act harbors a view that an investigation is necessary, it would be in the interest of both the government and public servant that such a nagging suspicion is obliterated. In order to achieve this objective, therefore, the government should be given a greatest degree of latitude to accord approval for conducting investigation. In fact, it says, my lord, the government should be granted an approval. The contention, therefore, that the material furnished by the investigation officer is required to be subjected to microscopic examination before according approval to investigation of a public servant, as suggested by the learned senior counsel appearing for the petitioner, does not merit acceptance. As stated earlier, before seeking approval under section 17A of the act, the investigation officer would only have to form a tentative opinion to determine as to whether an investigation is warranted or not, having regard to the material / credible information in his possession at the point of time. It may so happen that after conducting an investigation officer may very well come to the conclusion that there is no justification for initiating prosecution and may drop such proceedings against public servant. Thus, the mere grant of approval to conduct investigation would not lead to inference that investigation would be necessarily culminated in a prosecution against the public servant. Therefore, my lord, my respectful submission would be that what is required, my lord, has to see whether the investigation officer was in a possession of a material which discloses an investigation under PC Act is required against that servant. And that request has been placed before the competent authority. And competent authority, after examining that report, has accorded sanction. Now, if I place the entire file, my lord, the investigation officer has produced the complaint, produced the FIR, produced his opinion, produced the allegations which the so far, this is, my lord, unlike other cases. In fact, this case, FIR was registered against IPC offenses. It was not registered against them. The people who are supposed to have the beneficiary of the Bowie Corporation, the entire scheme, my lord, if I narrate in 2 lines, my lord, what happens, my lord, the various schemes of the government.
All schemes are made, nothing reaches the beneficiary.
Nothing reaches the beneficiary. In this case, my lord, interestingly, my lord, the same petitioner, my lord, they make the beneficiaries to open an account in one particular bank. He writes to the bank manager and tells them, don't give this checkbook to the person who opens the account. The entire bank passbook, checkbooks are held with them. There is the official letter he writes from sitting as a managing director of the corporation. That letter, based on that letter, my lord, they don't issue any passbook to anybody. They place that letter, my lord, which now these beneficiaries, my lord, do not know.
Let us have a look at what material.
Yes, I'll place the entire file, my lord, but just if I give background of the entire the event, my lord, what is transpired is that the accounts have been opened in beneficiary's name. Account books, passbooks, checkbooks are not given to beneficiaries. They have taken signature. From their account, money has been transferred to third party. And from third party, monies have been transferred to either family members of some of the petitioners or relatives of some of the petitioners.
That material is.
Yes. That's the post investigation which I can place entire material, my lord, which discloses. In fact, my lord, I made a table, my lord, to show how much amount has been transferred back to the petitioner family member.
So now the narrow conspect is the passing of order at annexure H.
Yes.
Those references and whatever material was placed before the government.
Yes.
When they gave that sanction permission.
Yes.
That material that was placed.
May I place that material?
And that office note.
Yes.
I'll have a look.
This is the entire file, my lord, pertaining to this particular petitioner. Entire file movement and all the documents.
This is the file that was put up to the government.
Yes,
for giving up.
Yes,
file put up by the
investigation officer. Of course, it's sent through DG, CID, and then to the appropriate government. And thereafter, they've examined.
It originates from the
investigation officer. Opinion of the investigation officer is also there, my lord. Thereafter, a forwarding letter from the DG, CID, and then goes to the government.
You have the note that is put up.
The file note is also there. The beginning is the file note. They have produced the entire file.
Oh, this is the.
It's a E file, my lord. It's,
File, E
yes,
file.
my lord. Yes.
I'll have a look at it.
Yes. ma'am.
I'll have it on Monday. I'll have a look at it.
Yes.
May I make one submission, my lords? If my lords are to kindly take, my friend said that I have opened an accounts in one single bank. May I make a request, my lords, which memo which I have filed now? Sir, could you? That memo, my lords. That was filed in the morning. Huh? If my lords are to kindly take page number 7, my lords, in that memo.
Now, just 1 minute. Apart from these two, there are no other orders, is it?
No, there are 3 orders, my lord.
No. On the 17A.
Yes, my lord.
Any other orders?
Yes, one more order.
Huh.
That has not been challenged. We're investigating against him with respect to 17E.
Him.
Yes, yes. The 3 people we sought for sanction so far.
Some other person.
Yes, yes. So 3 again, out of 3 people, 2 people have a challenge and got a stay. 3rd person has not approached this court and we are investigating against him with respect to PCI. Of course, IPC offense my lord and coordinate bench now vacated the stay and directed us to investigate and we are investigating.
No, I'm saying on the legal position, any other orders apart from this Sri Rupa, anything else of any bearing?
Subsequently, recent judgment, my lord, of course, that doesn't deal with this particular issue.
On 17A?
No.
It doesn't.
Tamadu on that.
Huh?
Tamadu on that. Yes, Yediyurappa matter. Those orders, my lord, is dealt with the issue of
19.
No, 17. Your lordship order on 17 EMLs. Abraham versus Yediyurappa, where
We have dealt with 17A.
17 EM. There your lordship has held the private complaint. Whether private complaint has to be accompanied by 17 years approval.
That's at what stage?
Yes, madam. But that is not, that doesn't deal directly with this issue. And of course, my lord, recent judgment of Justice Nagaprasanna, that also doesn't deal with this issue.
And that is a private complaint.
That's also on a private complaint.
On a private. If my lords have to kindly take page number 7, my lords, which page number 7 in that memo, which my learned friend said that I have opened an account. I have given a letter, which is the government. This is a government order, my lords, in 2020.
Yes.
2021, page number 5, my lords. Page number.
Yes.
This is a government order passed in the year 2021, 22 to 2021, page number 6. In page number 7, if my lords are to kindly come to clause number 7.
Page number 7.
Page number 7, clause number 7. May I read that, my lords?
That is on page number 6. Okay.
6, a government order is dated 22 to 2021. I went to that post in 5/4/2021.
Para 7.
Para 7 in page number 7.
Yes.
Next page.
No, there is some page difference. Para 7 is in page 6.
May I read that, my lords?
Internal page.
Yes.
Internal page 3, my lords, of that government order.
Okay, you read that. Vyavasthapaka Nirdeshakaru.
ಫಲಾಪೇಕ್ಷಿತರು ಹಿಂದೆ ಹೊಂದಿದ ಬ್ಯಾಂಕ್ ಖಾತೆ ಹಣವನ್ನು
Just one.
ಅದು
ಬೆಳಗ್ಗೆ ನೋಡ್ತಾ ಇದ್ದೀವಿ.
ಬೆಳಗ್ಗೆದ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ, ಇವಾಗ ಒಂದು ಕೊಟ್ಟು
ಈಗ ಕೊಟ್ಟಿದ್ದು.
page number
7. That is a government order dated 22/2/2021. My lords could kindly get it at page. Podi.
We only say don't spare anybody. Don't spare
No, we
anybody.
will not spare anybody. This is the preliminary stage, my lord. We don't know where it leads to.
No, correct. I'm saying don't spare anybody.
And 17A, my lord.
That is what
Only
asked-
whenever we get the information, only then we can go and seek an approval. Unfortunately, we can't take a blanket approval and then start investigating.
That is there, but we are saying don't spare anybody. The faith of the system depends on how uniformly you apply.
No, I can assure my lord, on behalf of the investigation agency, my lord, that we will not spare anybody, my lord. In
Page
fact, my lord, if in his own complaint, if I interrupt my lord, he himself says that Nagaranagal nedide anta. For his own benefit, let that matter be investigated. In fact, we
Not only against me, that is what exactly.
Everybody.
Ade page open madidini. That is a government order.
Yes.
Plus that is next page, government order dated 22/2/2021.
Yes.
Atali next page, clause number 7 minutes.
Yes.
This government order was passed even before I come into picture, my lords. That the Vyavasthapaka Nirdesh ಅವರೇ account open ಮಾಡಬೇಕು. Based on this government order, I have given letters to open an account. I was posted to that place on 5/4/2021. They are mainly relying on a letter given by me to open an account in one bank. This is the government order which was passed in February 2021.
So let us see.
I am not saying that let there not be investigation. Let them be fair investigation against all the officers who have been involved. From 2018 till 2023, they pick and choose only 3 officers.
Yeah, that's only starting point.
That is the start. That is not the starting point. Starting point was much before I took charge. The reason why they have been it has been signed by the highest officer of the state, highest government officer. That is the reason why they have dropped them. Every movement of the file has been signed by him.
2018 to
2023. Every moment has been signed. Malats, I am not a drawing officer. Drawing officer is some person, some other person. If this 2024 complaint is to be read, kindly see the complaint which they have filed in 2024. Even though I give a complaint in 2021. That is the reason why I am submitting before this court that there is no fair investigation being going on.
Only at the stage of investigation beginning. So let us see. You suppose it's a now even if after investigation, if they have to prosecute you, there has to be sanction for prosecution.
Clearly, my lords.
So
but the issue is, my lords,
we are at the very first stage.
If based on my complaint, my lords, no sanction is accorded to officers who are serving in that organization even before my posting, nor after my posting.
No,
I would put this question to myself.
They have to do it. They can't leave it.
They have left, my lord, specifically if the sanction is given against all the officers who have been serving from 2018 to 2023. My lords, I would have no legs to stand before this honorable court.
No, they have to do it.
They have not done. They have only picked and choose only 3 officers of the state.
That will let him. They will undertake to do against
We
all.
will undertake, my lord. We will give assurance, my lord, to this honorable court.
Between the entirety of the period of 18.
Let them file an undertaking that in entirety of the period. That is the reason why COD was constituted.
No, they will do it. They have to do it.
If the order of government order is seen why the COD has been constituted to inquire into all the allegations based on my complaint, my own complaint. And since I went and gave a complaint, I have been made a scapegoat to these proceedings.
In fact, the lordship asked me the 17 any other judgment, one more judgment. page 10, my lord, para 14. Para 15 also.
Let us see. I'll
May I
have
pass
it
on one more judgment?
Yes, put it. Paragraph.
Last paragraph, my lords, where no application of mind is. Paragraph 17, 17 and 18.
But this is sanction for prosecution.
So 17.
Paragraph 15, 17
The 17.
17.
17 and 19 both have been discussed. Para 13, my lords. Para 13, section 17A is also discussed.
Read para 13.
Section 17A casts an obligations on application of mind on the part of competent authority in three situations, the same judgment, same word. The section makes it clear that no officer shall conduct any inquiry without therefore approving authority will have to look into materials, apply its mind in all the three contingencies, inquiry, investigation to inquiry.
Repetition of the same.
Same, my lord.
Huh?
Same.
Okay, so we'll have it on Monday.
The other matter, my lord, that I have the different file for other matter. I place that. Connect.
We take it up one by one.
Yes.
And then see, because now
Both
the-
are with regard to same allegations, same FIRs.
Arising out
Both
of the
the
same
petition-
crime number.
Same crime numbers.
Huh?
Arising out of same crime number, just as the sanctioning authority are two different authorities.
So
They are,
what-
they are co-accused in the same crime.
But you have a different file.
Because sanctioning authority is different. Therefore, the files are different.
So what is the difference now?
In fact, there, my lord, I have, they've collected the entire investigation materials and then accorded sanction. This is the entire file of
The second matter.
second. Entire investigation paper was summoned before according sanction and then
Okay, take us to the second matter. Let us have a look.
The interim orders could be extended till.
Yes, yes. Interim order, earlier grant is extended till the next date.
Monday at 2:30, man.
Huh?
2:30 Monday.
This one. Tuesday. We'll have it on Tuesday.
Tuesday at 2:30, my lords.
List at 2:30 on Tuesday. First list will be arbitration. After that, I'll take.
Second matter, my lord, place that in the
Interim orders in operation.
office file, my lord.
It till the next day. But you take me through it.
I'll
and then
take.
you-
Yes.
Then you can do it.
Yes.
41, Satish.
You can make a list of dates if you want, both of you. You can, depending on the availability, you can make a.
Well, if my lord's permit, I'll take back those papers which I have filed now. I'll file it along with one single memo with details, page numbers.
Yes, yes, interim orders in operation extended till the next one.
But here for the petitioner. But matter pertaining to my lord, the extension of UGC pay scale. Lord, the state government has issued an executive order on 4/5/1994, extending the UGC pay scale to the teachers who are working in my lord, educational institutions such as my lord, vide degree. Lord, the petitioner has obtained MPhil.
No, now, have you taken your, complete your readings, your file?
But the
Lord,
matter
the
is
list of
covered by,
judgment.
it is covered by the judgment rendered by my lord, coordinate bench. Lord, I have produced the list of citation on 25/9/2024. But short point is, my lord, whether teacher who possesses MPhil is entitled for exemption of net slet, and whether I am entitled for UGC pay scale is considered by the my lord coordinate bench of this honorable court. It says that, my lord,
Just one minute. Now, what is your prayer now?
prayer is, my lord, the impugned order dated 8/7/2024, which withdraws the UGC pay scale given to the petitioner in the year 2015. After 9 years, my lord, UGC pay scale is withdrawn.
It was first given to you when?
Lord, it was extended to me on 7/11/2015. Lord,
7/11/2015
15.
and withdrawn on
8/7/2024 on the ground that, Lord, I do not possess PhD, net or slet. Not for the first time, not only 2 dates may be relevant. 5/3/2010, the institution where petitioner is working is admitted to grant in aid. I was appointed as lecturer on 8/2/1999, and institution was admitted to grant in aid on 5/3/2010.
8/2/1999.
Grant in aid, my lord, is on 5/3/2010. But I have completed MPhil. But whole the case lies with this date. 2006 May admitted, completed on 14/5/2009.
You started it when?
May 2006. May 2009, I have completed the MPhil degree is awarded.
May 2019.
9, my lord.
9.
14/5/2009. If I have got MPhil before, my lord, September 2009, but I am entitled for exemption and UGC pay scale. Consequently, my lord, I am entitled for such benefit.
Why do you say before September 2009?
But that is the date on which, my lord, the policy is changed. And my lord, this honorable court has considered the issue with regard to, my lord, extension of UGC pay scale.
Squarely covered.
Squarely covered.
Roundly also. Page.
List of citation which is filed on 25/9/2024.
Yes.
My lord, in that, my lord, it is only a coincident where, my lord, the page 28, my lord.
Yes.
Lord, the one Mr. R.S. Raju and another approaches this honorable court seeking for a direction to the state government to extend the pay scale. Lord, kindly come to page 30 at para 3. Lord, the case of the petitioner was given as a, my lord, example for extending the benefit of UGC pay scale. Lord, may I read, my lord, last 3 lines. The petitioners have also stated in the writ petition that similar relief was extended to one MS Veena, that is, my lord, present petitioner. Petitioner's name in this writ petition is, my lord, MS Veena. MS Veena, lecturer working in Sarvagna College of Education, Vijayanagara, as she has acquired MPhil qualification as per order dated 7/11/2015. Lord, the issue with regard to this is discussed, my lord, at para 7 at page 33.
Now, this order has not, has attained finality.
Yes, ma'am. This has become final. No, my lord, as an officer of the court, my lord, I should bring it to your lordship's notice that, my lord, since this writ petition is allowed, relying upon the benefit which is extended to the petitioner herein, but the the impugned order says, Honorable High Court has allowed the writ petition in respect of similar situation, citing as a ground as MS Veena. I am passing the order to withdraw the benefit which is extended to the petitioner is the impugned order.
No reasons are assigned.
Please, my lord.
No reasons are assigned.
No reasons are. But they, virtually, my lord, I would say, they, my lord, in a way, turned down the order of this court, my lord. Had they not cited, my lord, my case in, my lord, R.S. Raju, they would not have passed this order.
No, but the cutoff date, what is the significance of the 2009?
2009, my lord. That is the introduction of the page 33, my lord, para 7. In the light of the submissions made by the learned counsel appearing for the parties, it is not dispute that the petitioners are working as lecturer in 4th Respondent College. On careful examination of the writ papers, it would indicate that petitioners have passed MPhil during 2009. In this regard, it has to be considered as to whether candidates having MPhil degree is exempted from net, and the relevant regulation in this regard is as under. But they quote, then, my lord, the candidate having MPhil degree in the concerned subject are exempted from net for UG level teaching, page 34. Then, my lord, the judgment in, my lord, University of Kerala versus Merlin is considered, and my lord, para 9, page 38. Having taken note of the regulation 2009 referred to above, and on perusal of writ papers, it is clear that proposals made by the 3rd respondent to the 1st respondent herein, as per letter dated so and so.
Proposal is to be made by whom?
By the institution. Institution has made the proposal, not based on the recommendation of institution. UGC pay scale was extended to me.
This one.
Please.
The 3rd respondent is joint director.
Yes.
Of collegiate education.
Of collegiate education.
Proposal emanates.
Should emanate from, my lord, the joint director.
And decision is to be taken by the government.
Government. The said aspect is also reflected in the letter dated so and so. Having taken note of the fact that similar exemption and approval has already been given to some of the lecturers, particularly referring to the government order dated 7/11/2015. That is, my lord, my pay scale. I am of the view that reason assigned by the respondent authorities in letter dated so and so is not just and proper, and the said communication is liable to be quashed. Accordingly, petitioners are entitled for similar benefits which have been extended to the other lecturers as per the government order dated 7/11/2015. A writ petition is allowed. Petitioners are entitled for UGC benefit in terms of regulation 2009 and other consequential benefit compliance within. So, my lord, before that, the division bench has also taken similar view. May I request my lords to kindly come to page 18. May I read page 20, my lord. If the candidate possesses MPhil degree exempted from net SLET, this is the question, my lord, involved, which is answered, not at para 8, page 24. But what is the significance of this date is not discussed. Admittedly, may I read, my lord? After the process of selection to the post of lecturer was initiated, the regulations framed by the University Grants Commission were amended with effect from 11/7/2009. The learned single judge of this court in paragraph so and so has held that the regulations are prospective in nature. The relevant extract of the order reads as under. For yet another reason, regulations have to be prospective in nature, as the University Grants Commission in its meeting held on so and so held as follows. Then, my lord, page 12. Thus, according to Universities Grants Commission itself, amendment in regulations have been held to be prospective in nature, and the appellant has already been held to be eligible being appointed to the post of lecturer in question. The appellant cannot be deprived of benefit of University Grants Commission pay scale by linking the qualification which is prospective in nature with the pay scale. However, the aforesaid aspect of the matter has not been appreciated by the.
What is the, does it say that you should have done PhD?
Yes, my lord.
Prospective.
Yes, lord. The regulation says, yep, my lords are right. For extension of UGC pay scale, lord, UGC has made it mandatory
to have PhD.
PhD, yes.
But that is prospective.
That is prospective, which is considered by the, my lord, the Honorable Apex Court in the case of University of Kerala and others versus Merlin, which is at page 1.
So in case of
persons who are appointed after one should have, my lord, the very same question is considered by the Honorable Apex Court and says that, lord, if this is operated retrospectively, those persons who are already appointed would be sent home. Lord, page 1. University of Kerala and others versus Merlin JN, which is at not para 14. That is, my lord, 11/7/2009. Para 9, page 14. Analysis and findings antide. Page 9, my lord. I'm sorry, page 9.
Yes.
This meant that large group of PhD holders, such as so and so, who had been awarded their doctoral degrees prior to 11/7/2009, that is cutoff date under 2009 UGCR, suddenly became disentitled to claim exemption and were per force made to appear and qualify in the net. UGC become aware of this situation and by 2 resolutions dated so and so find that since the regulations are prospective in nature, all candidates having MPhil degree on or before, kindly note the date, 10/7/2009, and all persons who obtained PhD degree on or before 31/12/2009 and had registered themselves for PhD before this date, but would be awarded such degree subsequently shall remain exempted from the requirement of NET for the purpose of appointment as lecturer, assistant professor. Then, my lord, para 17, exemption is considered.
So by virtue of the UGC.
But
regulation-
UGC passed a resolution, my lord, this had cascading effect throughout the, my lord, country, where, my lord, the professors, assistant professors working in different colleges, my lord, were sought to be terminated on that ground. That, my lord, net select PhD you don't possess. On that ground, my lord, pay scales were withdrawn. That is considered, my lord, page 10 at para 15. The Honorable Apex Court in the case of, my lord, Susila, this court in P. Susila ruled that since the central government was the final authority under UGC Act, it had the final say with regard to how 2009-10 UGCR were going to operate. It was held that regulations had to be construed in such a manner that only those acquiring their PhD degree on or after 11/7/2009 in terms of 2009 PhD regulations were entitled to the exemption. And, my lord, ultimately, page 20, para 26.
Yes.
The logic pervading all the versions of UGCR from so and so to exempt MPhil PhD holders from qualifying in NET was perhaps premised on the understanding that such a doctorate in one's chosen subject involving years of study would render a greater understanding of the subject compared to most other candidates taking NET who have only obtained master's degree. Such qualification, MPhil or PhD, is undoubtedly awarded for a proven proficiency of the candidate in the subject or discipline concerned. This is apparent from the minimum qualification requirements of the different position as well. Example, while this one. So that is the, my lord, reason for giving exemption or for MPhil holder.
Yes, what do you say?
Then, my lord, there is another judgment, my lord, of the coordinate bench, which is in a similar terms, my lord. I will not read. Your lordship may kindly come to the impugned order now. In the background of these facts, my lord, page 54 is the impugned order. Lord, page 55 nalli on top, my lord. That is, my lord, the petitioner's case is considered. Sadri ಅವರು M.Ed ವಿದ್ಯಾರ್ಥಿಯೊಂದಿಗೆ MPhil ಪದವಿಯನ್ನ ಮೇ 2009 kindly note,
You're reading?
page 55.
Yes.
Top ಅಲ್ಲಿ. ಸದರಿ ಅವರು M.Ed ವಿದ್ಯಾರ್ಥಿಯೊಂದಿಗೆ MPhil ಪದವಿಯನ್ನ ಮೇ 2009 ಮಧುರೈ ಕಾಮರಾಜ್ ವಿಶ್ವವಿದ್ಯಾಲಯದಿಂದ ಪಡೆದಿದ್ದರು. ಶ್ರೀಮತಿ MS ವೀಣಾ ಇವರನ್ನ ವೇತನ ಅನುದಾನದ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡಿಸಲಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ DSRT ಇಲಾಖೆ ಸದರಿ ವೇತನವನ್ನ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. Lord, maybe, my lord, I have acquired degree during May 2009. I am entitled for exemption provided if it is before 11/7/2009. Probably, my lord, if I had acquired MPhil after that, I am not entitled for exemption. That is discussed, my lord, at page 56. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 4ರಲ್ಲಿ ಶ್ರೀಮತಿ ವೀಣಾ MS ರವರು MA ಕನ್ನಡ, M.Ed ಮತ್ತು MPhil ಪದವಿಯನ್ನ ಏಪ್ರಿಲ್ 2007 ಪೂರ್ವದಲ್ಲಿ ತೆಗೆದುಕೊಂಡಿದ್ದು 14/5/2009 ಎಂಫಿಲ್ ಪದವಿಯ ಫಲಿತಾಂಶ ಪ್ರಕಟಿಸಿರುವುದನ್ನು ಪರಿಗಣಿಸಿ ಇವರನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯು 18/8/2/99 ನೇಮಕಾತಿಯನ್ನ ಮಾಡಿಕೊಂಡಿರುವುದನ್ನು ಪರಿಗಣಿಸಿ 15/19/5/2009 ಕಾಲೇಜು ಮತ್ತು ಹುದ್ದೆಗಳನ್ನ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿ 5/3/2010 ಸದರಿ ಸಂಸ್ಥೆಯ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ನೌಕರನ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿರುತ್ತದೆ. ಹಾಗೂ ಸದರಿ ನೌಕರರು NCTE UGC ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿಯನ್ನ ಹೊಂದಿರುವುದರಿಂದ UGC ವೇತನ ಶ್ರೇಣಿ ವಿಸ್ತರಿಸುವಂತೆ ಕೋರಿ ನಿರ್ದೇಶಕರು ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಇವರು ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 5ರಲ್ಲಿ ಸರ್ವಜ್ಞ ಶಿಕ್ಷಣ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ಉಪನ್ಯಾಸಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀಮತಿ MS ವೀಣಾ ಇವರಿಗೆ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯಿಂದ UGC
We'll continue on Monday.
since it is covered, my lord, your lordship may
We'll have it in the orders list. What do you?
Only the short point which was canvassed by the learned council is only the MPhil. Whether that MPhil is a sufficient qualification to get UGC pay scale or not. That's the only point, my lord, that I'll clarify, my lord.
That has been extended earlier.
Please.
And now it was sought to be
It's withdrawn.
So if the UGC 2009 regulations are prospective and does not affect those who are already teaching with MPhil for assistant professor.
That's only in respect of UG, undergraduate courses, not in the postgraduate.
So he's teaching, he's an assistant professor.
Yes.
But then it will not affect those who have already been appointed and acquired.
I'll take instructions on this, my lord, with the
But the
Monday.
reason for withdrawal is Raju's writ petition is allowed. In that, the benefit of UGC is placed in respect of this petitioner. Therefore, we are passing this order withdrawing.
Let's hope they don't take away Raju.
my lord, have it on Tuesday.
Relist the matter. You make one small synopsis.
I'll
And that those that the regulation of UGC comes into effect from 11/9. 7/9.
11/7.
11/7. 11/7/2009.
Yes, my lord.
And accordingly, it does not affect those who have already been appointed, nor their pay scales. That is your view. Relist the matter on Tuesday in the on top of the B group list.
ಆಗ್ಬೋದು ಮಂಗಳವಾರ ಇನ್ನೊಂದು 17 ಏನೋ ಹಾಕಿದಿರ ಅನ್ಸುತ್ತೆ.
That is in the afternoon.
Let us see, that will be in the afternoon.
Yes,
morning. Top of the B group list.
Yes.
We just make one.
In short synopsis, I'll be.
And then read that, we'll just go through that impugned order.
Please.
One submission, my lords.
Interim order which is subsisting may be extended.
Interim order. Is extended till the next day.
My lords, one submission I want to make.
Yes.
Item 54, my lords, it is repeatedly listed for hearing. And last, it was heard also sometimes, but they did not complete on that day. 2014 matter, my lords.
Yes. Let us see, I'll relist it, and on the next day, I'll try to take it up.
Yes, my lords, 23rd October, your lordship kindly listed, my lords.
My lord, serial number 47.
23rd.
23rd October, if it is listed,
Yes.
at 2:30, that may be completed, my lords.
No, 2:30, I have an arbitration list every day at 2:30. Let us see, I'll have it on 23rd. We'll see to accommodate.
Please, my lords, please.
My lord, serial number 47.
Dates you can.
My lord,
take
serial
from-
number
There is an
49,
urgency in 47. my lord.
Dates you can take from the court officer. Interim orders in operation will stand extended till the next date. Dates you can request
My
the
lord,
court officer, he'll give it According to your.
Small submission, my lord.
Yes.
In serial number 47, my lord. So I was appointed as a human resource officer. So based on an unknown person complaint, I was relieved without any proper inquiry, my lord. Even Shoka's notice was issued. I have replied to the Shoka's notice, my lord. So even after that, I have been relieved. So there is an urgency, my lord. Please kindly have it on Monday in a preliminary hearing, my lord.
Serial number?
Serial number 47, my lord. No interim order was given, so hence kindly have it on Monday in the preliminary hearing, ma'am.
We will have it in the orders list and we'll consider your request.
Sure, my lord. Monday, ma'am.
47.
Sure, ma'am. Order.
The answering respondent.
My lord,
Government.
it is state, madam.
State.
State, the managing director.
State, you just look into it. 47. It's the matter in the orders list 47. Orders list on.
Monday, ma'am.
Serial number 49, my lord. Serial number 49, interim order may kindly be extended, my lord.
Interim
Serial
orders
number
will stand
40
extended in
49.
all matters which have not reached.
But kindly, my lord, serial number 52.
Just wait, please wait.
Please.
Judiciary, wherein there is a proposal for promotion. In the way of the proceedings, in view of the fact that as per the first National Judicial Commission, there was a requirement for restructuring of the stenographer's course from just stenographer to stenographer grade 1, grade 2, grade 3. That has not been done from 2009. Now there is a proposal for promotion of the stenographer without restructuring as per the directions of the Honorable Supreme Court.
The matter in the orders list.
Serial number 50, my lords. My lords, if it is serial number 50, what has been mentioned, I have to file my objections to it, my lords. I require at least 10 days time, my lords.
But now they're seeking for an interim order stating that promotion will be given before that.
No, my lords, no, my lords, nothing like that. Right now, we are only collecting consent from everybody, my lords. That's all. It's still in the very preliminary stage. There is no interim order necessary as of now. Next week, my lords, anytime next week, I will file my objections by then. It could be heard, my lords.
List the matter in the orders list on
25th, my lords.
25th. We'll consider.
Yes, please.
Kindly, my lords, serial number 52. Lords, the notice was lords issued on the respondents to ascertain lords about the recruitment rules. Where not the survey, my lord, the grant, on Tuesday, my lords, for the consideration of interim prayer, my lords, order is passed, my lords, without even affording an opportunity of my lords issuing notice.
Is the matter in the orders list for consideration of interim prayer on
Tuesday, my lords.
No, let the court officer read just 22nd. All matters in which interim order may not have been granted and notice is issued, you can make a request. We'll post it in the orders list.
Please.